right, welcome back to the 2022 Contest of Candidacy hearings for the Oklahoma State Election Board. At this time, I would entertain a motion to reconvene.
I'll make a motion to reconvene.
Motion from Mr. Montgomery, second from Dr. Malden. Please call the roll, clerk.
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
The meeting has now reconvened, and at this time we will go to our next order of business, which is cause number 2022-06, Allen v. Young. This is regarding District Judge, District 7, Office number 2. Let's see, Mr. Hendrickson, are you ready?
Yes, sir.
You may begin presenting your case, sir. And will you please state your name again for the court reporter?
Yes. Are we going to do opening arguments, or are we proceeding?
I'm sorry. Let's do a 2-minute overview as your opening statement. Just lay out the case that you plan to make.
Sure. My name is Jeffrey Calvin Hendrickson. Do you need me to spell it, or should I? Is that good enough?
She's got it.
Okay. Ladies and gentlemen of the board, as I've said, my name is Jeffrey Hendrickson. I have the honor of representing Petitioner Judge Caitlin Allen in this election contest. Briefly, this petition is concerned with the application of a statute 20 OS 92.8A. This statute applies only to Oklahoma County, which is district number 7 in the state judicial district system. And what it does is it apportions various seats in Oklahoma County to specific electoral divisions. It is a residency case. Some of the seats in Oklahoma County are not tied to electoral divisions. They are, the candidates can live anywhere in Oklahoma County, but some of them are tied to electoral divisions, and this is one of those seats. This is office number 2, which the petitioner currently occupies. According to 20 OS 92.8A, office number 2, candidates for office number 2 must be, at the time they become a candidate, a legal resident of electoral division number 3. This petition is because the contestee, Mr. Brian Young, we believe the evidence will show, is not at the time of becoming a candidate a legal resident of electoral division number 3, and therefore is not qualified to become a candidate for office number 2 of district number 7. I know that was a lot of numbers, but hopefully you can follow me through that train there. We believe, well, I should say first, the term legal resident is defined as a domicile at which a person intends to reside without the intention of returning to a previous domicile. That comes from Supreme Court case Moore v. Hayes. It's also important to note that one can only have one domicile, or one can only be a legal resident of one location. We believe that the evidence will show that at the time that contestee became a candidate, he was a legal resident of a location that was outside electoral division number 3. In particular, we believe the written evidence that's going to be submitted is going to show that the contestee owned a home outside electoral division number 3, and that only up to a couple days before filing his declaration of candidacy, that he was a registered voter at this home outside electoral division number 3. And indeed, the Oklahoma Bar Association in its membership rules thought that the contestee resided at this home outside electoral division number 3. We intend to call contestee as a witness, and we believe the testimony elicited from contestee will add to the claim that contestee is in fact a resident of a home outside of electoral division number 3. For those reasons, we believe petitioner can establish that contestee was not a resident of the proper electoral division to be a candidate for office number 2, and therefore will request that the board strike contestee's candidacy from the record. Thank you.
Thank you, Mr. Henderson. Mr. Haynes, you are recognized for your opening statement. A couple of minutes, and just outline your case, please.
As counsel for the petitioner stated, this is a residency case. This is not a case that involves whether 6 months residency was met, whether Mr. Young lived within the county. It's solely a matter of, was he a resident of Division 3 of District 7, which is Office 2, at the time he filed his declaration for candidacy. I believe the evidence will show he certainly was, and it will be insufficient to show that he was not. As this board is well aware, residence domicile is within the intent of the individual. It's a subjective intent, and it's within his mind. The evidence will show that he moved into a house that has been in his family for over 40 years. He did that before filing his declaration of candidacy. he changed his registration before filing his declaration of candidacy, and that he doesn't intend to go back to his old residence. All of that establishes residency within the appropriate division of District 7, and at the termination of this hearing, we'll ask the court to, board, to deny the petition.
Before we start, I just had a point of clarification that I'd like to ask both counsel for both parties about. Are you both in agreement that the issue of the six-month residency requirement within the county is not at stake here?
We believe that the statute at issue is 92.8A. The 92I statute regarding the 6-month requirement, we believe could also apply here. The spirit of that statute is clearly to establish that the candidate has familiarity with their voters. Though it is listed as a county by county type statute, we believe that the spirit and the intent of the statute would equally apply to Oklahoma County's electoral divisions. And so we're not saying that that statute is off the table in terms of application. However,
are you saying it should apply to the electoral division?
we were saying that the spirit of the intent of that statute should apply to the electoral division, yes.
Okay. And what is your position, sir, just so we understand it?
That is clearly a separate statute. There are, as I see it, 3 requirements. Be a registered voter within the county for 6 months, live within the county for 6 months, and then lastly, be a resident within the appropriate division at the time the declaration of candidacy is filed. I'll note when I reviewed the petition for contest of candidacy, it does not appear to bring up the 6-month requirement, which under...
Right, I mean, it was mainly about the electoral division and whether that 6-month requirement applies to the electoral division or not, and that's, I think, something we will probably want to get into. So with that, Mr. Henderson, you're recognized to begin your case.
Prior to doing so, counsel for contestee and I discussed in advance stipulating to the admissibility of a set of exhibits that were attached to the petition, as well as exhibits that were attached to the answer. I have those here in 3 binders.
Okay. One to counsel. And you'll pass this down to the next table. And so you do stipulate to the...
With the exception of one exhibit being petitioner's exhibit number 9, as to that we would object regarding relevancy, which is a printout for the Oklahoma voter portal, which I believe shows outdated information as it pertains to contestee Young.
Counsel, are these exactly as they appeared attached to the petition?
Yes.
Yeah, that makes sense.
So what is your position toward the objection?
Certainly, and I did not intend to misspeak earlier. My understanding was the stipulation was to admissibility, and objections to relevancy would be held over and made at the time the exhibit was used. So I didn't mean to mislead or indicate otherwise in that regard. However, with regards to the relevancy of exhibit number 9 is voter registration information for the contestee that was obtained several days prior to the contestee's filing of his declaration of candidacy. It is clearly contestee's position that he changed his voter registration in advance of the filing of the declaration of candidacy deadline. However, that being said, the relevance of that information is that this contestee does not intend to stay at the home that he is listed at his filing residence, as evidenced by the fact that it was only 2 days prior to filing the declaration that he changed his voter registration. So that is why we deem it relevant for purposes, of consideration here.
I'm going to overrule the objection on advice of counsel, and we will admit the entire packet. So you may proceed, sir.
And then just for housekeeping point, so we will number each of these as exhibits corresponding with the list on the front page. Is that accurate?
Yes.
Okay.
I will begin by offering a short discussion of the legal background of what we're working with here. As noted in the opening, to qualify as a candidate for office number 2 of district number 7, A person must be nominated and elected from, as well as be a, quote, legal resident of electoral division number 3. That determination is made at the time that the individual becomes a candidate. According to 20 OS, let's see, 20 OS 5, I think it's 101, the time an individual becomes a candidate is when they file their declaration of candidacy. So in other words, the question before the board is, was Contesty a legal resident of electoral division number 3 at the time he filed his declaration of candidacy? Now, legal resident is a term of art, means it has a legal definition to it. In this case, it is defined as the domicile at which a person intends to reside, and this is key, without the intention of returning to a previous domicile. There are various factors that apply to legal residents and are used to assess whether somebody is in fact a legal resident of a certain location. Those are a variety of sets of things, and they don't all have to apply in one certain case. The whole idea is identifying a pattern, identifying conduct that suggests whether a person intends to reside at a location and never return to the previous location at which they lived. Those can be things like the person's present place of abode, the holding of local office, the exercise of the right to vote, the situs of personal or real property, somebody's driver's license, where their automobile is registered, the payment of taxes. And those suggestions come from a case called Shuglove v. Oklahoma Tax Commission, 1979 OK 168. They also come from a broader definition of domicile as used by the 10th Circuit in Middleton v. Stevenson, which is 749 F. 3rd 1197. The whole point of assessing these factors is to identify whether somebody is in fact a legal resident of a piece of property. And it is beyond simply what that individual says they are a legal resident of. For example, were I to tell you that I reside at the Jim Thorpe building and I have no intention of ever leaving the Jim Thorpe building and returning to my home, that does not make me a legal resident of the Jim Thorpe building. What we would need to assess is this variety of factors to see if in fact I do live here. And so it's important to note that even if the contestee tells you that he intends to reside at this home and never go back to the previous domicile that he lived at, that is not determinative of the outcome in this case. The factual background, as indicated in the exhibits that were submitted, is that the contestee filed a declaration of candidacy which listed his residence as 1426 Southeast 20th Street, Oklahoma City, Oklahoma 73129. That document also lists contestee's voter registration at the same address. Contestee also filed a statement of organization candidate committee with the Oklahoma Ethics Commission on March 4th, where he listed that address, 1426 Southeast 20th Street, as his filing address. That address is within electoral division number 3, and if indeed contestee is a legal resident thereof, he would be qualified for this election. However, he was not. At the time that contestee became a candidate for office number 2, division number 7, or district 7, excuse me, he was a legal resident of a home that he owned at 8304 South Country Club Drive, Oklahoma City, Oklahoma 73159. So with that, we would like to call Mr. Young as our sole witness for this case.
Very well. Mr. Young, if you will
Yes, sir.
go to the witness stand and please state your full name again for the record.
Brian Patrick Young.
And will you please raise your right hand?
Yes, sir.
Under penalty of perjury, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You're sworn in. You're with us.
Mr. Young, my name is Jeffrey Hendrickson. I represent Petitioner Caitlin Allen. Thanks for being here.
Thank you.
Are you married?
Yes, I am.
When did you get married?
3 years ago.
So that would be 2019, roughly?
Yes, that's correct.
Okay. Did you live by yourself before you got married?
No, I did not.
Okay. Who did you live with?
With my wife.
Okay. How long did you all live together before you got married?
2 years, I think, on and off.
And does she live with you now?
No, she does not.
Okay. Do you have any kids?
No, we do not.
Okay. Do you have any animals?
We have 2 dogs.
Where do the dogs reside?
The dogs reside at 8304 South Country Club Drive.
Okay. Where did you live prior to 2016?
2016, I lived at, I believe that's when I moved into Country Club Drive. Before that, I lived at 1809 Mansfield in Del City.
How long did you live at 1809 Mansfield in Del City?
I think for 2 years, and then before that, I lived in an apartment in Midwest City.
And so in 2016, June, I think, did you purchase a home at 8304 South Country Club Drive?
Yes, I did.
Okay. When did you move into that home?
Sometime after June, in July or August.
Did you move all your furniture out of 1809 Mansfield and move it into 8304 South Country Club?
No, we did. Moving was a gradual process.
Okay. So what did you do with the furniture you didn't take out of 1809?
Well, 1809 is owned by my parents, and so it remained in 1809 until I don't know what they did with it.
Fair enough. So did you buy additional furniture for 8304 South Country Club?
Yes.
Okay. Did you set up the utilities at 8304 South Country Club in your name?
Yes.
Counsel, can you just slow down a tad
Yeah.
for the court reporter?
Sorry.
No, it's okay. I understand. I understand.
So, after moving into 8304 South Country Club Drive, did you ever return to 1809 Mansfield?
Yes, I've been back several times.
Okay. And did you return to stay there for periods of time?
During the move, we would stay moving furniture and things like that. It took us a month or two to get everything moved in, and I think we may have stayed there for some amount of time. I don't remember.
Okay. Since moving into 8304 South Country Club Drive there, you wouldn't consider 1809 your residence any longer, is that true?
That's correct.
Okay. So, let's talk about 8304. You own this home, true?
That's correct.
Okay. And you're saying you're not living there anymore, correct?
That's correct.
When did you move out?
I began the process of moving into the home on Southeast 20th in March, fully moved out in April. So we're talking about a few weeks before I filed my candidacy.
So what specific date did you start moving out of 8304 South Country Club Drive?
We had to, this is another home owned by my family, and so we had to start getting it cleaned up. I don't remember a specific date when we started.
You're saying 1426 Southeast 20th is a home owned by your family?
That's correct.
Okay. Why did you move?
Why did I move? Because I wanted to run for this position.
Okay, so you moved to run for this position.
That's correct.
Okay. Is anybody still living at 8304 South Country Club Drive?
Yes.
Who's still living there?
My wife Anna is still living there.
Okay. And so it's presently your intention to live apart from your wife. You're living at 1426 Southeast 20th Street, and Anna living at 8304 South Country Club Drive?
That's correct.
Okay. And you and Anna got married in 2019, is that correct?
That's correct.
And you guys have no intention of getting a divorce?
That's
or anything
correct.
like that? So, I take it 8304 South Country Club Drive is still furnished then, is that true?
That's correct.
Okay. Did you buy new furniture for 1426?
We had some older furniture that we moved in there.
So you didn't take any of your furniture from 8304 to 1426, so
That's correct.
Okay.
So not the, no, not the currently furnished
okay.
furniture.
Are the utilities at 8304 still registered to your name?
Yes, they are.
Okay. Are you still making payments on the utilities at 8304
Yes,
South
I am.
Country Club Drive? Are you still, well, so let me ask you, did you take out a mortgage to pay for 8304?
Yes, I did.
Okay, are you still making mortgage payments at this
Yes,
time? Are you paying property taxes at 8304 South Country Club Drive?
Yes, I am.
Okay. But to be clear, you're saying you no longer reside there?
That's correct.
Okay. So you're not trying to sell 8304 South Country Club?
The intention is to sell the house. Basically, the intention, yes, is to sell 8304. We have to do some repairs. We had some hailstorm came through and screwed up our roof, and there's a lot of visible damage that you can see from the road. And we've been fighting with the insurance company over getting that repaired. It's not something that my handyman skills are equipped to do myself. But the intention is to sell the house at 8304. So your statement is incorrect. We do intend to sell that house.
Is your house, is it listed anywhere for sale right now?
It is not.
Okay, so the house is not currently for sale?
That's correct.
Are you renting that house to anybody?
No.
You're not listing it on Airbnb or VRBO or anything, no short-term rentals?
You're correct.
Okay. How big is the house at 8304 South Country Club Drive?
I think it's listed at about 2,700 square feet.
And it's 2 bed, 2 bath, is that right?
Yes.
Okay. Did you tell the Oklahoma Bar Association that that was your residence? Have you ever told the Oklahoma Bar Association that?
I'm sure at some point, yes.
Okay. Would that have been after you moved in 2016?
I mean, I suppose so, yes.
Okay. Do you know?
Excuse me, may I ask you a quick question on that?
Sure.
I'm registered with the Oklahoma Bar Association. I don't provide them with my residential address. I provide them with my office address. Am I missing something?
All that we know is that Mr. Young provided the OBA, and in his membership directory up until somewhat recently, we think within the past couple of days, it listed 8304 South Country Club Drive as his point of contact, more or less. So, does 8304 have central heating and air?
Yes, it does.
Okay. So back on the OBA question, you did recently change that information, didn't you?
That's correct.
When did you change that?
When I received the basically petition to have me removed, I saw one of the pieces of information listed there was the Bar Association address, and I updated it then. And that's listed in our answer to the petition. We note that it's since been corrected.
So just, I want to make sure we have clear testimony on that. We filed our petition after you filed your contest, or after you filed your declaration of candidacy, correct?
That's correct.
Okay. And so you did not update your information with the OBA until you had received this petition? Is that
That's
true?
correct.
Okay. And in that petition, we advised that one of the reasons that we believed that you resided outside the proper electoral division was because you had a home at 8304 South Country Club Drive, correct?
That's right.
Okay, but you didn't see fit to update the OBA with that information until you were told that that was a basis for contesting your candidacy.
Honestly, I didn't even remember that they had an address for me. So I go on the OBA website about once a year when I have to pay my bar dues, and I haven't looked at where they had registered to me. I don't know when I even updated it to them. So, yes, so when I saw the contest of candidacy, I went and updated it, and we included a mention of that in our answer.
So the answer to the question is yes, you changed your you changed your address with the OBA after being advised that it was a reason that your candidacy was being contested. That's yes. Okay. You were registered to vote at 8304 South Country Club Drive, is that true?
That's correct.
And was the last time you voted while you were still registered to vote at
Yes.
8304? Sorry, is that yes?
Yes.
I'm trying to slow down the way I'm talking, so can you wait till I finish my question so we can just keep a clear record?
Yes.
Thank you very much. So the last time you voted, you were a registered voter at 8304 South Country Club Drive.
That's correct.
And you updated that voter registration a couple days before you filed your declaration of candidacy?
That's correct.
Okay. So let me ask you, you said you moved, or you were in the process of moving, so you could run for this election.
That's correct.
If the board decides in petitioner's favor tonight, what do you do about where you live?
But we're still going to sell our house. So we don't like our neighbors. We're still proceeding to move forward to sell the home. And so our intention is, right now, I am staying with the house on Southeast 20th is owned by my uncle. And my aunt requires additional care, so I'm helping out while he's a long-distance truck driver. So she's on oxygen and has other needs, so I'm helping out around while he's not home. And so I'm going to continue to stay there. We're going to sell our house, and we're looking at purchasing another home.
So would it be your testimony to the board then that if you were to lose tonight, that you will not be going back at any point to 8304 South Country Club Drive to stay for any period of time?
That's correct. I'm going to remain here on Southeast 20th.
Okay. Do you agree that 8304 is outside electoral division number 3?
Yes.
Okay. So you agree that if the board were to find you were a legal resident of 8304 South Country Club Drive, that you would be ineligible to be a candidate for this office?
Yes, I think that's correct.
Okay. So I want to ask you a little bit about 1426.
Okay.
See what we've answered so far. When you moved to 1426, which I think you testified earlier, you completed that move in April, is that correct?
That's correct.
Did you take all of your personal belongings with you, or are some of those still at 8304 South Country Club Drive?
I have a lot of personal belongings, so some of them are still at 8304. I brought my clothes, I brought my bedding, I brought my toiletries, toothbrush, toothpaste, comb, hair gel, all the things I need on a daily basis. I brought books, I brought computers, I brought my DVDs, I brought my TV. I brought everything that I'm going to use in a normal day-to-day environment. I did have to go back because I realized that I had forgotten, I don't remember what it was, but I'd left a nail clippers or something like that, and I had to go back over to pick that up from the house. But I went back, picked it up, and took it over to the house on Southeast 20th.
What of your personal belongings remain at 8304 South Country Club Drive?
Let's see. Our Christmas decorations are still there. We have, it's still furnished. I have some winter clothes that I hadn't brought over yet are still there. Let's see, what else do we have? There's assorted sundry materials that are still there. I guess it depends what you mean by personal belongings.
Things that you own, personal property.
Okay. Still have some dishes there. So, as I said, my wife continues to reside there, so we didn't clean the place out. I took what I needed to move and live just a day-to-day life there at Southeast 20th.
Okay. So is your plan then to, well, does your wife work?
Yes, she does.
Okay. So is your plan just to never see your wife, more or less? If you're residing there, she's residing here, and you've said you're never going back there, even if you were to lose tonight?
It's only 2 or 3 miles, so we see each other every day. But so my plan is definitely still to see her. The house on Southeast 20th Street has the fence needs repaired. We can't bring the dogs over until the fence is fixed. And so we have to get some repairs done on the house on 8304 Country Club Drive to get it ready to sell. And so the intent is for us to finish that up, get the fences repaired there at Southeast 20th Street. Then my wife would come along with the dogs. Southeast 20th Street is sort of close-ish to the interstate, and we don't want our dogs running out there and getting hit by cars. So the plan is, once everything is ready, she can move in then with me at Southeast 20th Street. And in the meantime, we are looking for, she is house shopping. So we don't know when she's going to find the one, but that is the plan.
Sure. It's possible that you, in fact, though, end up not selling your house at 8304 South Country Club Drive, right?
I am not psychic, so it is certainly possible that could happen, but it's not something that I can predict.
Gotcha. Have you looked at the home market recently? Because of the
She has been, oh yeah. My wife does new home sales, so she's all about, she sells houses, and she's been shopping for months.
Sure.
So.
Sure. So are you aware that homes typically are tending to go over quite a bit of, what their listed value is?
Yes, I am. And that's part of the problem that's part of why we chose the house on Southeast 20th Street, is because several of the houses that we were looking at were snatched up in an instant. So it's something where it's, you can't put all your eggs in one basket on a single place.
Sure. So let me propose something to you, and look, I'm not trying to invade by any means. This is sort of a hypothetical question. You testified earlier that your aunt is in somewhat poor health. Is your aunt is in somewhat
That's
poor
correct.
health? Okay. And so you're going to be taking care of her at 1426 Southeast 20th Street?
Well, I'm not a trained medical professional, obviously. I'm a lawyer, not a doctor. I am there to assist around, help her out with, you know, with whatever she needs. But I'm not a home caregiver.
So you're not required to be there
That's
for
correct.
her to conduct activities of daily living?
I mean, she can get up and move around. It's just, you know, she's older and, you know, she's got an oxygen tank. So,
How many people live at 1426 Southeast 20th Street, including yourself?
3.
Okay, and who are those 3?
So that's my uncle, James Young, his wife, Barbara, my aunt, and me.
Okay, and that house is something about 1,300 square feet, is that right?
That's correct. It's not very big.
2 bed, 1 bath?
Technically, I think that's correct. It's actually got some additions on the back part of the house, which is where I'm living. But as far as, it's a shotgun style house, so you've got a room at the front and then additional rooms going all the way back. Yes,
Are you sharing a bathroom with your aunt and your uncle?
that's correct.
Okay. And even if you don't sell your house at 8304 South Country Club, your wife would be moving into 1426 to live in that somewhat tight quarters living situation. That's your testimony?
My testimony is that the plan is to have a new house before she has to make that determination. So basically, we're already looking at selling the house on Country Club Drive, and she intends to basically move into the new house, whatever that may be. So if we sold the house on Country Club Drive and didn't have the new house purchased, yes, she could move in there with me at on Southeast 20th. But ideally, what happens is we have a new house lined up to move into, ready to go.
But in any event, your wife is going to continue to reside at 8304 South Country Club Drive until other things which may or may not happen occur.
That's
Fair enough?
correct. That's correct.
And nonetheless, if you lose tonight, or say you prevail tonight, but you lose in the election against Judge Allen, you're saying that regardless of all of that, even if you hadn't sold 8304 and it was still there, it was still the size that it is, and still had the amenities it does, you would be staying at 1426 Southeast 20th Street.
My intention is to stay at
Sir,
14.
that's a yes or no question.
Yes, that's my intention.
Thank you.
Do you have your wallet with you?
I do.
Can you pull out your driver's license for me?
I can. I presume you want to see my driver's license.
I would like to. I'll bring it back to you, I promise. So I'm looking at driver's license you just handed me. It expires July 31st of 2024, is that right?
I believe so.
Okay. It was issued July 30th of 2020.
Yes.
Okay. And it lists the address as 8304 South Country Club Drive, Oklahoma City, Oklahoma 73159.
Yes.
Is that accurate?
Yes.
Okay. This is your current driver's license?
That's correct.
Okay.
Thank you.
Let me get through my notes here real quick. So, do you have a copy of the exhibits that we entered into, submitted as exhibits earlier?
I do not.
Okay, counsel, can you use the copy that I gave you earlier, just for reference? Thank you very much. You'll flip to exhibit number 6, although. There we go. These are right here.
Yes.
So I want to ask you some questions about what has been submitted as defendant's exhibit number 6. Excuse me, not defendant's, petitioner's exhibit number 6. Should be for the board's reference behind tab number 6 in the evidence that was submitted. So Mr. Young, what we're looking at here is a document titled OG&E Electric Services Analysis of Electric Service. Do you see that?
Yes, I do.
Okay. And if you'll flip over to the next page for me. So this should be, say, page number 3 here at the top. Do you see that?
Yes.
Okay. And have you ever seen a document that looks like this before?
I've seen it in your petition.
Okay. Do you have any reason to dispute that this is a report of electrical charges and payments for an address at 8304 South Country Club Drive?
I do not.
Okay. And in fact, at the top of page number 2, I told you to turn one a little too early, it has your name listed there at the top, correct?
That's right.
And it has your address, 8304 South Country Club Drive, correct?
That's correct.
Okay. On this next page, I just want to point out a couple things that I find interesting here. So page number 3, about halfway down the page, there is a line for December 9, 2021 bill. You see that?
Yes.
Okay, and then across the page, the dollar amount listed there is $79.65. Do you see that?
Yes.
A couple lines down, there is a line for January 10, 2022
Yes.
payment. And then across the page, it says $80.84.
Yes.
Is it your understanding that what is being described in those three lines we've just covered there is that a payment was made of $80.84 on January 10, 2022 to satisfy the December 9, 2021 bill plus a late charge? I'll represent to you that $79.65 plus $119 is $80.84.
That appears to be what that is, yes.
Okay. So, a couple lines down, there is a bill on January 12, 2022 for $99.93. You see that?
Yes.
And a few lines down from that, there is a payment February 8th, 2022 of $101.43.
Yes.
Same question, is it your understanding that that February 8th payment?
Object to relevance.
Well, the relevance will be established by the fact that we're going to see that as Mr. Young is claiming to be moving out of his house, the utility electrical charges are increasing, which would be a little bit curious if he is spending less time at the home than he says he is.
Counsel, can you just get to that point?
Sure. On April 12th, the last entry here, April 12th, 2022, for $134.79, I would represent to you that that's a bill for the March 2022 usage. Would you agree with that?
That the April 12th bill is for March? Yes, I believe so.
Okay. And that $134.79 is in fact the highest electrical charge per month in 2022 reflected on this chart right here. Isn't that true?
Yes, I think so.
And yet you testified moments ago that in March 2022, that's when you began the gradual move out from 8304 South Country Club Drive. Is that true?
That's correct.
A couple last questions. With regard to 8304, did you claim a homestead exemption?
Yes, I did.
Okay. And you're aware you can only claim one of those, correct?
That's correct.
Okay. And you claim that, in fact, over the home that you were residing in, presumably when you filed that tax.
That's correct.
Okay. Are you paying any sort of rent or any payment to live at 1426 Southeast 20th Street?
I have discussed with my uncle reimbursing him for the costs of various bills, but I do not have any sort of rental agreement.
Okay, so to say that question again, are you paying anybody right now to live at 1426 Southeast 20th Street?
I am not paying any rent right now, no.
Are you paying any other charges as a condition of you living, hold on, let me finish. Are you paying any other charges as a condition of you living at 1426 Southeast 20th Street?
No.
Okay. I have no more questions at this time.
Mr. Haynes, your witness.
Mr. Hendrickson, I think you got a pen.
Yeah, thanks.
And I did pronounce your name correctly, it's Haynes?
You did, thank you.
Yes.
Mr. Young, did you talk about 4 different residences you've been living at over a course of years here?
That's correct, yes.
And was the Midwest City or the Dell City the first residence?
First residence that we refer to here was an apartment in Midwest City. I don't remember the address for it. It was back around 2013 and 14. Second address would have been 1809 Mansfield in Dell City, and that was in the 2014, 15, 16 period. Then Country Club Drive, and then the most recent that I moved into, completed the move into in April, is the one on Southeast 20th Street.
When you moved from the Midwest City address to the Dell City address, did you intend to ever move back to the Midwest City address?
I did not.
Did you ever move back to the Midwest City address?
I did not.
When you moved from the Dell City address to the Country Club address, did you ever intend to move back to the Dell City address?
I did not.
Did you ever move back to the Dell City address?
I did not.
When you moved from the Country Club address to the Southeast 20th address, did you intend to move back?
No, I did not.
Have you moved back?
I have not.
You acknowledge that you own the property on Country Club,
Yes, I did.
and as a result of that, you paid bills there.
That's right.
And you moved out of there when?
We started the process in March. I knew that I was going to be moving into that address, and so that was reflected on the committee form. I started in mid-March and finished first week of April.
When you moved from the Country Club address to the Southeast 20th address, was it your intent to return?
No.
At some point in time, did you file a declaration of candidacy?
Yes, I did.
What did you list your address as?
I listed my address as 1426 Southeast 20th Street in Oklahoma City.
At that point in time, where were you living?
I was living at 1426 Southeast 20th Street in Oklahoma City.
Where was it your intent to reside at that point in time?
At 1426 Southeast 20th Street in Oklahoma City.
Did you have any intent to return to your previous address at that time?
No.
Was it your intent to either live at the address on Southeast 20th permanently or for an indefinite period?
Yes.
Now, since filing your declaration of candidacy, were you served with a petition for a contest of candidacy?
Yes, I was.
Can you please tell me where you were served with that at?
I was served with that at 1426 Southeast 20th Street.
And do you recall what time of day that was?
I received a phone call from my wife, who was at 8304 at about 6:15 in the morning. She said there was a police officer there looking for me. He then came over to me at Southeast 20th Street, where I was staying, where I live, and at 6:45 a.m. he served me with the contest of candidacy.
So you were at the Southeast 20th address when you were served?
Yes, I was.
Was that where you were living at that point in time?
Yes, it is.
Is that where you were intending to reside at that point in time?
Yes, it is.
Had you changed your mind about wanting to go back and live at Country Club at that point in time?
No.
Do you recall when you would have given the Bar Association the old home address on Country Club?
No.
Is it something you look at every year to make sure it's accurate?
No.
And just brief, what type of practice do you do?
I am a DUI defense attorney.
Would it be your general intent to give out where you are living to criminal defendants and your clients?
Generally
Forum
not.
relevance?
Counsel?
I'd overrule it.
We'll overrule and allow it.
I think I work for a DUI defense firm. At some point in time, I was considering leaving that firm because I normally keep it as my work address. At some point, I was considering going out on my own. May have changed it then, but I don't recall any specific time when I would have changed it from my work address to my home address, and it has since been changed back to my work address.
And when it was brought to your attention that it was not your work address, it was in fact an old address, you changed that?
That's correct.
The house on Southeast 20th, who owns that?
It's owned by mine.
And has that house been in your family for a significant period of time?
Yes, it has.
Do you have any idea how long that house has been in your family's possession?
I believe before World War II, what is listed on the county assessor's webpage is 1978. 1978 would have been when my grandfather died, and it passed to my grandmother, and that's the earliest date that they have listed.
And have you seen a copy of the assessor's report for the address at Southeast 20th Street?
If that's what they listed in their challenge, then yes.
If you could look at the petitioner's exhibit number 4.
All right.
In the section property deed transaction history, who is Martha Young?
Martha Young is my grandmother.
Who is Herschel Young?
Herschel Young is my father.
And who is James Young?
James Young is my uncle.
So is it a fair statement that this is property that's been in your family for a substantial period of time?
Yes, it is.
And you're staying at that family property?
That's correct.
In fact, in the past, you had actually stayed at your parents' residence.
That's correct.
And you did file a declaration for candidacy.
Yes, I did.
What address did you state as your legal address?
The house on Southeast 20th, the 1426,
And why did you list that address?
because that's my address.
And is that where you intend to remain?
Yes, it is.
Any intent to go back to the old address?
No.
Any set in stone plans on an exact date when you're going to leave that address?
No.
And as a housekeeping matter, did you have to list a precinct number on your declaration for candidacy?
Yes, I did.
Is it your understanding that the precinct number you listed is incorrect?
Yes.
Could you explain that briefly?
When I updated my voter registration information to the new address, I waited until everything had been moved in and I was definitely living there because I wanted to do it all on the up and up. I updated the voter registration information, and then when I went to file my my candidacy paperwork on April 13th, I think, they had the old precinct number, and I asked, they told me to fill in the precinct number. I checked on the voter registration website, voter portal, whatever, and it had the old information. And when I was filling out the paperwork, the people there with the election board told me that I should put what was on the website at that moment, even though I knew that was not the updated and correct information.
Have you since went to the county election board?
Yes, I did.
And have you since determined what the correct precinct number is?
Yes, we received the updated precinct number.
to your knowledge, is the correct precinct number 550332.
I believe that's correct, yes.
And to the extent the board believes it's necessary to amend the declaration of candidacy, would you ask them to amend to reflect the appropriate precinct number?
Yes, please.
I have nothing further.
Redirect?
Yes. Mr. Young, you are an attorney, correct?
Yes, I am.
You owe a duty of candor to tribunals that you appear in front of, correct?
That's correct.
You owe a duty of candor in filling out forms that you fill out, is that true?
That's true.
Okay. I'm curious a little bit about some testimony you just gave. I believe you said you started moving out in mid-March.
Yes.
Would you flip to petitioner's exhibit number 3, please?
And I don't have,
Oh, sorry.
I'm sorry, I'm not sure what they're like.
That is there.
Okay.
So we're looking at the Statement of Organization Candidate Committee. And is this something you were required to file?
Yes, it is.
Okay. Here at the top, you listed under Brian Young, District Judge, District 7, Office 2, candidate residence street address, 1426 Southeast 20th Street.
Yes.
Candidate residence city, state, zip code, Oklahoma City, Oklahoma 73129.
Yes.
And this was in a statement to the Oklahoma Ethics Commission.
Yes.
So, pretty important to be honest in what your statement is right here.
That's correct.
You didn't reside at that house at that time, correct?
On, which date is that?
That would be March 4th.
I had an agreement in place to move into there. I had not moved, I think I moved a vehicle over. I had not completed any move to there, that's correct.
You hadn't started any move to there, I believe is what your testimony was earlier.
I believe that is what I said, yes.
And also, I would add, I think you don't have any sort of living agreement at 1426, is that true?
I don't have a written rental agreement.
Okay. So to be clear, on March 4th, 2022, when you submitted your Statement of Organization Candidate Committee, you listed a address as your candidate residence street address that you were not living at. Is that true?
I believe that's correct, yes.
So this is a false statement to the Oklahoma Ethics Committee on your Statement of Organization Candidate Committee, what we're looking at right here.
No, I don't think so.
Okay, why not?
As you were speaking to me earlier about trying to get me to come up with exact dates when I began moving, I gave you my best guess, my best estimate as to when I was moving, because honestly I wasn't keeping track when I began moving things in.
Well, actually, you told your counsel when he was asking you that you moved in mid-March, right?
I think you had asked me some questions pertaining to that as well. I gave you a date of mid-March sometime when I began the process of moving in. And that is the testimony I gave here. But the truth is I don't recall exactly when I began moving in. I reached an agreement with my uncle to move in there. Began moving things in. I don't know exactly what date it was. So you're correct. I stated here that it was sometime in mid-March. If I put it here, then it may have been earlier than that. But I don't know exactly what date I began moving.
So even by virtue of the fact that you put a specific residence and a date that you submitted this on, then you didn't even know what your residence was when you filed this Statement of Organization Candidate Committee.
I knew at the time. Asking me now, almost 2 months later, about exactly what date I began moving, I could not, I don't know now. But at the time, since I put this, I had moved something and begun the process of transferring over.
you'll flip to, go to Exhibit 9 for me, please.
And that is,
Sorry, this is the voter registration information
yes,
shortly prior to your filing of declaration of candidacy.
yes,
Your testimony here was that you changed this
that's correct.
prior to filing your declaration of candidacy.
That's
Is that
correct.
true? I want to point you to something listed here at the top under zip code.
Yes,
And that zip code is 73159. Is that
That's
true?
correct.
Which is the zip code for 8304 South Country Club Drive.
yes,
And the last time you voted, this is where you were a registered voter.
that's right.
Okay. To be clear, also, you gave some testimony to your council earlier that the property at 1426 Southeast 20th Street is owned by a family member.
That's right.
It's been owned by members of your family for a long time,
That's correct.
but it's not owned by you.
That's correct.
Okay. And for all intents and purposes, you don't pay anything at all. Utilities, rent, anything to live at
Mr. Hendrickson, we're
1426.
getting unnecessarily duplicative.
Understood? I have no further questions.
Mr. Haynes, do you have further questions?
No, thank you.
Very well. Members of the board, do you have any questions? No. Dr. Malden, you recognize.
We talked about home ownership property, what property do you own?
I own a home at 8304 Country Club Drive.
You and your wife own it
Yes,
jointly,
yes, sir.
and that home that you own, that's the only one
That's the only one.
you're paying, you're receiving as a tax exemption.
That's correct. We filed our taxes in, actually she filed our taxes. And I know she did them, she didn't wait for April. She did them earlier, but I don't know exactly when.
But you and your wife own the property jointly.
That's correct.
Now at 1420, you're not paying property tax there, are you?
That's correct.
And you don't own that exactly, I mean, it's not your.
That's correct.
Ms. Klein, do you have questions?
I do, thank you. Sir, I understand from your direct testimony that your sole purpose for moving to the Southeast 20th residence was to run for office. Is that
Yes.
correct?
That's correct.
When did you form the intent that you wanted to run specifically for District Judge in Electoral Division 3?
I had meetings with people back in, it was last year sometime in November, I believe. It's when I first began talking with people, determining what the best spot to run for happened to be. And I can't tell you an exact date, but it was before Christmas of last year. I decided that this was the spot that I wanted to pursue.
How long have you been an attorney in the state of Oklahoma?
Since 2003.
And since 2003, have you maintained any other address with the Oklahoma Bar Association?
Yes, I have.
When did you change the address of the Oklahoma Bar Association to the 8304 Country Club Drive address? I
don't remember. I worked for the Oklahoma County Public Defender's Office until about 2015. And I definitely didn't want any public defender clients to have my home address, so I changed it. I had it as the address for the public defender's office. When I left the public defender's office, I updated it to the work address downtown with the new firm, and I don't even remember when I changed it to the, obviously it was after 2016 because that's when I moved into 8304. At some point I changed it, but I would be totally guessing if I tried to tell you when.
When you moved from the PD's office to the work address, is that where you are currently working with the DUI firm?
Yes, it is.
And you've been continuously employed since leaving the PD office with the DUI firm?
Yes, I am.
Are you in good standing with the Bar Association?
Yes, I am.
Is it your testimony to this board that until you received the petition for the contest of candidacy, that you had no idea that you had your home address listed with the Bar Association?
That's correct.
Do you not receive your MCLE information at the 80304 Country Club Drive address, since that's what you have listed with the Bar Association?
I'm sure they send me something. I check my MCLE at the end of the year to make sure that I'm in compliance. And then I pay my bar dues at the beginning of the year. But I've been ahead on my CLE credits for several years, so it wasn't something that I had to really upkeep on.
And is it your testimony to this board that you have never, not one time, received a piece of mail from another attorney in a case at the address that you had listed with the Bar Association?
That's correct. I've never received a piece of mail at my home ever from another attorney. I've always received, no matter which home it was or what address, I've always received mail from other attorneys at my work address.
Have you ever listed a home address with the Oklahoma Bar Association other than the Country Club Drive address?
Yes, I have. So when I was before I worked at the Public Defender's Office, I had my home address, and that was 2003, 2004, in that time frame before I worked at the Public Defender's Office starting in 2007. I had my home address. I had a period there for 6 months or so, basically where I wasn't working, and I had that as my home address. I had my home address listed with them. And I think at some point in time, while I was at the Public Defender's Office, I may have changed it for some reason, but I don't.
Do you agree that the same is true, that you do not want the criminal clientele that you represent in DUIs to have your home address either? Would you agree with that?
No, there's a world difference between a DUI person and a murderer or something like that. So, as I told my counsel, I believe, and I'm thinking back several years now, trying to come up with something I wasn't really, at the time I made the decision, whenever that was, to change the address to the house on Country Club Drive. I had some reason why I changed it from my work address. I don't remember what that was. I'm retroactively trying to come up with that reason. I think I was considering leaving that firm, but I can't recall specifically why. But no, I'm not worried about a DUI client hunting me down.
Do you agree that the pertinent time frame that this board needs to look at in determining the facts germane to this issue is the actual time that you filed your declaration of candidacy?
Yes, I do.
I have no further questions.
Mr. Montgomery? Counsel?
No questions.
Very well, thank you.
Thank you.
I was going to conclude with some legal argument, but I can save that for closing, whatever the board would prefer.
I think, would we prefer that to be saved, or would you like to hear that now?
Closing.
What's that? Okay, it'd be appropriate for closing. Thank you very much. Yes.
Your rest, thanks.
Very well. Change, you're up.
Our sole witness would have been Mr. Young, so we have no further evidence to present at this time other than argument.
Very well. And you can do that at closing argument. Mr. Hendrickson, you are recognized for closing argument.
Ladies and gentlemen of the board, I want to emphasize a couple things in closing this petition, namely kind of the legal framework that we discussed at the start. To qualify by law as a candidate for district judge in District 7, office number 2, a person has to be nominated and elected from, as well as be a legal resident of electoral division number 3. The time of somebody's legal residency is measured as when they become a candidate. And when they become a candidate is when they file their declaration of candidacy. However, the term legal resident means the domicile to which a person intends to reside without the intention of returning to a previous domicile. So the time before contestee filed his declaration of candidacy is absolutely relevant to the board's consideration. There are a set of factors that can kind of vary, and they do, in determining if someone is a legal resident. As I told you in opening, the contestee was going to tell you that he intends to reside at 1426 Southeast 20th Street, and he intends not to go back to 8304. But the fact of the matter is, aside from that, and saying that he was present on the morning that the petition and the notice of hearing were served, the contestee has no other evidence that he did not ever intend to go back to 8304 South Country Club Drive. On the other hand, there is written evidence that was submitted and introduced as exhibits that up until very recently, the contestee was registered to vote at 8304 South Country Club Drive, that was the address that he submitted to the Oklahoma Bar Association as his address, that he was paying utilities at 8304 South Country Club Drive, and in fact those utilities continue to be paid. They are written in his name, that his driver's license still lists 8304 South Country Club Drive as his residence, that he makes no payments in exchange for residing at 1426 Southeast 20th Street. Nothing. He's staying there for free. Doesn't even pay utilities. That he claims a tax exemption for his residence at 8304 South Country Club Drive. That though he hopes to sell 8304 South Country Club Drive in the future, he has no immediate plans to do so. That his wife, his dogs, and personal property of his still remain at 8304 South Country Club Drive. And that he only moved to 1426 Southeast 20th Street to run in this race. The contestee is not a legal resident at 1426 Southeast 20th Street. The evidence that is submitted shows, as the Oklahoma Supreme Court described in a case called Sugarloaf, a pattern of conduct indicating that the contestee has no intention of abandoning 8304 South Country Club Drive, despite what he says, because all he has is what he says. The evidence shows otherwise. The law requires that the contestee be a legal resident of Electoral Division number 3 to run for this office. The evidence submitted to you, both in written form and in testimony from the contestee himself, demonstrates that the contestee has not established that he has abandoned 8304 South Country Club Drive. Therefore, he remains a legal resident of that address, and that address remains outside Electoral Division number 3, meaning that according to 20 OS 92.8A, he cannot be a qualified candidate to run in this election. And for that reason, petitioner submits to you and requests that the board strike contestee's candidacy from this ballot. Thank you.
Thank you. Mr. Haynes, you're recognized.
I'm sure I don't have to remind the board of what the burden or who the burden is upon here, but I'd feel remiss if I didn't point out it's upon the petitioner and it's a high burden. The sole question is not where Mr. Young lived 5 years ago, 2 years ago, 1 year ago. It's where he was a legal resident at the time he filed the declaration for candidacy. And the petitioner has wholly failed to show that Mr. Young was not a resident at the address on Southeast 20th Street. Mr. Young, through testimony, indicated he had been looking at that petition for some time. He sought out residences in that area. He moved into that specific division to seek out that seat. While it may be uncomfortable if you're a candidate for a position, if somebody moves to contest you in an election, that's not the standard of law. It's where you reside, where you intend to be, whether you intend to return and whether you intend to stay for an indefinite period of time. And I believe the testimony the board has received here is that Mr. Young did move. He did reside at Southeast 20th Street, and he does intend to reside there for an indeterminate period of time and has no intent to go back to the address on Country Club. He changed his voter registration. He filed a declaration of candidacy stating that was his legal address. And he told you as a witness that he moved there, that he intends to stay. He doesn't intend to go back. That's residency in a nutshell right there. Again, I understand why any candidate would not want to have a contested election. But the burden has not been met because Mr. Young properly lives in with Division 3 of District 7 and is a proper candidate for Office 2. And we ask you all to deny the petition, allow the voters of Division 3, District 2, to select their next district judge for office number 2. To the extent the board deems it appropriate or requires it, we would ask to amend the prior declaration of candidacy to reflect the correct precinct number. I don't believe that was brought up as an allegation, and the petition would be waived before this board as argument. But to the extent the board believes that's required, we would ask the board to allow that amendment.
Thank you, Mr. Haynes. Counsel? Oh, did you have a question?
I'm just thinking.
Counsel?
Board members, there are 2 statutes under Title 20 that are relevant to the determination or outcome in this case. The first being 92I, which Petitioner's Counsel did discuss. And it states as follows: to file as a candidate for the office of District Judge or Associate District Judge, one must have been a registered voter and actual resident of the appropriate county for at least 6 months prior to the day of the filing period. And that is the relevant part. The second statute that is relevant to the question for the board is Section 92.8A. In relevant part, quote, for elections held after 1994, district judges shall be nominated and elected as follows. Skip forward. Offices for candidates for offices number 3 and 10 shall be nominated and elected from and be legal residents of electoral division 2, which I believe is, are we in? Wow, no, sorry. Candidates for office numbers 2 and 11, statute's fun, shall be nominated and elected from and be legal residents of electoral district number 3. And it goes on to list other candidates, and then finally candidates for office numbers 5, 6, 7, 8, 13, and 14 shall be nominated and elected at large, beginning with elections in 1998. Candidates for office number 15 shall also be nominated and elected at large. And that is a relevant portion. You have heard the arguments of counsel, the testimony, and you have seen the exhibits. And you have 3 decisions before you. 1, if you find that the petitioner has met her burden, you can sustain the petition and strike the candidacy of Mr. Young from the ballot. Or if you believe that petitioner has not met her burden, you can deny her petition and retain the candidacy of Mr. Young on the ballot.
Thank you very much. Do I hear a motion?
I move to sustain the petition and strike the contestee as a candidate from the ballot.
Ms. Klein moves to sustain the petition and strike the contestee, Mr. Young, from the ballot. Is there a second?
I second the motion.
There's a second by Dr. Malden. Will the clerk call the roll, please?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
By a vote of 3 ayes to 0 nays, the board has voted to sustain the petition and strike the contestee, Mr. Young, as a candidate from the ballot. Thank you very much. That concludes
Thank you,
this matter.
everyone.
Thank you.
next cause will be 2022-07, Jean-Lou V. Lowe, State Representative District 97. Do we want to take a 5-minute break, to allow for the transition?
That'd be great.
Do I have a motion?
Second.
We have a motion for a 5-minute break and a second. Mr. Dunn, please call the roll.
Mr. Montgomery.
Aye.
Dr. Malden. Ms. Klein.
Aye.
We will reconvene at 8 p.m.
Who's the second, Ralph?
John.
Thank you, and welcome back. Now before us is the matter of cause number 2022-07, John Lou v. Lowe. And at this time, Mr. Schneider, did you have any comments to make?
Yes, Mr. Moody, as you probably recall, I'm legal counsel to the board. Have you reviewed cause number 2020-08 in the order setting forth findings of fact, conclusions of law related to the previous contest of candidacy against Mr. Lowe brought by Mr. Ben John Lou?
I looked over, I confess I did not read it with great particularity.
So what we're going to ask is that we don't want to rehash of last time. We want to streamline this process. We want to hear new evidence. So to the extent that you have new evidence, we're ready to hear it. But you're going up against this. So.
Very well, at this time we will recognize each party for opening statement. Mr. Moody, if you wouldn't mind, keep it to about 2 minutes and just give the board an overview of the evidence that you intend to present.
I'll just waive opening statement and we'll get straight to it.
Did we come back in?
Oh, did we both come back in?
I don't think we
You know what,
I believe you did.
I apologize, we need to have a vote of the board to come back in.
I'll make a motion.
We have a motion.
Second.
And a second from Heather Klein. Call the roll, please.
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
Very well. We're now officially back in. Mr. Moody, in cause number 2022-07, you waive opening statement?
We do.
Okay. Ms. Virgin, will you please state your name again for the record?
Yes, Emily Virgin, EMILIVIRGIN, counsel for the contestee. As Mr. Schneider said, this challenge should be familiar to this board. Essentially, nothing has changed. Mr. Lowe still resides on 63rd Street, where he is registered to vote and where he has lived for several years. The evidence we'll present is similar to that presented 2 years ago, in that he receives mail, pays utilities, pays for rent, and various upkeep around the residence at 63rd Street. I will note that on the petitioner's petition itself that there was a residency challenge and also a challenge on lying under oath. I would ask that the board not consider that claim, as that is not a grounds to challenge a candidate's candidacy under law, and that we would only take up the residency challenge at this time.
Thank you. Mr. Moody, you're recognized to begin your case.
Call Mr. Jason Lowe as witness.
Representative Lowe. Sir, if you'll please raise your right hand. Do you swear or affirm under penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
Yes.
And will you please state your name for the record?
Jason Lowe.
Thank you.
Mr. Lowe, what's your current address?
25 and a half Northeast 63rd Street.
And how long has that been your address?
Since 2015 or 16.
And since 2015 or 16, what percentage of your nights would you think you've slept there?
I have no idea.
Half?
More than half. That's where I live.
More than half? I didn't hear the last part.
That's where I live. More than half.
And so it's your under oath testimony that you're confident that you've spent more than half your nights in the last 5 years at that address?
Absolutely.
There's one way that we could put this issue quickly to rest. Would you be willing to allow my forensic examiner to take a look at your cell phone location?
Absolutely
Location
not.
If you've got nothing to hide, why would that be?
Because I'm not giving you my cell phone.
But wouldn't that clear this up as to whether or not you actually spent 50% or more of your time at that residence in the past 6-7 years?
No.
I absolutely think it would. And so you are denying us permission to look at your location without my experts got qualifications about. Please.
I'd object to this. If there's evidence that he has to present, would ask him to present that at this time, but he's not presenting any evidence.
Recommend sustaining.
We'll sustain the objection.
In your answer, you have an exhibit list, and one of those exhibits is a letter from Dr. Carl Clary, the alleged landlord of the property you live at. Is that correct?
Yes.
May I?
Mr. Secretary, have these exhibits been admitted? I know that the contestee filed them, but online it's just the answer. I have packets. If the petitioner would like to deem the exhibits as admitted or agree to stipulate that they're admitted, I'd be happy to distribute those at this time.
So stipulated.
Very well. Was opposing counsel with this already?
Counsel, are these identical to what was attached to your petition?
Yes.
Thank you.
Mr. Lowe, may I call your attention to Exhibit 6?
Yes.
What is that?
It's a letter from my landlord indicating that I have resided there since 2016.
And you've got that in front of you looking at it? Did you write was there a similar letter in the 2020 contest from that same landlord?
I don't recall.
Would you recognize it if you saw it, if there were?
I'm sure I would.
May I approach the witness?
You may.
You recognize that?
Mr. Moody, do you wish to enter this as an exhibit? Will you let Ms. Virgin review that prior to the witness reviewing it?
Yes.
Yes, what?
I do recognize it.
Okay, and so...
Can I see it?
Yeah, we have not admitted that yet. This will be Exhibit 9. Do you have additional copies for our files?
I do not.
If you'll hold tight, Garris, would you please make some copies of this momentarily?
Mr. Moody, do you have any other exhibits that you'll attempt to admit so that we could also get copies of those at the same time?
No.
And Ms. Virgin, you had no objection?
Correct.
Okay. And it will be admitted when we get it back as Exhibit 9?
Correct.
Okay. And he gets the original back.
And may I reapproach the witness?
You may, yes.
I'm going to turn this to you, Mr. Lowe. And if you would please turn back to your exhibit number 6 and compare the handwriting of those two documents for me. Does that look to you as though the same person penned those documents?
Yes.
You don't notice that the more recent one is much more in cursive and much more florid in its style.
I would object. The contestee is not an expert in handwriting. I don't think that anyone here is. So I would ask that we stick to the content of the letter rather than the handwriting contained.
Mr. Secretary, I recommend sustaining.
On advice of counsel, we will sustain the objection. Please move on to your next line of questioning.
Nothing further in the way of questions. I would just invite all of you to carefully compare that handwriting.
Do you have additional questions of the witness at this time? Very well, thank you. Ms. Virgin, your witness.
Thank you, Mr. Secretary and Board. Representative Lowe, you have the exhibits that have been deemed admitted in front of you. So I'd like to go through those with you at this time.
Yes.
Can you identify Exhibit 1A for us?
Yes, this is a bill, my water bill, I received from the City of Oklahoma City. It's dated 2/21/22. The amount is $54.66, and the address on the bill is 25 Northeast 63rd Street and a half, and that is my current address.
And turning to Exhibit 1B, is that the same type of bill from April of 2022?
Yes, April 21st, 2022, and it was sent to that address as well.
Turning to Exhibit 2, do you recognize this as a Cox Communications bill for Jason E. Lowe at 25.5 Northeast 63rd Street, dated January of 2022 for approximately $160?
Yes, absolutely. It was 12922, and once again, my address, 25.5 Northeast 63rd Street.
Turning to Exhibit 3, we have 3 and 3B. Are these copies of newspapers addressed to you at 25.5 Northeast 63rd Street?
Yes.
Turning to Exhibit 4A, is this a check for rent from you to your landlord, Dr. Cleary?
Yes, I pay my rent 3 months at a time, 3 months ahead. So this check is for $2,250, November 21st, December 21st, and January 2022. And if you would look on the back of the check, the next page, Dr. Cleary signed it, and it has been cashed.
Okay. Turning to Exhibit 4B, similar check for rent in February, March, and April of 2022 that has been cashed by Dr. Cleary, correct?
Yes.
Turning to Exhibit 5, can you describe this for us?
I installed a security system. There's a camera system throughout the premises, and I paid to have that installed. And this is a letter from the person that installed it.
Okay. On Exhibit 6, we've already discussed, this is a letter from your landlord, correct?
Absolutely.
And what does it contain?
It indicates that I've been a resident since 2016, and I'm in good standing.
Turning to Exhibit number 7, do you identify this as a receipt for mowing your lawn at 25.5 Northeast 63rd Street?
Absolutely, that's my responsibility to maintain upkeep. So I purchased, or I paid for services to have my lawn cut, and this is a receipt.
And Mr. Lowe, where is it that you reside?
25.5 Northeast 63rd Street since 2016.
All right, and that's where you're currently registered to vote, correct?
It is.
And that's the address that you listed on your declaration of candidacy?
Yes, it is.
All right, turning to Exhibit 8, this has already been referred to, but after looking this over, and I trust that you have looked it over, do you see anything of the facts and findings of the board in a similar case in 2020? Has anything from that time changed?
Objection, that's just simply self-serving and argumentative.
Can you rephrase the question?
Mr. Lowe, have you looked at the decision from this board in 2020?
Yes.
Objection, relevance.
Overruled.
We're going to overrule that on advice of counsel. You may continue.
Do you see anything in this order from this board that has changed since 2020?
I still live at the same place. I pay the same rent. I still reside there. Nothing has changed. This has been litigated. Nothing has changed.
Nothing further.
Mr. Mr. Moody, redirect.
Council asked you about that check that you paid your rent with. Was that your business check?
Yes.
You pay your personal bills with your business checks?
Yes, it's my law firm.
You expense your rent?
No, I do not.
And the receipt that she referenced with regard to the lawn mowing, by whom was that notarized?
Paula Brown,
Who is she?
my assistant.
And the person who mowed your lawn, who is he?
He is a lawn service guy. I mean, cuts lawns.
What month did you have the Ring device installed in your house?
I cannot recall.
Was it in the latter half of 2021?
No, I believe it was in 2021, middle of 2021. I don't know the exact date, but I believe it was in 2021.
Yeah, your brief indicated it was in 2021, but it did not suggest whether it was in January or December. Can you nail it down anymore?
I cannot remember, sir.
Could it be that you only had that installed once you moved in?
I've been living there since 2016. So I've moved in, I was there years ago, so I don't understand your question.
Nothing further.
Ms. Virgin, do you have additional questions?
Just one briefly. Mr. Lowe, is it fair to say that in reference to the petitioner's attorney's question on the Ring doorbell, is that maybe an improvement that you've made to the home since you've lived there?
Absolutely.
Are there other improvements you've made to the home since you've lived there?
Yeah, there's been things that has been repaired, the front door, the backyard, there was some repairs that were done. Matter of fact, inside of the home, we had a leak that was repaired. Yeah, so there's been a lot of things that have been repaired since the last time I was here.
Right. Nothing further.
Thank you. Members of the board, do you have questions for the witness?
No.
None? Counsel?
No questions.
Very well. Mr. Moody, do you have additional evidence to present at this time?
No, sir.
You rest your case.
Just a brief closing.
Okay. We'll get to that in a moment. I need to, if you rest, you'll have an opportunity to close. Ms. Virgin, do you have any evidence to present?
No, nothing further.
Very well. Mr. Moody, you're recognized to close.
In law, whenever you take the Fifth Amendment, it creates an adverse inference.
No one took the Fifth Amendment here.
We have a situation very analogous to that. We could have easily settled where Mr. Lowe has slept his head every night for the past 5 years had he been willing to show us his phone. I brought along an expert to accomplish that task. The very fact that Mr. Lowe was scared to have his phone seen and his location seen should alert suspicion in all of them. In fact, it should be a very good way for all of these contests in the future to be easily resolved. I would suggest you guys perhaps do that in the future, because I know of no better indication of where people are these days than where their phone is. Thank you.
Thank you, Mr. Moody. Ms. Virgin?
Members of the board, the facts and the evidence before you today only show that Mr. Lowe resides at 25.5 63rd Street. There is no evidence to the contrary, and to suggest that everyone should submit to tracking via their phone to prove their residency, I think this board should firmly reject as a matter of privacy and public policy. So we would ask that the petition be denied and that the contestee be retained on the ballot. Thank you.
Thank you. Counsel?
Is the witness dismissed? Sorry.
I'm sorry, Mr. Lowe. I left you hanging there. I'm sorry. You're dismissed from the stand.
Members of the board, there is one statute I would like to draw your attention to in determining the issues before you. and that is section 14108. I need to get my updated version. Apologize. Section 14108 sets forth the qualifications for a candidate for the House of Representatives. And that is again Title 14, Section 1008, and I'll quote to you the relevant language. It says, to file as a candidate for the House of Representatives in any House district, a person must have been a registered voter in such district and a resident residing within such district for the 6-month period immediately preceding the first day of the filing period prescribed by law. Except, however, to the file as a candidate for the House of Representatives in any House district in 2022, the person must have been a registered voter and a resident residing in such district no later than December 31st, 2021. Board members, we've also talked about what does it mean to be a resident, and we talked about some of the case law that is cited in cases such as these. I'd like to remind you that in Boggs versus State Election Board, 526p2, the court held that residency is a subjective intent. It's a fact question. Facts evidencing the intent of the individual to establish their residence. Board members, do you have any questions about the laws? I've read it to you.
No.
Thank you. So board members, after having heard the testimony presented before you as well as the evidence presented, and should you find by the greater weight of the evidence that Representative Lowe does meet the qualifications for candidacy for a House of Representatives, then you should move to deny the petition and retain the contestee as a candidate on the ballot. On the other hand, if you find that he is not qualified as with regard to residency, then you should move to sustain the petition and strike the contestee as a candidate from the ballot.
Do we have a motion?
I move that we deny the petition.
There's a motion by the chairman to deny the petition and retain the contestee, Mr. Lowe, as a candidate on the ballot. Do I hear a second?
Second.
There's a second from Dr. Malden. Will the clerk please call the roll?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
By a vote of 3 ayes, 0 nays, the petition is denied, and Mr. Lowe will be retained as a candidate on the ballot, and that concludes this matter. Thank you very much. And we appreciate everyone's patience. I know it's been a very long day. Thank you all.
Thank you.
Thank you. And our next contest will be cause number 2022-08, Sykes v. Wheeler. You're on deck.
I will make progress.
This one has 4 witnesses. No, the next one has 4 witnesses. 11 has 6
I do, thank you.
Good evening, everyone. We appreciate everyone's patience. I know it's been a very long day, so thank you for bearing with us today. We now call up cause number 2022-08, Sykes v. Wheeler. This is regarding Associate District Judge for Stevens County. And at this time, Mr. Sykes, I will recognize you for an opening statement. If you can keep that to about 2 minutes, and just give us an overview of your arguments. In one moment, counsel, did you have any? I heard you talking over there.
We're good.
Okay. Mr. Sykes, please. Thank you. You're right. And if you don't mind, restate your name for the record.
My name is Anthony Sykes.
You're recognized.
Members, Mr. Secretary, come before you today bringing this contest as my opponent does not meet the requirements of statute, specifically Section 511, and as detailed in my contest of candidacy. There are only legal reasons to not list or to be confidential under your declaration of candidacy are two. He does not meet either one of them, and his declaration of candidacy is insufficient, does not meet the statutory requirements. I request that you find that as a board, that he be removed from the ballot, or in the alternative, that this board require his candidate to make his declaration of candidacy public. Thank you.
Mr. Sykes, I do have a question. You alleged under 5-111. Could you get into detail on that? And 2, are we in dispute on the grounds of contest being qualifications, correct?
Can I address your questions
Yes.
one at a time?
Yeah.
Okay, if you start from the top there. Under paragraph 2 of my petition are many of the requirements in 511, and also list the general requirements in 5-111. It is my contention that unless those are filed properly and either a legal reason shows make them confidential, which I don't believe we have here, and I intend to prove with evidence that they should not be, that must be made public. I have a due process right to review that, and also the public, the legislature and the statute has contemplated that that's to be made a public document as well.
But do you agree that the grounds for contest of candidacy statute explicitly states that grounds of contest only go to a candidate's qualifications, correct?
Yes.
Okay. And so would you stipulate with me that 92I sets the qualifications for?
That is part of them, but every candidate, regardless of associate district judge, state senator, governor, must file a declaration of candidacy in order to be considered a candidate for the ballot.
And I'm not disputing that, but I'm getting down to the brass tacks. So the qualifications, are, and succinctly, a durational residency requirement and a durational registration requirement, both being 6 months, and the appropriate county.
As to the specific requirements for associate district judge. However, any candidate, and the statute is, got it right here, must contain the following information and must file their declaration of candidacy per the statute. And it's my contention he has not met 511.
Okay, and so in short, what I'm getting at is this is really an argument of law. This is not an argument of fact.
I think it's a fact that he's not entitled to the confidentiality provisions that he has claimed.
Do you have any information to dispute that?
Yes.
Okay.
And I intend to present it. And also, he has filed an answer which contains that evidence concerning that allegation as well.
Okay. Thank you, Mr. Sykes. But before we proceed with opposing counsel, I would ask that, because the issue was just raised on confidentiality, what we're dealing with is something known as restricted records as far as the contestee's address. Can counsel just briefly outline what that matter is regarding so the board has an understanding?
Title 26, Section 4-115.2 allows for certain members of our communities to have their records related to their voter registration restricted to public access, including their address information. This includes members of the judiciary, the law enforcement community, district attorneys, assistant district attorneys, and family members of the same, including spouses. And so we would just do of course, a respectful admonishment to the board that if we can, because Mr. Wheeler does enjoy the presumption of a restricted record, because he is, we have confirmed he is restricted in Stevens County on his records. We would just ask that we not reference the specific address in question to keep that confidential and out of the open domain.
Very well. Mr. Hammond, you're recognized. Would you please state your name for the record again, and then give us about a 2-minute overview of what your case involves.
Ladies and gentlemen of the board, my name is David Hammond. I'm an attorney for Duncan. I represent Lawrence Wheeler. I think the contestant's main complaint here is that he's denied due process because he cannot check out Mr. Wheeler's qualifications. His main complaint being he wants to be able to confirm his address. The application that Mr. Wheeler submitted shows that he lives in Stevens County. He's lived there more than 6 months. He's a licensed attorney. His work, he'll testify around 9 years, and that his residency has been consistent in Stevens County. The restricted status that Mr. Wheeler received was based on an application that he made with the election board in Stevens County. The contestant is not the person that can determine whether or not he qualifies to have a restricted address. That's up to the Stevens County Election Board, and the exhibits that Mr. Wheeler attached to his response show that he applied, and he will testify that he's been on that restricted list ever since. We do not think there's a basis to strike Mr. Wheeler from running for judge. At the most, so we're going to ask the board to deny that. If the board believes that Mr. Wheeler needs to amend his application, we can do that. Because what he'll do is, he'll testify there were 2 blocks that he needed to check to verify that he could restrict his address. One that deals with people that are members of law enforcement, judiciary, those types of things. He'll testify that he's been a city judge and a city prosecutor for Duncan for many years. And he was, when he checked the box, he mistakenly checked the wrong box. There was no ill intent. He more than qualifies to be a candidate. We're going to ask you to uphold his candidacy and deny Mr. Sykes' petition. Thank you.
And again, following up on counsel's instructions to the board earlier, we would ask all parties to not disclose any information about Mr. Wheeler's address in open session. Yes.
In his response, he has disclosed his address. So I just want to bring that. So when I raise that, I just want to let you know that I'm coming from his own pleadings.
I think if you refer to that, just please reference it as the address in the answer, not don't read the full address. Thank you. Is that agreeable?
It is.
Mr. Sykes, you're recognized to begin your case, sir.
Thank you. May I take the podium?
Yeah, of course, yes, please.
May I inquire, for clarification purposes, the issue before this board is not residency, is that correct?
As far as we're concerned, it's not.
I'm not allowed to examine and to discuss with counsel to provide any kind of confidential records that regarding his address.
Mr. Sykes, I do want to confirm with you, though, that you filed this petition at the state election board, correct?
That's correct.
And at the time you filed the petition, you were offered, based on 4-1152, you were allowed to see a copy of his declaration without the cover sheet, correct?
That is correct. However,
and that was your right under statute, correct?
I don't think so. The statute, at the time when I was filing it, he was under the ACP, which is a different program than the county program.
He was never under ACP. He mistakenly...
Is that his declaration of candidacy that you're referencing?
Yes.
That's the cover sheet. Is that the declaration?
It is a confidential declaration of candidacy request is what it is. And without any kind of adjudication, without any kind of, my understanding is this is the board that adjudicates whether that is correct or not. I was not offered that until I filed the contest.
In anticipation.
I was denied that prior to. In discussions, I was told I could not have it because of the
Counselor,
ACP.
please do not interrupt counsel for the board.
What I'm trying to say is, you were initially done that because he did mark ACP. And we wanted to be sure he was not a part of the address confidentiality program with the Attorney General's office. Once that was rectified and we confirmed that he was not an ACP program participant, were you allowed to see his stuff?
Only after I filed my contest. And the board and the personnel at the election board had reviewed it and to take note of the arguments in there, then I was.
Mr. Sykes, as we are here today, are you aware of the contestee's address?
I have been provided the information for review. However, I'm not allowed to discuss it with anybody. My understanding, instructions to me was I'm not allowed to discuss it, confer with counsel or anybody else besides just viewing it.
And for the board members to be aware, we do have an executive session on the agenda, so should we need to move into executive session so that you all have the benefit of discussing the address, we could take up a motion at such time as you believe it appropriate, if at all.
So just so I'm clear, Mr. Sykes, did you have the opportunity to review the contestee's residential information?
After I filed my contest.
And having reviewed the contestee's residential information, do you dispute his qualifications as a candidate based upon his residency?
I dispute his qualifications based on 115 that he has not met the requirements of that statute in filing the declaration of candidacy publicly. And that my rights are being restricted as far as being able to share that information, confer with counsel, confer with supporters, and due process rights that I would have in preparing a proper contest.
Any further questions? Please continue, sir.
I'd like to call Lawrence Wheeler.
Mr. Wheeler, will you please state your name for the record? Here.
Lawrence Wheeler.
Great. Will you please raise your right hand? Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
You are sworn. You may be seated. Mr. Sykes, your witness.
Thank you, Mr. Secretary. Mr. Wheeler, I've marked as my Exhibit A, this confidential declaration of candidacy request. Are you familiar with this document, sir?
May I approach?
Yes. Are you wishing to have that entered into the record as?
I was going to offer it after I'd give him a chance to further examine it.
Okay.
Yes, I'm familiar with this.
Will you please allow opposing counsel to see it? Mr. Hammond, do you have any objection to entering this into the record?
No, sir.
This will be Exhibit 1.
Sir, do you have a copy?
Yes, sir.
Oh. Sorry, we were slow.
Thank you.
Mr. Wheeler, having recognized this document and being admitted, is that your signature on this document?
It is.
And did you sign that on April 13th, 2022?
I did.
Mr. Wheeler, there are two boxes in here upon this form, and would you please read the language besides the box that you checked?
Check here if you have been certified as a participant in the address confidentiality program established by 22 OS section 60.14.
Now, Mr. Wheeler, is that a true statement?
I am not a member of that program.
Are you familiar with that program?
I thought I was.
What is your understanding of that program?
Well, at the time I checked that box, I thought that box was a reflection of the restricted records program that I am a member of. It was a mistake. I checked the wrong box.
What is that program designed for?
That program, is my understanding, is designed for victims of sexual assault and stalking.
Now, Mr. Wheeler, did you also include this as part of one of your exhibits?
I did.
Mr. Wheeler, you have filed a respondent's brief in support and a number of other exhibits as your answer, have you not?
I have.
And that includes an affidavit as well?
It does.
And I assume, counsel, you have a copy of that?
Yes, sir.
I'd like to ask you some questions from those documents that you have submitted. Okay.
And Mr. Sykes, will you be admitting that document in as an exhibit?
There are several in here, and I'm going to go through them one at a time if that's okay. They are stapled together, but they are separate. So would it be okay if I address them in that order, or would you prefer differently?
Would you like to admit them as one exhibit, or would you like to reference them individually?
I'd like to reference them individually because I'm
It would
going to
be
object
best
to
if we would mark them, and we could go ahead and do that now, and then we can take them back up.
Sure, they had marked them when they filed them, so I didn't know if that was the marking or if the board would like to remark them.
Do you have additional copies?
I just have the one that was provided to me. My understanding is it was filed with the board and distributed prior to.
I believe we all have copies in the packet.
I have no objections to those exhibits being in.
Okay.
My only, I just need to make sure that we have a formal stack for the permanent record.
Yeah.
And so the ones that I have available to me have my markings on them. We can go ahead and mark them as long, is that something that you could give to me after you're done with your questioning?
This is my only copy that
Okay.
I was provided.
Can we grab at least one copy?
Mr. Sykes, may he borrow your copy just to
Yes.
make some photocopies? We'll return that to you momentarily. Thank you.
Just the original back to you.
So Mr. Hammond, when he returns with the copies, if you'll review those quickly and if you have no objection, we'll admit those as exhibits.
Yes.
And we'll proceed. He should be back any moment now.
Quick question.
You may.
These things 1 through 10, some of them have A's, and have B, might be
This one's already one.
Okay.
So I could just start numbering to Mr. Sykes, maybe the three of us could talk about these exhibits and that might streamline the process going forward.
Very well.
So we have this as exhibit 1, and then the affidavit. You want that as an exhibit? Okay. Yes, that one too. And then if you'll just go ahead and tell me where the next exhibit is, and I'll go ahead and mark those, and then we can proceed. That's okay. Okay. But that'll be 3. Right, we have to remember we have one already. Yes.
I'm going to number these up for you, write their notes, and then I'll hand it to you so you can have what was marked and what was not, what he doesn't intend to call initially as a mistake.
Thank you.
May I continue?
Please.
I apologize, since I received this Friday afternoon, they were already marked. I thought that was, my understanding was already filed, so I apologize. Mr. Willard, and do we have another copy for him, or? Well,
Garris, we have an extra copy?
Let me give him mine.
Here we go. Thank you, we got it.
Mr. Willard, the first document in question is labeled as Respondent's Brief in Support. It's my understanding your counsel does not have any objection to the admission of this document.
That is correct.
Mr. Willard, my first question is on the second page in the paragraph that says therefore, who is Lawrence Walker?
That would have been a typo.
Okay, so it is intended for you that?
That should say Wheeler.
Okay, all right. On the first page in paragraph 4, you mentioned there's language there about the fourth line that says, which he completed as directed. Do you see that?
I do.
Okay. Now, was this direction did you complete this form at the direction of election officials there that day?
I did.
Okay. And are you referring to the confidential declaration of candidacy request?
I am.
Okay. Now, later on in that same paragraph, a few lines down, you see the words accidental oversight.
Yes.
Now, can you try to reconcile those two terms for me? You said on one hand that you're completing it at the direction of election board officials, but then it's an accidental oversight. How do you reconcile those two terms, or how that took place?
Clearly, the election official running the desk and myself both made a mistake of fact as to the contents of box number 2. I should have checked box number 1.
And going back to box number 1, it had a statutory side in it, correct?
It does.
Okay. And as an attorney, you're familiar with the statutes of Oklahoma and have looked those up?
Of course.
Okay. In paragraph 6 on the next page, you mentioned at towards the very last full line, an appropriate remedy. Is that correct?
It does say the appropriate remedy on the second to last line of paragraph 6.
And are you asking this board to make an amendment to your declaration of candidacy?
I'm asking the board to deny your request to have me taken off the ballot and allow me to amend my confidential declaration of candidacy request from box 2 to box 1.
So you agree that at the very least there'll have to be some kind of amendment made for your prayer to be answered?
Can you rephrase that?
So your argument, or what you're stating, is that at the very least you're asking this board to make an amendment to your declaration of candidacy.
I'm asking the board to deny your request to have me taken off the ballot. Alternatively, or in addition to, if the board sees fit to order my ballot or my confidential declaration amended, that is up to the board's discretion. I'd be happy to abide by whatever decision they make.
Your language says, which is the appropriate remedy in this case? So are you asking for that remedy, or are you just...
Check, he's answered that 3 times.
We'll sustain it.
Okay. In your packet that you had filed as response next, there's a document entitled Affidavit. my understanding, council has no objection to this being amended as well.
I do not.
In paragraph 1, you make a statement regarding your residence. And now I want to refer to it per the board's instructions as a residence or the address. And you say, do you see the part where it says, "am currently a resident of the property described"? And it's the very last of the
Yes.
of that paragraph. Okay. Now that's the property described in exhibits B1 and B2. Is that as labeled later on in your packet, which we have renumbered for the purpose of the board. Is that correct?
It says that.
Okay. All right. Now, in paragraph 3, about midway through, you mention the words stalk or harass. Do you see those about almost dead center of the paragraph?
I do.
Okay. Now, is this in any way related to your claims in box number 2 on the request for confidential declaration of candidacy?
Absolutely not. I've made it clear that I should not have checked box number 2, and that was a mistake.
Mm-hmm. In paragraph number 5, you have a long narrative there, and about beginning with the sentence "at the first desk." 1, 2, 3, 4, 5, 6, 7, 8, about 9 lines down. Do you see that? Do you see that sentence "at the first desk"?
I do.
It says, "I informed the election board representative that I was a municipal judge and the records are in the restricted section." Is the fact that you're a municipal judge the reason why your records are in the restricted section?
To be technical, the fact that I'm a municipal judge makes me eligible for the restricted records program. At the time I filled out my application for restricted records, I cited my status as a city prosecutor, but both that status as well as my status as a municipal judge both entitle me to the restricted records program as described in box 1.
And with your reference to box 1, do you see the words "I have applied" in that box?
I do.
And does that infer to you the past tense?
That to me inferred to me present tense. The impression I had from reading box 1 is that that was a process that was being considered, not something that I've been already accepted to. I thought the grammar of box 1 was misleading the way it's laid out.
Now, also in that paragraph 5, last substantive sentence, "at the representative's direction, I checked the second box and signed." So, are you again stating that it was a representative of the state election board that instructed you to check that box?
As you can see in my affidavit, I had a conversation with the election board representative at desk 2, and after having that discussion, he indicated to me that I should check box 2, based on the concerns I raised in my affidavit in paragraph 5.
All right, and counsel, the next exhibits are the warranty deeds.
Senator Sykes, before we move on, let's go ahead and admit the affidavit. I know that
Yes.
there was no objection. What is the exhibit number for this? Will this be exhibit 2?
The warranty deed,
No, the affidavit.
oh, I apologize. The affidavit is exhibit 3.
Exhibit 3. Okay, that will be admitted as exhibit 3. And now you're moving along, sir, to the warranty deeds.
Yes, please, if I may.
So
And
the warranty deed is number 4, and then 5. So what was B1 is now exhibit 4. What was B2 is now exhibit 5.
Mr. Willard, May I proceed?
Please.
Mr. Wheeler, the next exhibit I'd like to discuss, which is tentatively marked as number 4, is a joint tenancy warranty deed, which you marked as B1 on your answer. Are you familiar with that document, sir?
I am.
My understanding is council has no objection to the admission of that.
That is correct.
Now, before I move to admit, I want to bring it to council's attention and the board's attention that I'm about to come up on the documents that do contain the address that I'm not allowed to discuss, but yet is before. There's no objection from council. It's been offered by the contestee. I'm moved to admit it.
There's no objection, it will be admitted, but again, I would ask that you not verbally disclose the address in the conversation and in the questioning.
Mr. Wheeler, having said that you're familiar with this document, having been admitted, does this document contain the address of your residence?
Yes.
Okay. And is the document true and correct, to the best of your knowledge?
To the best of my knowledge.
Mr. Wheeler, very similar set of questions here as far as to the exhibit that's been tentatively marked number 5. My understanding is there's no objection from council.
That is correct.
It'll be admitted.
Be admitted as number 5. Mr. Wheeler, does the exhibit you offered as B2 that is now exhibit number 5 also contain your address?
It does.
And both exhibits 4 and 5 were offered by you with the consultation of council?
Yes.
And is the exhibit number 5 true and correct to the best of your knowledge?
Yes.
Board council, I now intend to move on to the document titled Request for Restricted Record Status. Will this be tentatively marked number 6?
That is accurate.
Yes.
And for the record, that was formerly attached or filed as Exhibit B. It was now being referred to as Exhibit 6.
Oh, thank you.
B.
Mr. Wheeler, are you familiar with the document that we have just identified as former Exhibit D, now Exhibit 6?
Yes.
My understanding is no objection from council to the admission of this document.
Correct.
Will the exhibit number 6 be admitted?
It is admitted.
Now, Mr. Wheeler, does your signature appear on exhibit number 6?
Yes.
And under reasons for application for restricted record status, is that your handwriting?
It is.
Would you read it, please?
City official -- assistant city attorney / city prosecutor.
And Mr. Wheeler, it's your contention that you are entitled to this restricted record because that title, and I'm going off previously admitted documents here, you were a member of law enforcement. Is that correct?
A city prosecutor is considered a member of law enforcement.
Do you have a statutory definition that supports that contention?
The statute that concerns the restricted record program specifically allows for law enforcement. I have a badge number. I issue tickets for failure to pay and failure to appear through the City of Duncan Municipal Court.
So you were the witness then on those tickets then?
I'm the prosecuting officer and the prosecuting attorney on tickets for failure to appear and failure to pay.
I'd like the board to take judicial notice of Title 21, Section 99, the definition of a peace officer.
I object to this document on the basis of Stevens County Election Board has already determined he qualified. Mr. Sykes cannot argue the legality of that once that election board has made that decision. So I don't think it's relevant to this hearing.
May I respond?
Yes.
The contestant answered the question that he is a member of law enforcement, that he believes he falls under that definition. I'm entitled to cross-examine. Counsel did not object at that time.
Counselor, may I ask you a question? Isn't it true that if you have a dispute to whether this particular witness qualified under the records confidentiality program in Stevens County, that you would have to take that up with the board that issued the protective order to allow him to maintain confidentiality as to his residence?
I respectfully disagree. For number one, I don't know of any procedure that allows a statutory procedure that allows a citizen or a contestant at a state level to do that at the county level. The statutory definition of the program you've referenced, the county program, is specifically on the form that has been admitted here at the state election board. And if he does qualify, then he is entitled here. So I think my recourse, my remedy is here is he is a state officer, a state candidate. It is a state statute. It is incorporated into a state form, and as he has joined in his prayer also to for this board to amend under that statute. I think my only avenue and recourse is here is for the reasons stated.
Are you asking this board to determine the validity of a decision made in Stevens County that this witness qualified to maintain confidentiality as to his residence?
I am asking that, and so is he. And however, even though that is a county determination, the county election board is subservient to this board. This board routinely appoints and members to county election board secretaries. It is a state statute. It is a state office, and it is incorporated into the forms and the procedures of filing for office. And that is a way if it's a way that you can be confidential through this board, then I think my only avenue is here, and I've got to take that up here. And I think the proper venue is before this board. Is that is what he is indeed claiming.
So we have an objection to the admission.
Mr. Chairman, that's your objection.
Yes. Illegal.
I think at this point, let's overrule the objection. Let's go ahead and do the testimony, and then we can evaluate the analysis in relation to the board's determination.
Very well. The board will take judicial notice of the statute.
And Mr. Sykes, before you begin, will you please recite the statute that you're referencing?
Absolutely. Title 21, Section 99, definitions, peace officer.
Continue.
May I read the statute?
You may.
The first paragraph, the term peace officer, in quotes, means any sheriff, police officer, federal law enforcement officer, tribal enforcement officer, or any other law enforcement officer whose duty it is to enforce and preserve the public peace. Mr. Wheeler, are you CLEAT certified?
I am.
And what are your certifications in?
Can I pull out my CLEAT certification?
Sure.
I am I will read it verbatim. Firearms qualification certificate for municipal judge.
Okay. Are you qualified, CLEAT certified when it comes to law enforcement, not a judge?
I'm qualified for CLEAT for municipal judge purposes. That's my only CLEAT certification.
Okay. So my question was, are you qualified?
Object. One of the reasons for the confidentiality is not only law enforcement, but it's also judges. Mr. Wheeler is the city judge, and he'll testify to here in just a little bit. I think it's irrelevant and a waste of the board's time.
And my response to that is he has never applied for that status. And therefore it's a contingent, it's a maybe. He might be qualified, he might not be. That's a question for another day. It's not before the board at this time. He is alleged that he is a member of law enforcement, and that is what is before the board.
Mr. Sykes, I have a question just for the board's sake as we are heading down this path. For the sake of argument, let's say that he is not qualified as he applied for the restricted records. How is that disqualifying to run for associate district judge?
He is claiming this confidentiality, and I've got, as cited in my petition, section 5.111, and then .1, to be valid, a declaration of candidacy must be submitted to the secretary of the election board and shall be signed by the candidate in writing. I cannot examine that. It is a requirement. He must either file it, and the only way he can keep it confidential is to qualify.
Did you receive a copy of the declaration of candidacy from me when you dropped it off at our office on the last day to file the contest?
I was allowed to. I did receive a copy.
One more question. Were you offered an opportunity to amend your petition in the event that something on the declaration caught your eye and was deemed to be a violation?
I was offered that in the less than an hour I had to do that, to consult with counsel, to reconcile it with records. So while I was offered that, I don't think there's any kind of due process accountability to a contest or contemplation of candidacy to do that right on the spot because you have filed this, we're giving you this. And so yes, to answer your question, yes I was, however I don't think that meets with due process requirements or the statute.
Very well, thank you.
Going back, because I'm sorry, I forgot where we're at. You're not CLEAT certified to be a peace officer, correct?
I'm CLEAT certified pursuant to 20 OS Section 129.
Yeah, just a moment, please.
Yes.
Mr. Wheeler, is the only request for confidentiality you've made at the county, under Title 26?
I'm sorry, I thought you weren't finished.
Oh, no, pardon me. Is the only request for confidentiality you've made pursuant to Title 26?
So I made a request for confidential records based on my stats as a city prosecutor primarily. That was granted on January the 8th of 2015. I became a municipal judge within 2 weeks thereafter. I did not see it necessary to reapply for a program that I was already a member of, listing my additional qualifying status.
That would have been under Title 26 as well, correct?
Yes.
And that's the only one you've made, correct?
I've only made one application to Stevens County for confidential records, and that is the one that has been provided here today.
In your testimony, you said that you were, and on your form, you said city official, assistant city attorney, city prosecutor, correct?
That's what it says.
Now, are you an employee of the city of Duncan?
I'm not.
What is it true that your firm, that you're an associate of, has a contract with the city to provide legal services?
That is correct.
So the city of Duncan doesn't provide any benefits to you through that employee relationship, through that relationship, correct?
Outside of compensation provided via the contract, no.
And is it a full-time job being the assistant city attorney or city prosecutor, or do you maintain a private practice as well?
I maintain a private practice as well with my law firm.
Now, in this, you said you were a city official. What are these two titles of what you're claiming as a city official, the city assistant city attorney and city prosecutor?
I have the title of assistant city attorney and city prosecutor. You could say that those two titles imply in some capacity I am a city official, despite the fact that I do not have a direct employment relationship with the city of Duncan. I do appear as the face of the city of Duncan for PR purposes routinely anytime I interact with the public, and I take that into account in all my interactions with the public.
But your relationship is through your private law firm, correct?
That's correct.
He's answered that at twice.
Will sustain.
Mr. Secretary?
Yes, sir.
Before proceeding, I have a case that I'm going to be asking to take judicial notice of, or can I admit that now, or will I be allowed to use it in argument?
Did you bring copies, or do you need copies to be made?
I've got the one copy here.
Okay, if you'll provide that to Garris, we'll make copies for the opposing counsel and the board and our own counsel.
Can you give us a quick side, please?
Yes, ma'am. It is Oklahoma Association of Broadcasters, Inc. versus City of Norman. It is 2016 OK 119, 390 Pacific 3rd, 689. And once again, that's Oklahoma Association of Broadcasters, Inc. versus City of Norman, 2016 OK 119, 390 Pacific 3rd, 689.
Thank you.
Thank you.
Thank you. We'll pause just for a moment while he makes copies.
At some point, I would ask the witness a question.
At the appropriate time, yes, sir.
Notes about the case. We're looking at accommodations for tonight.
I understand.
And we're looking for a room. Yeah. Whoa. Jerry. You have to drive up there and go to the meeting. That's when we'll have.
Just a reminder, we're still in session here.
Oh, I'm sorry. Thank you.
Board members, do you want to take a very brief break while we're waiting on these copies? Does anyone need a 5-minute break, or do you want to just wait? We'll wait? Okay.
I'm fine.
On second thought, I
Okay.
move to take a quick 5-minute break.
Second.
All right, we have a motion by Ms. Klein for a 5-minute recess, seconded by, I think Dr. Malden already seconded it.
Okay.
Can you please call the roll, Mr. Dunn?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
We're at a 5-minute recess. We will reconvene at 9:26 p.m.
Get a room.
speeds up.
Thank you. At this time, I'll entertain a motion to reconvene. We have a motion by Mr. Montgomery, a second by Dr. Malden. Mr. Dunn, please call the roll.
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
Mr. Sykes, we have distributed the copies of the case that you wanted to refer to, so you may proceed, sir.
Members, Mr. Secretary, the case that I've been distributed, or had distributed, is Oklahoma Association of Broadcasters Inc. versus City Norman. It is a final decision by the Supreme Court of the state of Oklahoma. It has to do with confidential records. I would move that the board take judicial notice of it.
Without objection, that'll be the order.
Okay. And with that, I wanted to argue it during my closing, which I believe I'll be provided later, correct?
Yes.
But it is in the record and in evidence, correct?
We have taken judicial notice of it, yes.
I would pass the witness at this time.
Very well. Counsel?
Thank you, sir.
Can I proceed? Mr. Wheeler, what county do you reside in?
Stevens County.
And tell the members of the board how long you resided there.
I resided in Stevens County since April of 2012.
And are you a registered voter in Stevens County?
I am.
And tell the board when you registered.
I registered to vote approximately the spring of 2012.
At that time, had you tried to get restricted status on your address?
At that time, I did not attempt to get restricted status on my address.
And when did you decide to do that?
In January of 2015, I was at the courthouse early voting, and a member of the Stevens County Election Board recognized me as the municipal prosecutor from City Court and asked me if I was...
Without getting anything that she said, because that's hearsay, what did you do at that point?
After encountering that election representative at the courthouse, I filled out an application at their direction for the confidential records program with Stevens County.
At that time, did you have any intent to be deceitful about anything?
No.
What was the purpose for doing it?
It was I was told to hide my address so people couldn't harass me that I might have made upset through city court.
And was that application accepted?
It was.
To your knowledge, was it approved?
I believe it was approved the following day.
Can you tell this board what information you have to know that it was approved?
On the exhibit marked request for restricted record status, where it says city official, assistant city attorney, city prosecutor, that document, if you will look at the top right corner where it says deleted 1/8/15, that was the day after I made this application. And a member of the Stevens County election, I was made aware that that meant my voting records up to that date had been destroyed. That's why it says deleted 1/8/15. So it wouldn't have been approved. Those records wouldn't have been destroyed if they hadn't been approved.
Is your voter registration on the regular list of Stevens County voters? Or is it on a different list?
It's on a different list.
Could you explain, please?
My voting registration is on a list entitled restricted in the Stevens County Election Board.
Are you a practicing attorney in the state of Oklahoma?
I am.
And are you licensed?
I am.
Tell the board when you were licensed.
April of 2012.
And sir, over the last 9 years, have you ever lived in any county other than Stevens County?
I've only ever lived in Stevens County since becoming an attorney.
Has that residency been interrupted at all?
My residency has never been interrupted since I became a resident of Stevens County.
When you filled out, do you recall the day you filled out your candidacy application?
I do.
And on the application, are you required to put your address?
Yes.
And did you do that?
I did.
Is that on file with this election board?
It is.
And part of the time Mr. Sykes filed the complaint, is he allowed to get copies of that?
According to Title 26, Section 4-115.2, He's allowed me to copy my address from the election board.
And did you ever have any objection with that?
No.
Did Mr. Sykes ever call you and ask you where you lived?
No, he didn't.
Anybody on his behalf ever call you and ask you where you lived?
No.
The form that you filled out on your application to request your address be kept confidential, is that a form you had or is that a form you received?
It's a form I received from the Stevens County Election Board.
Is that a form you were able to study before you came to apply for the judgeship?
Can you rephrase that?
Did you have that form prior to the time you filled out your application?
If I may, I'm confused about which form he is referring to. Is he referring to the one that we've entered as Exhibit 6?
Exhibit 1.
Or Exhibit 1, okay.
Yes.
Very well.
Exhibit 1, Mr. Weeder, did you get that copy before you came to the election board to apply, or did you get it when you came?
I was given this form at the courthouse, and I filled it out at the courthouse.
Which courthouse?
Stevens County Courthouse.
Now, you may be confused. I'm talking about Exhibit 1, where you checked the wrong box.
I apologize. I was looking at the request for restricted record status.
I'm referring to Petition Exhibit 1.
The document titled Confidential Declaration of Candidacy Request?
Yes, sir.
I see it.
And when did you receive that?
I received this when I approached desk number 2 on the election day, on Wednesday.
Now, you testified earlier about there may have been some confusion on which box you checked. Is that correct?
There was.
Now, on the second box that you did check, do you recall seeing 21 OS section 60?
I see 22 OS section 60.14 on box 2.
Is that something that you thought about at that period of time?
I did not think through that statute at that time.
And was that a mistake on your part?
That was a mistake on my part.
Were you trying to hide anything?
No.
Do you feel that the contestant, Mr. Weeder, has access to information that he needs to determine your eligibility?
I believe he has that access and had it last week.
Do you believe there's any basis to his complaint?
I do not.
Is there anything else you would like to tell the board about your qualification status that I did not ask?
I'll object, ask for a narrative.
Can you please ask a specific question?
I'll withdraw the question.
Very well. Does that conclude your questioning of the witness, or do you have further questions?
I just want to introduce one exhibit, so I'm going to let him look at it.
I've looked at it, but this be the proper time to lodge an objection.
You have an objection?
I have an objection that's irrelevant. It has to do with qualifications regarding municipal judge, which is not before this board at this time.
If I can respond, he asked Mr. Wheeler if he was cleat certified. Mr. Wheeler pulled out his cleat card and has already testified to it, so he's waived any objection that he may have.
I'm going to overrule the objection since this has already been a line of questioning.
If I'll mark this as R1, I'll go follow his left.
We're going to go ahead and do the next number, and I'll show that as what you marked as Exhibit 7.
Exhibit 7 is omitted.
May I have my copy back?
That's going to leave me one copy short.
You need one more, you said?
Yeah, I've got 5 here.
I think we can make 5 work. I don't need one.
you want a copy of your food card? Go ahead.
At this time, we move to introduce Exhibit 7.
Yes, it has been amended. Thank you.
I'll pass the witness.
Very well, Mr. Sykes, do you have further questions?
Left cross, please.
You may.
Mr. Wheeler, is this CLIC certification the only CLIC certification you hold?
Yes.
And your counsel asked you if you were familiar with the statutory site on exhibit number 1. And my recollection is your answer was no. Did you look up that statutory site before affixing your name to that document?
Are you referring to 22 OS 60.14?
Yes.
When I signed this document at the help desk, I did not look up that statute while I was standing in line.
Mr. Wheeler, do you still object to your address being made public?
I do not. If the board wants to make my address public, that's up to the decision of the board. I'm not going to express an opinion on that.
Pass the witness.
No questions. At this time, does any member of the board have a question of the witness? Dr. Malden, you're recognized.
In relationship to the city of Duncan as currently, I believe, and as a judge, you're a municipal judge presently.
I'm a municipal judge for the town of Ryan.
I'm sorry, for the town of Ryan. Statement. To do that, you have to be sworn in by the city of Ryan.
That is correct.
So it's not that they just simply hire somebody, there's an oath you take.
I had to be sworn in by the city council when they hired me.
Thank you. That's all I have.
Ms. Klein, do you have questions?
I do not.
Mr. Montgomery? No. Legal counsel of the board, questions?
No questions.
Very well. You're dismissed. Mr. Sykes, do you have further evidence to present?
I pressed at this time and I'd like to be heard in this argument.
Very well. Mr. Hammond, do you have additional evidence to present?
I do not.
You rest?
Yes.
Very well. At this time, Mr. Sykes, you're recognized for closing arguments.
Members of the board, Mr. Secretary, I have in the past both prosecuted and defended cases successfully before this election board, and I want to begin by saying that this is certainly not your average run-of-the-mill case. I certainly recognize that, and I appreciate your patience and your questions that you brought here. This case started with my opponent claiming to be a victim of sexual assault, domestic violence, or stalking. And in the course of that, and thus enrolled in a program that kept his declaration of candidacy confidential. Now, we've discussed the statutes. They are cited here in my contest that a person must file a declaration of candidacy. And in doing that, their opponent has the right, the statutory right, which becomes a due process right, to examine that and see if a contest is warranted and prosecute that with the full knowledge and benefit of that information. And throughout the course of this, it was a flowing process, and I'm not going to get into whether I disagree with the process as it turned out. However, I will tell you, it was denied that information. The only time I got that information is when I filed that declaration of candidacy after expending every other resource I had to try to explore and to learn about what my options were. So this board is my only recourse in that. It is my opinion that the contestee has not met the requirements of the public declaration of candidacy, and for that must be stricken as a candidate for the office of Associate District Judge of Stevens County. Now, that is cited in my, specifically in section 5111 and section 5-111.1. Sorry for all the ones, but that's how they numbered them. And if the board will not entertain that prayer, then even the contestee has asked this board to amend the declaration, and I think I've shown through evidence that he is not entitled to either program. He's confessed that he's not a member of the ACP program as indicated in the exhibit number 1, and if you recall in the evidence, the statute, he's claiming confidentiality as a peace officer. Or as he is not law enforcement. He does not meet the statute, which was taken judicial notice of. He is a part-time contract attorney with the city of Duncan, and he only clean certification is that of a judge to carry a firearm. He does not meet that definition or Title 26 of that class, and I'm asking the court the board to make that determination and make his declaration of candidacy public in that regard and amend that. He has waived his objection to that. I would also draw the board's attention to this case, Oklahoma Association of Broadcasters, Inc. versus the City of Norman. This is the much famous Joe Mixon case from the University of Oklahoma, where the running back for the University of Oklahoma had an altercation, and there was a criminal investigation, and the press wanted it, and the investigating officer said that was confidential under the exceptions to the Open Meetings and the Open Records Act. However, and I would specifically draw your attention to the concurring opinion, paragraph 5, and I'm sorry the pages aren't numbered, but essentially the holding of this case was that it might have been a confidential record at some point, but the way it was introduced in court and marked by the court made it a public record. And I would submit to you that through the exhibits on the warranty deeds, Mr. Wheeler has made that address, which I very respectfully did my absolute best to respect the board's guidance in not mentioning that address. He filed it, that's his exhibit, admitted with no objection offered by his attorney, so it has been made public by, I believe, these are public records that can be requested by anybody that qualifies under the Open Records Act. So I would urge this board under Oklahoma Association of Broadcasters versus City of Norman, if it was confidential at any point, it's not now, and to amend his declaration of candidacy to be public for all those reasons. And still, that is my alternative prayer as cited in my petition. I would first ask you to strike him from the roll of candidates. Thank you for your time and attention.
Thank you, sir. Mr. Hammond.
Thank you. Ladies and gentlemen of the board, we appreciate you considering this matter on behalf of Mr. Wheeler. I believe that the petitioner's complaint that he's made has missed the point. The two requirements, the reason for these requirements are to make sure that the candidate for Associate District Judge of Stevens County are qualified. It's undisputed that Mr. Wheeler is a resident of Stevens County. It's undisputed he's been registered to vote for well over 6 months. It's undisputed that he's resided there for well over 6 months. Mr. Sykes' problem is he wants to know Mr. Wheeler's address. The candidate qualifications state that if they reside in Stevens County, they qualify. Mr. Wheeler filled out his application to keep his address hidden. The Stevens County Election Board confirmed that and allowed him to do that. The petitioners cannot complain about that in front of this board. He's claimed that he's denied due process because he needs to verify where Mr. Wheeler lives. These deeds that we submitted as exhibits, those are public records. Anyone can walk into the county clerk's office, to the assessor's office, and make sure that Mr. Wheeler is a resident of Stevens County. Mr. Sykes knows that he's a resident of Stevens County. He knows that he's a voter. He's complaining because he didn't get his address. He's brought forth complaints to this board, in our opinion, trying to make Mr. Wheeler look bad. That's not the purpose of the qualification requirements. That's not the purpose of this board. We're going to ask this board to not deny Mr. Sykes' request. If the board believes that Mr. Wheeler should change the form and check the appropriate box, we would do that. He made a simple mistake. There was no evil intent that he did. He's standing in line. He's got people behind him. It's not like you've got 2 or 3 days to sit there and study these things. He should have checked the right box, and he did. And he was honest, and he told the board that he didn't do it. However, he is more than qualified to be a candidate. We're going to ask you that you deny Mr. Sykes' request. Thank you.
Thank you, Mr. Hammond. And I do want to say I appreciate the patience of both parties. I know the hour is late, so thank you. At this time, I would ask counsel to advise the board on matters of law.
Okay. There's two statutes that I want to call your attention to, specifically Section 5-120 of Title 26, which sets forth the grounds for contest. Said petition must allege that the contestee was not qualified by law to become a candidate for the office for which he filed a declaration of candidacy must contain the reasons therefore. In other pertinent part, Title 20, Section 92I states, to file as a candidate for the office of district judge or associate district judge, one must have been a registered voter and actual resident of the appropriate county for at least 6 months prior to the first day of the filing period. Board, you have heard the testimony, you have heard or seen exhibits, and you've heard the arguments of counsel. You have three options before you. One, if you believe that the petitioner has met his burden, you should move to sustain the petition and strike the contestee as a candidate from the ballot. If you believe that the petitioner has not met his burden, you should move to deny the petition and retain the contestee as a candidate on the ballot. Or, in the alternative, you may also move that the contestee be allowed to amend the contestee's declaration of candidacy to conform to law, if the board determines such amendment or correction is appropriate.
I have a question, Mr. Schneider. When you refer to amending the declaration of candidacy to conform with the law, in your opinion, would that also apply to the confidential declaration of candidacy request form?
I think it can apply, but it's my recommendation and my argument that the request form has no legal value.
Very well. Are there questions of counsel from the board? Very well. Do we have a motion?
I'll make a motion.
Mr. Montgomery, you're recognized.
I want to amend the declaration to conform with the law. That'd be my motion.
And are you referring specifically to the confidential declaration of candidacy request?
Yes.
Okay.
As we were talking about.
So there is a motion to allow the contestee to amend the confidential declaration of candidacy request form. Is there a second?
Can we have any discussion before?
Of course.
Wait a second.
Oh.
Based on counsel to the board's advice that that declaration has no legal value, to me the more appropriate motion would be to simply deny the petition and allow the contestee to remain on ballot based upon the counsel to the board's advice.
We will, but with this, we will give him the option to clean up this declaration. You know, you might call it clean up, I don't know, my word is clean up. That's the only thing I'm saying. I mean, he can say, hey, I made a mistake, I'm fixing it.
Is there further discussion? Well, right now, go ahead, Dr. Malden.
I'll second the motion.
Okay, so you're seconding Mr. Montgomery's motion. So the motion, go ahead.
Do we have two motions?
No.
Well, you can only take up one motion at a time.
Well, and that's why I thought I heard two.
I said the more appropriate motion.
Okay, you were not discussing the motion. Okay, I understand.
Yeah,
Sorry.
I think we need to dispose of the first motion.
I agree.
First, yeah.
I agree. I wanted to make sure we knew which motion we were voting on.
So Mr. Montgomery has moved to allow the contestee to correct the confidential declaration of candidacy request form, and Dr. Malden has seconded the motion. And so I believe at this time we would call the roll.
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
So by a vote of 3 aye, 0 nay, the board votes to allow the contestee to amend and correct the confidential declaration of candidacy request form. Mr. Clark, would you please bring that forward? And next we'll talk about assessment.
May I ask a question, Mr. Secretary?
Yes.
Since he's given the option to correct it, does that include leaving it blank?
How would you like me to do it?
Well, he needs to be the one that makes the correction, not you, Rusty.
Well, I'm going to hand him that red. Yes.
I'll just strike through the blocks below and then check.
However you believe it's appropriate. So another matter for the board to consider at this time is the assessment of the costs of the hearing. I think following the precedent of earlier today, when a contestee was allowed to make a correction, the contestee was assessed the costs. Is there a motion of the board regarding the costs? Dr. Malden?
So,
Would you, can you state your motion?
that the contestee will pay the cost.
Very well. So your motion is that the contestee be assessed the cost of the hearing?
Yes.
Is there a second?
I'll second that.
Mr. Dunn, will you please call the roll?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
By a vote of 3 ayes, 0 nay, the contestee will be assessed the costs of the hearing. And just a quick announcement based on this finding, the State Election Board will not be making Mr. Wheeler's declaration of candidacy or address information public. We are required by law to keep these confidential under 26 OS 4-115.2 and the relevant administrative code as well. So with that concludes this matter. Thank you very
Mr.
much.
Secretary,
Yes.
can you correct your announcement to make sure that was 114.2? Is it 4-115?
What, 4-115.2, Title 26, yes.
Thank you.
Thank you.
We will be excused.
Yeah, oh, yes, thank you very much. That concludes this matter. I appreciate it. And
Thank you, everybody.
I know the hour's late. Sorry, we're.
I appreciate you all.
Thank you. Next up will be cause number 2022-09, Roe v. Huggins. Roe v. Huggins. Good evening, everyone. I appreciate everyone's patience at this late hour. It is now 10 p.m. and so we are going into, if my math is correct, hour 13 of the Contest of Candidacy hearing. So we appreciate everyone bearing with us. The matter before us now is cause number 2022-09, Roe v. Huggins. This is regarding State Representative District 42, and at this time, I would recognize Matthew Fleece, counsel for the petitioner, for opening statement. Please keep that to about 2 minutes or so, and just, if you don't mind, give the board a broad overview. You can be a little specific if you want to about the arguments you'll make in terms of your case today.
Matthew Fleece on behalf of the petitioner, Representative Cindy Rowe. And the basic issues we'll address today are residency of the contestee, and I believe we'll address that with 3 Supreme Court cases and a statute that is very instructive and right on point. The Supreme Court in 3 cases stated what residency was. One of them is the Box case, which I'm sure the contestee will argue that this present matter is distinguishable, and in the Box case they said each case is to be decided on the facts. And we believe we had overwhelming evidence that would show the facts in this case is that the contestee did not reside at the alleged address as of December 31st, 2021. Also, we'll get into a couple other cases that talk about the definition of abode and residency, and those cases are all linked together. Actually referenced, the Johnson case is referenced in the Box case, and then also again, we'll focus on Title 14, Section 108.
Very well, and may I ask you, do you have a number of exhibits to enter?
I have the exhibits that were attached to the petition.
And those will need to be entered at the appropriate time.
Yes, I'd like to.
So there will be a number that you intend to admit this evening.
And I would like to do that when the witness who is responsible for that report
Very well.
is on scene.
Ms. Klutz, you're recognized for the, did I pronounce your name correctly? You did. I just want to make sure. You're recognized. If you don't mind, once again, state your name for the record, and then you have a couple of minutes. Thank you.
Sarah Klutz for the respondent or contestee. It's spelled C-L-U-T-T-S. I intend to be entirely brief. We've all been here a very long time. I don't think that we have a significant disagreement here on the controlling case law and what this board is required to look at in terms of determining residency. This is a very, in our opinion, simple residency discussion, which you've heard plenty about today. It is your obligation to look at the question of what my client's intent was with regard to establishing a new domicile within the District 42, and he needed to be registered by December 31st. What Mr. Fleece did not raise, and which I think is important for this board to recognize, is a little bit different than some of the cases that we've dealt with today. Is today we're also dealing with a redistricting issue, and my client having to relocate and choose a new domicile because his previous residence was kicked out of District 42 by the redistricting. And so we'll go into the facts of that for you, but I think that this is an important distinction to pay attention to, is that but for redistricting, we would not be here dealing with this issue today. So with that, I'll go ahead and
Ms. Klutz, you have a number of exhibits to enter as well.
I do. I have a booklet that I made, probably enough copies for everybody in here that I'm happy to hand out.
Have opposing counsel consulted on each other's proposed exhibits?
We haven't stipulated.
We haven't stipulated anything. The only objection I would have was the statement at the end of the petition, but the witness is here, so I don't think that'll be necessary.
So in order, just in the interest of time, would it be possible to go ahead and have both attorneys stipulate the opposite attorney's exhibits?
I have no problem.
And have those entered as evidence? Well, if you don't mind, before we move forward, let's go ahead and bring copies of those to our counsel. Do you have additional copies?
Mine are the ones that are attached to the petition, and I thought everybody had a copy of the petition they attached.
We do, but we'll need an official copy. If you can come forward and show me in my notebook which ones they are, I'll turn those over to the counsel to be the official record. Is it beginning with the declaration? Okay. Where is it marked? I don't think mine is marked.
The copies will have off, if I remember right.
Okay. None of these appear to be marked. So what is your very first copy?
Very first copy of
Do you mind just looking? Are you sure? Okay, go ahead.
Copies of these. I think these are marked.
Okay, well, let's go ahead and make an official copy then. Why don't you make 2 official copies very quickly? Okay. Thank you.
And we're gonna start numbering. That's how you want to break it down.
Well, we're gonna start,
Okay.
and then we'll do the petitioners.
Just so both parties know, because of the way the contestees' exhibits are organized in numerical order, and they're bound, we're going to start with exhibit number 1 being contestees number 1, and then we'll come to the petitioners following beginning at 16.
Sounds good.
And while we're waiting for the copies, Mr. Fleece, I think earlier, very much earlier today, you said you intended to call 2 witnesses?
Yes, and I would like to call the contestee as a witness. Miss Rose will be like 10 seconds.
Okay.
I mean, it is like very narrow ground.
So the first is your client, and
the second would be
okay. So and what about your 2 witnesses?
We intend only to question my client and Mr. Fleece's second witness. I mean, if you're calling Mr.
Yeah, Mr. Ramming.
Ramming,
Okay.
yes.
Very well.
In the interest of time, if we could, I would suggest that I go ahead and be able to address my case in chief in cross with my client rather than
Would you have an
calling.
objection to that at the time he's called?
Well, the pattern of the day has been that the petitioner has been able to call the contestee as a witness. I would like to follow the pattern of the day.
Well, I don't. I just mean rather than having to call him again in my case in chief.
Oh, yeah.
I think
No. I thought you said you wanted to do your direct first.
For interest of time, I don't want to have to recall him later.
I think without objection, that would be fine to go ahead and address your case when he's already on the stand. That was your intention, correct? Thank you.
The original back.
Thank you.
Here come the copies. Mr. Fleece, if you'd like, you may begin your case.
There's the first one.
I'd like to call Representative Cindy Rowe as my first witness.
Representative Rowe. Would you please stand and raise your right hand? Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
The witness is sworn. Your witness, sir.
Ms. Rowe, are you familiar with Title 14, Section 108?
Yes, sir.
Could you please read that into the record?
Okay, Oklahoma State Statutes, Title 14, Section 108. To file as a candidate for the House of Representatives in any House district, a person must have been a registered voter in such district and a resident residing within such district for the 6-month period immediately preceding the first day of filing period prescribed by law. Except, however, to file as a candidate for the House of Representatives in any House district in 2022, a person must have been a registered voter and a resident residing in such district no later than December 31st, 2021. Any member of the House of Representatives whose district has changed by redistricting may change residence with the intent of becoming qualified to seek re-election in such district in the first election applicable to such district following redistricting without thereby being deemed to have vacated his or her existing office.
And are you familiar with that particular statute?
Yes, sir.
Did you vote on that as a bill?
I did.
Okay. I have nothing further for this witness.
Thank you. Ms. Klutz, your
Yes,
witness.
thank you.
Representative Rowe, thank you for reading that into the record for us. To be clear, I want to make sure that I understood your testimony. You, in fact, were part of the subcommittee in your district that had participation in determining the new district lines and helping the legislature come to the new districting lines that were ultimately signed into law by the governor, correct?
Yes, ma'am.
Okay. And so you were intimately aware of what the new lines were going to be presented to the governor at the time that you voted on that, correct?
Yes, ma'am.
Okay. And so were you aware at that time that Mr. Huggins had in fact already filed in September for House District 42?
I was, but I did not know what his address was at the time.
Okay. When is it that you determined what his address was?
Kind of after the redistricting lines came out, I received a text message from someone that told me that he was not in my district.
That he was no longer going to be in your district?
That he was not in the new legislative district.
Okay. Now, is it your understanding as you read this that the traditional requirements for residency and being a registered voter have an exception because of this redistricting in the middle of essentially an election cycle, correct?
I didn't really understand what you were saying. Could you ask it again?
Because we're dealing with redistricting, there's an exception to the traditional rule, correct?
Just this election cycle only.
For 2022?
Yes, ma'am.
Right. And that exception being that as a candidate, my client would need to have been a registered voter by December 31st, 2021, correct?
Yes.
Okay. And to have been determined under state law to be considered a resident of the new District 42, correct?
Yes, it's a resident residing in the new district no later than December 31st.
And residing as determined under state law, is your understanding correct?
Yes.
Okay. And so it's your position that as of that date, you don't believe that he was a resident in the new district?
No, ma'am.
I don't have anything further.
Very well. Do you have additional questions?
I don't know, Mr. Rupp.
Very well. You're excused. Please, you're recognized again.
I'd like to call Mr. Ramming as our second witness.
Very well, sir. Will you please state your name for the record?
Randy Ramming.
And will you spell that?
R-A-N-D-Y-R-A-M-M-I-N-G.
Mr. Ramming, please raise your right hand. Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
The witness is sworn. You may proceed.
Mr. Ramming, do you have in front of you what is labeled as Exhibit D?
Yes, sir.
And I believe council and the board all has a copy of Exhibit D. And can you tell me what this represents, this report?
Council, just one second, please.
Okay, I'm sorry.
That's not going to work. I need to know specifically what document you're talking about.
It should be titled Exhibit D, and it starts off in December of 2021. Is the first.
I don't believe any of these are labeled.
Mr. Police, is this the document that you're referencing?
No, I believe that's Exhibit. So the page right after it would be it's called Photo 1, and it has a photo of the house.
Okay, and so just for clarification, for the record, we have already determined that contesty's packet provided will begin the numbering
16.
system. So this will be 16. Okay.
Yeah, it's a little bit, it's further, I think that's.
Oh, yeah, or up, that way?
No, keep turning further back. Okay, that's it. That's the beginning of 16. And everything after that. And everything after that is all a continuation of 16. May I proceed?
You may proceed.
Mr. Raymond, could you state what may be marked Exhibit D in your package? It would be Exhibit 16. Can you state what this report represents?
It represents the residents of, let's see, 121 North Elm in Pauls Valley, Oklahoma. It's going to show different progressions of a home being under complete renovation from December 10th through, I believe, April the 8th.
And for a better, lack of a better term, you were hired by Representative Rose to basically do some PI work in several regards. And you have a background in law enforcement?
Yes, sir. I was certified in law enforcement in 2006. I'm still currently certified. I was a chief of police in Lindsay for, it's been 4 years ago. I currently am a reserve with the Lindsay Police Department.
And you worked for approximately 16 years?
I've been certified for 16 years with no more than 2 or 3 months lapse in any department.
And what did you do to basically go and inspect this house or to view this house? Do you have different dates here that you visited?
I do have, let's see, on December 10th, it was the first day that I went by the residence. At that time, the interior of the home was stripped down to bare 2x4s. Sorry, I'm looking back on the notes here. Part of the windows had been replaced at this point in time. Part of them were boarded up, still waiting to be replaced. There's photos 1 through 16 are labeled. That is, the first photo you can kind of tell the front windows had been replaced, back windows are still being worked on. But photos 1 through 16 represent, I'm sorry, yes. I believe, it's a top graph blur. I believe it's supposed to be 1 through 11. Represent on the daytime. And again, it'll show you the construction trailers backed up to the door.
And
My photos,
11 through 16 are nighttime?
I believe they're daytime. 1 through 16 is what it says. I believe it's 1 through 11.
Okay.
I have photos 11 through 16 at nighttime. I'd have to flip over.
And counsel and the witness, if you all will be careful not to talk over one another for our court reporter. It's been a long day for all of us. Her least of all, or most of all.
Again, it's just multiple photos. You can tell that the construction's going on. Photo 6 shows the mailbox in front of the residence to be 121 North Elm.
Let's move along to it looks like your third sentence, which would be almost the third paragraph. You have a date of December 13th, 2021. And you say that's photos 22 and 23. And your report states that the residence was still unoccupied, in your opinion.
Yes, as you can tell, again, my photos are black and white here. The renovation trailer is still backed up to the front door. There's nothing covering the windows. You could actually see a floodlight through the back of the house from the front. Those photos are taken from the front. The reflections you're seeing are, well, the reflection of the door obviously my headlights, but the other reflections are the trailer from the renovation.
And if you move on, it says, if you look at your entry on December 16th, those are nighttime photos again. you state that the home remains unoccupied, and that's represented by photos 34 through 36. And you were physically present to take those photos?
Yes.
How long would you stay each time, do you think?
I would stay in the area for 30 to 45 minutes just to check, to see if anybody was coming and going. Again, there appeared to be no electricity on in the residence at this time. And the windows were still uncovered.
I'm going to ask you, I apologize, I'm going to ask you to go back to photo 24.
20 what?
24 on the photos.
Okay.
And what does that represent?
This is taken off of Matt Huggins' personal Facebook page, where he was showing the phone going in on that day.
And do you know the date of photo 24? When he posted that on Facebook?
December 14th.
I'm going to have you progress a little bit further down the list. January 25th of 2022, you have an entry. You said during the daytime hours, construction is still visible within the home. See photos 47 through 49. You were physically present to take those photos?
Yes, and if you look at the photos, I mean, it's obvious that there's, the sawhorses are still up. You can still see that there's no blinds in the windows. And you can see into the home.
Did you ever see Mr. Huggins come and go during any of the times that you were present?
I did not.
And your very last entry, you have the dates of April 1st, 3rd, 6th, and 8th.
On those days, I was able to, I went by at random points in time during the day. The only vehicle I was able to see on any of those days is going to be, I believe it's also the same vehicle that's in photo 50. It's a white, either Chevy or GMC, small to mid-size SUV.
Did you ever see anybody get into that vehicle or drive away in that vehicle?
I did not.
Did you ever see any other family members that you would know that went into the house?
The only people I saw there were obviously, they were working on the house. They were doing some sort of construction work.
And you do know what Mr. Huggins looks like?
Yes.
Did you know what he looked like at this time?
Yes.
I have nothing further for this witness.
Very well, Ms. Klutz.
Thank you.
Mr. Ramey, when were you first contacted by by Representative Rowe to undertake a private investigation related to my client's residence?
I'm going to say on the December 8th or 9th. Or I'm sorry, yes, 8th or 9th. Because on December 10th is when I started
Do you have any experience in the construction industry, Mr. Ramey?
I have.
You do?
Yes, ma'am.
In your opinion, would it be unusual for a home to be renovated prior to somebody moving in to live in that home?
Prior to?
Mm-hmm.
Absolutely.
That would be unusual?
No, it would be. I'm sorry, ask the question.
Sure. Would it be uncommon for a home to not be lived in while it's being remodeled?
No, it would be no.
And you're certainly, if you have construction industry experience, aware that a full remodel can take a certain period of time, correct?
Correct.
Would that potentially be exacerbated by some of the high prices and supply issues that we're currently facing in this environment?
I cannot answer that question.
Okay. How much experience in construction do you have?
I actually own my own construction company for probably 3-4 years.
You have no opinion as to how supply issues, costs of timber, those sort of things might affect the length of a project?
I have not done any construction work in the last year.
Now, think, let's see, photo 52, which you referenced, was a Facebook post made by Mr. Huggins. Let's see, let's go to that one, if you could turn to that for me. Particular reason that you did not screenshot pictures and provide copies of the comments to that photo?
No, ma'am. I just took the screenshot of the photo itself.
Let's do this. Why don't you go ahead? You don't mind, may I approach the witness to get
You may.
If you wouldn't mind turning to what has been listed as Contestee's Exhibit 15 for me. Let me know when you're there, just in general 15, not a specific picture. Let's see, in a couple different places in your report, you actually do reference my client's Facebook postings, correct?
Yes.
Okay. Did you, in any of the pictures that you included, take screenshots of any of the comments that were made on those postings?
I'm going to have to go back and look. If I did, it was just an overall in general.
Okay, well, for saving time, let's go ahead and see. Can you turn with me to your photo 24? There.
Yes,
this is, I believe you testified, was when it was clear that there was foam being put into the remodel, correct? Okay. And you testified, I believe, though your picture doesn't show it, that you believe these were made on December 14th?
Yes.
Okay. I'm going to ask you to take a look at the first picture of our Exhibit 15, if you might.
Yes.
Do those appear to be the same pictures that are included as your photos? 24, 25, 26, it looks like all the way through?
Yes.
Okay. Now, if you look at the second page, you'll agree with me that we're showing the comments that are made on that posting, correct? Would you mind reading for the record the comments that are made on the second page?
I want to see the finished product.
Okay.
121 North End.
Who made that comment?
That would be Mr. Huggins.
Okay. Please continue.
Jessica Marlowe, I believe what it says. What's going on here? Is this a flip project or a pet project? Mr. Huggins replied, "We are moving, long story." Jessica Marlowe says, "Nice. So, I'm sorry, it's kind of blurry.
Let me see if
Are you revamping your own home? This is the best and most fulfilling project." And Matt Huggins said, "I like it."
So you would agree with me, at least the comments represent that Mr. Huggins was telling whoever Ms. Marlowe is that this was a project that he was working on, a home that he was moving into.
It says we're moving, it don't say into, it just says we're moving.
We are moving, long story, correct?
Correct.
Okay. If you will look with me at the next page and let me know if those appear to match some of the pictures that you've also included.
I believe so, yes.
Okay. What is the date on that picture? may be getting a glare. I'll represent to you that my copy shows December 13th, 2021. Does that appear to be correct? Okay. Let's see. If you wouldn't mind reading those comments for the record, please.
Cool, how exciting, new chapter in your lives. God is good. The next one that says, what are you up to now? Headquarters? And Mr. Huggins says, new home. And I can't tell who. It says what? Moving into town? Question mark, question mark.
If you'll flip to the next page and continue reading the comments on that post.
Do you want me to start at the top or where this one finished off?
I think that you can do it where it finished off so we're not repetitive.
Mr. Huggins replied, yep. And April replies with, that looks so different. Can't wait to see the finished product, or see it finished.
And then finally, if you turn, it looks like 2 more pages in. Can you see the date on that particular picture from Mr. Huggins' Facebook page?
December 3rd.
Okay. Can you please go ahead and read what that post states?
Waiting on my house on North Elm and TV. Good work.
Okay. And so this is a picture of what appears to be a post by a Mr. Elber Carabantes. Does that appear correct?
Yes, which I believe to be the construction worker.
Okay. And showing some of the windows that had been installed correctly. Now, do you have any personal knowledge that Mr. Huggins didn't have any physical work or participation in the remodel of this project?
Are you asking if I know he did it himself? Or?
Do you have any personal knowledge one way or another?
No, ma'am.
Okay. Did you do anything to determine who owned the smaller white GMC SUV you referenced in your report?
I did not.
Would you have any reason to dispute if in fact it is owned by Mr. Huggins?
I would not.
Okay. Would it be unusual for you to not know the comings and goings at all times of this property?
At all times? No, I wouldn't know.
And it certainly wouldn't be unusual for the lights to be turned off in the evening, even if the property is being remodeled, correct?
Correct.
And so you don't have any actual knowledge of whether or not there was electric utilities at the property while it was being remodeled, correct?
Correct.
And so these are observations that you have made solely based at the request of Representative Rowe, correct?
Yes.
Over a period of different dates showing the outside of the construction project.
Correct.
That could very well be for the remodel of an individual who's moving into that residence, correct?
An unoccupied remodel.
At that time?
Yes.
Okay. I don't have anything further.
Thank you. Very quickly, please.
Mr. Ramey, did any of the photos that council showed you depict someone already moved in to the house?
No.
Did the comments ever say moved, as in past tense, moved in?
No.
Did they say moving in?
No.
Or did they say moving in or moved in?
I don't recall them ever saying one way or the other.
Or did they just say the word moving?
It says we are moving, I'm sorry. Long story.
And council said these photos were of the outside of the project. Are some of these photos actually of the interior of the project?
Yes.
Okay. In any of these photos, do you see any sleeping quarters?
No.
Do you see a bed in any of these photos?
No.
Do you see anything such as furnishings that would depict that somebody was living in this residence?
No.
And nothing further for this witness.
Ms. Klutz, do you have additional questions?
I do.
Members of the board, do you have questions for the witness?
I do.
Yes, ma'am. Go ahead, Ms. Klein.
Mr. Ramey, in your testimony, looking at your report, you indicate on January 17, 2022, that during the day uncovered windows in the home clearly show that there's no activity within the home, and you reference photos 39 through 46. Do you recall that statement in your report?
I've seen it just now, yes.
What do you mean by uncovered windows?
Just open windows, no blinds, no panes, where you could see from the road into the interior of the home.
Were there actual windows installed in the home?
In the front of the home from the roadway that I could see, yes.
When were the windows installed in the home on your timeline?
When I first got there, if you look at photo 1, the front half of the windows were installed on the front.
So from the very beginning?
From day 1. Yes, ma'am.
I have no further questions.
Very well. Counsel?
No questions.
You're dismissed. You
can just leave that at the
You'll
witness
leave
table
it
for now.
yes. Thank you. Mr. Fleece?
Yes, I'd like to call Mr. Huggins as our next witness.
Mr. Huggins, would you please go to the witness table?
Yes, sir.
And then please state your name for the record and spell it.
Do I raise my hand?
Go ahead and state your name for the record and spell
Okay,
it.
my name is Matthew Huggins.
And spell your last name.
Huggans.
Very well. Please raise your right hand. Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
The witness is sworn.
Mr. Huggins, if you will please look at Exhibit 1 in the packet that your counsel has provided. And is this a warranty deed for the 121 North Elm location?
Yes, sir.
And when did you purchase this home?
It was around July 20th is what this looks like. I don't remember exactly the date.
So the deed would represent July 20th of 2021?
Yes, sir.
And the purchase price was $30,000?
Yes, sir.
If you look at exhibit number 5,
Yes, sir.
is that your declaration of candidacy or part of it?
Number 5, no, that's my wife's.
So that's your wife's voter registration?
Yes.
And what date did she sign that?
The 9th of November.
And what address did she list?
121 North Elm Street.
Okay. You'll turn to exhibit 14.
Yes, sir.
Is that your declaration of candidacy?
Yes, sir.
And what is the date of that document?
It doesn't have a date.
Does it have a date next to your signature at the bottom? In section 8?
April 12th, 2022.
And what does box, if you look at the top, which says state representative, and it has check boxes, yes or no, what does number 2, what does that box state or ask?
It says yes.
What does the question ask?
Have you been a registered voter in the district and residents residing within such district no later than December 31st, 2021?
And is your testimony today that you were actually residing at the 121 North Elm house as of December 31st?
An objection calls for a legal conclusion as to what state law says is residing.
Counsel? On advice of counsel, we'll overrule and allow the question.
Okay, ask the question again, please.
Were you living at 121 North Elm as of December 31st, 2021?
My intent was to live there, yes, sir.
Were you actually residing, were you living there?
My intent was to live there.
Were you sleeping there?
No.
You weren't waking up in the morning and fixing breakfast or coffee at that location?
You're talking about in December?
December 31st, 2021?
No, sir, I was not.
Were you still residing at the 35,000 address? I don't know if I have the address exactly correct, but the house that's on East 1600 Road?
That's, at particular times, that's where I was sleeping, yes.
As of December 31st, 2021, where were you mainly living? Wake up, have breakfast, come home?
35,000 East County Road, 1600, where I had been for 18 years in District 42.
Okay.
For 18 years in that district.
Your wife's voter registration was changed in November. Is that also when you changed yours?
Yes, sir.
Is there any reason that you did not change your voter registration when you purchased the house at 121 North Elm?
Yes, because at that particular time, sir, I was still in District 42. They hadn't changed anything at all. That's where I was registered, and that was it. I wasn't planning on doing anything except already running for office, which I started in September. I filed with the Ethics Committee and did so. Then they changed the redistricting when the governor signed it on the 22nd of November.
Will you look at exhibit number 3, please, in that same package?
Yes, sir.
And I believe the third line down is the address.
Yes, sir.
And does that state that 35,000?
East County Road, 1600, yes, sir.
And the date of that is I apologize. The date you submitted this document was September 3rd of 2021?
Yes, sir. District 42.
Did you ever amend that ethics filing?
Yes, sir, I did.
And when did you amend that?
Sometime in January, I think it was the 25th.
And you amended that to the 121 North Elm?
Yes, sir.
But that was after December 31st, that amendment was
Yes,
made?
sir. I had talked with Darcy at the ethics, and she said I could do it at any time. It wasn't a big issue.
Did you attend an Oklahoma 2A meeting at H&H Gun Range on March 15th?
I don't know if that was the correct date, but I have been there, yes.
Do you remember making a statement about the redistricting?
I might have made some comments about that, yes, sir.
Do you remember stating that you, after the redistricting, it was okay because you owned another house in the new district?
I don't remember saying any of that, but if it's recorded, I'm sure I did.
Okay.
I can't recall exactly every word that I said.
I trust you. I'm not going to play it for you, so you said that you may have said that.
I might have said that. I don't remember everything about it. I've said a lot of things for quite a while now.
So at that time, you still owned both houses?
I still own both houses.
Okay.
Even now.
You're attempting to sell the 35,000?
Yes, sir.
East County Road. And when did you change your mailing address?
I have not changed my mailing address because I'm not required to change my mailing address.
So what? Oh, I'm sorry.
I'm not required to do that just for residency.
What is your current mailing address?
I have 3 of them.
What are those 3?
121 North Elm is where I reside right now. That's one. I have a P.O. box because I have a business. And then because of my East County Road, my prior residence, I have that also. I have things that still arrive there because I have a warehouse there that I have product and stuff in to run my business.
Do you have a copy of your current driver's license?
No, sir, I do not.
You didn't bring it with you?
No, sir, I did not.
Do you have the app where it has your driver's license on your phone?
No, sir, I don't.
Did you drive here today?
My wife did.
Okay. What does your address say on your current driver's license?
I'm not exactly sure. Probably my old residence. I don't know for sure.
So you don't remember going to DPS or tagging?
I don't remember. No, sir, I do not.
Okay.
It probably does say 35,000 East County Road 1600, more than likely.
I have nothing further for this witness.
Very well, thank you. Ms. Klutz?
Thank you.
Mr. Huggins, we heard testimony and we saw the deed regarding the purchase of the 121 North Elm Street property, correct?
Yes, ma'am.
And then council showed you what has been marked as our Exhibit 2, which was your, well, actually, I think we showed you 3. Let's look at Exhibit 2 just to make sure the record is clear, please. Can you please, for the record, describe the document that you're looking at?
You're talking about the Oklahoma Ethics Commission, the guardian for ethics?
Right. What exactly do you understand that document to be?
It gives me a report on when I filed with the Ethics Commission for candidacy. Or at least it's a part of me running for office.
Those are, you're required to file these at some point in time,
Yes, there's a
correct?
requirement. If I have over $1,000, I don't have to really file until there's at least $1,000 donated. But I wanted to get on it right away, so I did that.
Okay. And then I guess number 3 is the full page of that filing, correct?
Yes, ma'am.
Okay. And now, can you explain for us, you stated that this is about the time that you started your campaign, correct?
In September, yes, ma'am. We did start in August. We had different meetings with people when I was telling them I was going to be running for that position. We had meetings in August, but then I filed in, and then, yes, I have had other meetings in September.
Okay. And what district was this specifically for?
42,
How long have you been in District 42?
since 2003.
Now, we've heard some testimony that when did you first learn that it was likely that your previous residence was going to be moved out of the district?
Now, I'm not exactly sure on dates, but around the first part of October, we started hearing about the redistricting and that it might do something concerning the boundaries. That's when I first started to hear it. So,
When, if you can recall generally or specifically, did you learn that in fact that was going to occur with regard to your former residence?
we had looked online at one of the persons that had the new district maps on, and it was around the first part of November. I can't remember exactly the day that we had talked about that, but we saw that the new districting was basically going to kick my old residents out of the district that I had already registered to run in with the ethics committee. And now I just kicked everything out, and I had already spent money on going door to door, all kinds of stuff. I had bought push cards, all kinds of stuff.
Now, when you say we discussed, who are you talking about you discussed this issue of redistricting with?
My wife was one, and there's a bunch of other people involved that support me, that I had told them that I was running. There's a group of at least 3 or 4 other ladies that we basically, they helped start the campaign, forming a strategy on how we were going to try and do our best to reach the people.
Now, without getting into specific statements made by somebody other than yourself, can you describe for us generally what your discussions with your wife were with regard to your intents to continue running in District 42?
She was all in when we first started. She was like, if that's something you feel led to do, let's do it. And then as soon as we started hearing how, I got a phone call from somebody who had found out that it pushed my old residents out of the district. The next day, my wife and I were sitting down, and she goes, let's do it. Let's move into the district and do that house. And because we've already done the whole paperwork of being in the district, we've been in it for 18 years, she goes, let's do it.
Now, you could have, I suppose at that point in time, your old residents would have been kicked into what district would it have been then after redistricting?
Well, what it is, my old residence is now in District 48.
Okay. Why didn't you run for District 48?
Because I have I had already started in District 42. I'd already spent money on a campaign. I'd already bought push cards. I already bought banners. There's some pictures in here on banners and stuff like that. The representation that had been my representation for years, that's where I had the difference. That's what I wanted to do. I wanted to run against somebody that I felt did not represent me for we the people.
Okay. And so upon determining that you wanted to stay within District 42 as the new lines, what actions did you then take to make sure that you could comply in order to do that?
Well, we were going to do a simple rebuttal, but my wife said, no, we're not. If we're going to move and live there, we're going to do it the way I want this house to look. So we started a major renovation. We had to take everything down to the studs, everything, because the former resident had a bunch of dogs and it totally annihilated this house.
Okay.
So we took it to the studs and redid the whole thing.
If you can look with me at our Exhibit 8, please.
Yes, ma'am.
Can you describe for the panel what they're seeing as they look through these pictures?
Well, the first picture is basically we redid the headers up in the front kitchen area and the dining room and then the living room. We're holding up the structure. Basically, the old framing was atrocious, so I just had them redo the whole thing.
At this time, was there electricity being fed to this property?
Yeah, there's always been construction power there. Has always been power there. It's called temporary power. I work construction for a living, so this is what we call it.
And during this remodel process, were you physically there to assist with the work?
If I wasn't at some sort of meeting for my campaign, I was there every day.
If you look at Exhibit 9 with me, can you tell us about what time period these pictures are showing for the remodel?
November, I would say. I'm not exactly sure, there's no dates on here.
And these are pictures that came from your cell phone, correct?
Yes, ma'am, should be on Facebook too, I think.
And then if you look with me at Exhibit 10, what phase of the project is this?
Basically, that is putting the floor in.
Okay. For Exhibits 8, 9, and 10, would it be appropriate for you and your family, your wife, to be living day to day, waking up, having coffee in this residence in the condition that's in this place?
No, ma'am.
When did you actually start staying on a consistent basis at the 121 North Elm property?
Can I explain something just a little bit before that?
Please.
Okay. My wife's mom's been really sick. She caught like a pneumonia and COVID and had all kinds of problems. So a lot of the time, my wife wasn't around. But when we got to this particular space where it was enough flooring in and everything else, even though there were some things that weren't finished, I moved in and it was in the middle of February.
What wasn't finished at that point in time?
The countertops weren't in. And that's basically it. But it was right in the middle of February.
Okay.
I didn't have any blinds up, but that's when I decided to do so, right during the middle to the end of February.
What, if any, personal property did you move into the house with you at that point in time?
When I decided to do that, I had brought my TVs in, I had my couches in, and my beds.
Okay, if you look with me at Exhibit 11, please. Can you describe for us what we're looking at in these pictures?
Basically, that's finished product. Kitchen, that's everything we're done.
Would it be fair to say that this is approximately the time that you began staying consistently at the property?
Yes, ma'am.
During that period of time, did your wife have occasion to stay with you at the property?
And just like I had stated before, because of her mother being ill, I hardly spent any time with her at all, even at my other residence.
when did you both take up full residence in the property?
When we both were there, I would say right at the end of February.
If you look with me at Exhibit 12, please. Is it fair to say that that is the property upon completion of the remodel?
Yes, ma'am.
If you look at the second page, is any of this property the same property that you moved into it in February of 2022?
Any of it?
Mm-hmm.
Yes, most of it.
Okay, can you describe for us which property was there in February of 2022?
What property? I don't know.
The personal property, couches, TVs,
Yeah, you got a couple
toys.
couches there and TVs, and I had 2 beds, and then I had my washer and dryer, which is in another room you can't see. It's not here on these papers. I didn't take a picture. And the reason why I know it was around the middle of February or end of February, and I wasn't sure because I wasn't thinking of taking any notes on this. I had no idea this was going to happen. I started working out with a friend of mine, and every time I renew it, it's on the 15th of February. It's on the 15th of the month. Well, that's when I started 2 months ago.
And as you sit here before the board today, you understand you're under oath,
Yes, ma'am.
and it's your testimony that prior to December 31st, you changed your voting registration, correct?
Yes, ma'am.
To meet the new district of 42.
Yes, ma'am. Can I make a little point about that?
Oh, sir, just answer the question.
Oh, I'm sorry. Okay, I haven't done this before, so I'm sorry.
Your wife changed her voter registration as well, correct?
Yes, ma'am.
And is it your testimony that you had the intent to reside in the district, in new District 42, to change your domicile and to remain there permanently?
Yes, ma'am, absolutely.
Okay. And you took steps to actually make sure that that came to fruition, correct?
Yes, ma'am, I did.
Did you move that project as quickly as you thought that you could?
Yes, ma'am.
And it's your intent at this point in time to continue residing in that home?
Yes, ma'am.
I don't have anything.
Thank you. Please.
Yes, sir. Mr. Huggins, if you'll turn to Exhibit 8.
8?
Yes.
Yes, sir.
I mean, this is a pretty serious renovation, I suppose.
Yes.
Down to the studs. Looks like new electrical,
Everything.
new HVAC,
Everything.
new plumbing.
Plumbing, I didn't redo all the plumbing. I did fix most of it, but I didn't redo the whole thing.
Are you an electrical contractor by
I'm an
trade?
electrical contractor, yes, sir.
Can you tell me why you did not pull permits for this location?
Because I didn't realize that I had to really, since it was my own place, I didn't think that I had to.
Are you a licensed plumber?
I had a plumber, but I didn't do my own plumbing.
Did the plumber pull a permit?
No, when it comes to small issues, you don't have to pull a permit. He didn't do a major renovation.
What about the HVAC?
No, sir.
No, sir, you didn't pull a permit?
No, sir.
I have nothing further for this witness.
Ms. Clark, do you have additional questions? Very well. Mr. Fleece, do you have additional witnesses or evidence to present?
No more witnesses or evidence. I just have a closing argument with some statement of the law.
Oh, I apologize.
Long day.
It has been a long day and a long night. Ms. Klein, you're recognized for questions. I apologize. Thank you.
Sir, when you purchased this house that you renovated
Yes, ma'am.
in July of 2021, what was your intent with that home purchase?
Well, my wife and I had talked about, we have a son who's going through some difficult times and we were going to help him with it.
And at what point in time did you change your mind and decide that you and your wife would reside in this home?
Like I had stated earlier, it was either at the end of October when we heard about the redistricting or the first part of November.
You said several times in your Facebook post that it was a long story. What was the long story in shortened version?
Okay, thank you. The long story of it was I had been running for office already. I'd already filed. I'd already spent time and effort going door to door, and then finding out that the person I was running against is on the committee that does redistricting, and changed it, and my house was out of the district now. That's what the long story is. So now I was forced into doing something about it that I'd already spent time and effort running in the district before this happened.
Thank you. Thank you.
Yes, ma'am. Are there other board members who have questions of the witness? No. Counsel?
No questions.
You rest your case?
Rest.
Mr. Felice? Do you have additional evidence or witnesses to present?
No, Mr. Secretary.
You're recognized for closing argument, Mr. Felice.
As the board already well knows, I'm
Mr.
sure.
Secretary, I'm sorry for interrupting, Mr. Please. I think Mr. Huggins, if you would like
Oh,
to sit
Mr.
on
Huggins,
his
you're
counsel.
dismissed. I'm sorry. I made that mistake earlier. I apologize.
I'm sorry. Thank you.
And then also before I interrupt, since we're here, I have that you admitted one exhibit. Is that accurate? Exhibit number, I believe, 16, or yes, 16. That is the packet
That
with
is the
the
packet.
report and the pictures.
That's correct, because the other exhibits I had were duplicates.
Okay, just to verify.
Thank you. You may proceed. Sorry.
Please, the board. I'm sure the board is well aware of Title 14, Section 108. It's probably been covered ad nauseum today, but I think it's very important. The sentence that is on point is, says a person must have been a registered voter and a resident residing in such district no later than December 31st, 2021. It says residing in such district. The contestee admitted. He said we fully, I believe the word was full residence, was taken up to end of February. So by his own words, he's admitted that they did not reside there as of December 31st. And if you look at the Box case, it is instructive. And in that case, Urban Box was running for House of Representatives, and there was evidence in that case that said he lived in the House 50 to 60% of the time. So that case is distinguishable. It's a Supreme Court case. The case actually referenced, so the Box court referenced the Johnson case, which was a previous Supreme Court case. And in the Johnson case, why that case is important, the court held that the word reside, so they got into the definition of reside. Reside in regards to qualifications of electors means to be in residence, one's place of abode. So it's a very important case. The Box case also said that these decisions are fact-based. They're based on each particular facts of each case. And I think there's been overwhelming facts entered into evidence today that the contestee did not reside at this residence as of December 31st, 2021. And that statute is very specific. It doesn't say the intent, it doesn't say when you plan to move in, it says that you had to have resided there by December 31st of 2021. And lastly, you had the Matthews case, which is Matthews versus State Election Board. And the court held in that case, it's a 1978 Supreme Court case, and the court held that it's up to the legislature to impose reasonable durational residency requirements upon candidates. This isn't a durational residency, it's a specific residency. It's December 31st, 2021. So I think the statute's clear, the Supreme Court cases are clear, and the contestee does not meet the residency requirements.
Thank you, sir. Ms. Klutz, you're recognized.
Yes, briefly, thank you. Please the board. I think that council has rightfully directed us to the Box case, which has been since 1974 the controlling case. This panel is to look for to determining what we mean when we're talking about residing and residence. The legislature very well could have defined that term for us, but it has not done so to date. Maybe it would be helpful if it would do so, but for this timing, we have to look to the case law. Sure, there may be some cases that distinguish facts, because this is a factual question. You have to look at the facts and circumstances for each case to determine whether the candidate meets the residence requirement. And in fact, in the Box case, in quoting Johnson, it states very clearly There can be no absolute criterion by which to determine where a person actually resides. Each case must depend on its particular fact or circumstances. While bodily presence ordinarily is essential in affecting a domicile in the first instance, the most important factor being the intent to establish a new domicile coupled with acts evincing such intent. This case is almost exactly like the Box case. In the 6-month period leading up to his candidacy file, Mr. Box, then candidate, moved into the location. He couldn't do so immediately because he had to remodel the residence that he initially leased with an option to purchase that residence. He eventually did purchase that residence, but not until only a couple months before the candidacy filing. It states within the case that he updated his voter registration within that time. The same is the case for Mr. Huggins. Different than Box is Mr. Huggins' wife also updated her voter registration to match the house that they had bought and that they were intending to live in so that they would remain within what was District 42 so he could continue to run there. He took extensive amount of personal assets and time to make sure that he could move his family into this home in a condition where they could continue living there. He has taken step by step to do everything he could to try and comply with the 1 month, 1 week restriction that was imposed upon him once that redistricting was signed. To be clear, but for redistricting, my client would not have needed to determine a new residence and jump through all these hoops to be able to do that. He intended to run for District 42 for very specific reasons that he testified to. That didn't change. What changed was the lines of the district, and he had a very little amount of time to try and make sure that he complied with the letter of the law as understood by the case law and as understood by the statutes. Again, this is a redistricting issue that was of no fault of his own, and he's done everything he can to try and make sure that he is complying with that statute that says that he had to do these things within a 1 month, 1 week time period. He acted even before that was taken care of. I don't think we have anything further, unless you have any questions.
We're good. Thank you, Counselor. And again, thank you to both parties. The hour is late, and we really appreciate everyone's patience today. At this time, I recognize legal counsel of the board to address any legal matters for the board to consider.
Board members, I'd like to remind you of the requirements of Title 14, Section 108, Qualifications of Candidates for House of Representatives. Quote, to file as a candidate for the House of Representatives in any House district, a person must have been a registered voter in such district and a resident residing within such district for the 6-month period immediately preceding the first day of the filing period prescribed by law, except, however, to file as a candidate for the House of Representatives in any House district in 2022, a person must have been a registered voter and a resident residing in such district no later than December 31st, 2021. I'll remind you again that Box versus State Election Board 526p2 936 held that residency is a subjective intent. It's a question of fact. You should look at facts evidencing the intent for residency. Board members, do you have any questions about these legal authorities? No. Okay. So board members, having heard the testimony of the witnesses here today and receiving the evidence presented, as well as arguments of counsel, and by a greater weight of the evidence, if you find that the petitioner has met her burden, you should move to sustain the petition and strike the contestee as a candidate from the ballot. And the alternative, if you find that the petitioner has not met her burden, you should move to deny the petition and retain the contestee as a candidate on the ballot.
Thank you, Counsel. Are there any questions of counsel? I would entertain a motion at this time.
I move to deny the petition and retain the contestee as a candidate on the ballot.
Ms. Klein has a motion to deny the petition and retain contestee Huggins as a candidate on the ballot. Is there a second? Dr. Malden seconds that motion. Will the clerk call the roll, please?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
By a vote of 3 ayes, 0 nays, the State Election Board has voted to deny the petition and retain contestee Huggins as a candidate on the ballot. And that concludes the matter of cause number 2022-09.
May we be excused?
Thank you. You're excused.
Thank you, everyone.
Thank you.
At this time, in just a moment, if the board would like, we can take about a 10-minute break and give time for the court reporter to rest her hands for a few minutes and for everyone else to take a short break. We do have 2 more contests to consider, and the next one that we will consider is number 2022-11, Phillips v. Mai, but at this time I would entertain a motion for a 10-minute recess. Mr. Montgomery makes a motion for a 10-minute recess. Is there a second? Dr. Malden, please call the roll.
Mr. Montgomery.
Aye.
Dr. Malden. Ms. Klein.
Aye.
By a vote of 3-0, the State Election Board is in recess until 11:23.
Board members.
Welcome back. This is the State Election Board. We are now, we now need a motion to reconvene, please.
I'll do a motion.
We have a motion from Mr. Montgomery,
Second.
a second from Ms. Klein. Mr. Dunn, please call the roll.
Mr. Montgomery.
Here.
Dr. Malden.
Aye.
Ms. Klein.
Present.
The State Election Board is now back in session, and at this time, we will take up consideration of cause number 2022-11, Phillips v. Mai. This is for District Judge, District 7, Office Number 5, and at this time, Mr. Phillips, I'd recognize you for a brief opening statement. If you can, just give the board about a 2 to 3 minute overview of your case.
Mr. Secretary, I can do that. I'm also willing to waive.
You're okay, if you waive, that's fine. Thank you very much. And at this time, Ms. Norwood, do you have an opening statement?
I do.
Very well. You can just give a brief overview to the board of the case you intend to present.
Sure. Good evening, almost a morning. As you know, my name is Lexi Norwood, and I, along with my co-counsel Denise Lawson, represent Judge Mai. This is not the first time Judge Mai has been here for this exact same challenge. In 2018, Judge Mai's residence was challenged in front of the election board. After a lengthy hearing, the board voted to dismiss the challenge by a unanimous vote. You'll see that the petition filed again this year offers no additional facts, no additional evidence that should change the board's finding 4 years ago. Yes, Judge Mai owns the residence in Cleveland County. To help her mother out financially, she purchased that home that her mother lives in years ago. However, Judge Mai does not reside at that property, same as in 2018. She lives in a condo located in Oklahoma County with her minor daughter and her dog, Bosco, that she has owned and has moved into since 2019. Today you're going to hear from detectives that will confirm the Oklahoma County address of Judge Mai. These detectives are seeking signatures from warrants in which Judge Mai is available to sign at all hours. You will hear from neighbors that walk and feed her dog Bosco if she's working late. There's plenty of proof that Judge Mai lives in Oklahoma County, where she is registered to vote, where she pays bills, where she works, and it's the address on her driver's license. There's absolutely no evidence that she resides otherwise. Most importantly, as this board knows, a candidate is not prohibited from owning 2 houses. The only restriction in that regard is that they reside in the county for which they are running. As you will see, much like in 2018, she continues to reside in Oklahoma County. Thank you.
Thank you very much.
Mr. Secretary,
yes.
I would like to pass out the order from the 2018 Contest of Candidacy hearing.
Very well.
Make an announcement.
Mr. Schneider.
Here you go. Here you go. And I'll prove that. Mr. Phillips, Ms. Norwood, I've handed you a copy of the order that was issued after following the 2018 Contest of Candidacy hearing. It denied the petition from Mr. Sloan and retained the candidacy of Judge Mai. In light of that, and in light of the same address that is in question here as alleged by petitioner, we are asking you to keep to new facts. So with that, we respectfully request you make sure this is new facts. Let's not re-litigate our case from 2018.
Thank you very much, Mr. Schneider. Mr. Phillips, you're recognized to begin your case, sir.
So, ladies and gentlemen, I think before we began, we talked about exhibits, what we were going to propose to turn into the tribunal. We've got an agreement. We're actually going to admit, I think, everything by agreement. I don't know if you want to do that right now before we call witnesses, if that might help.
Yes, we'd like to do that. So both of you are stipulating to the other
Yes.
exhibits.
Yes.
If you have copies to submit to the board and to the council?
I do. How many copies would you like me to?
We need an
One
official.
official copy for the record.
Yeah, for the record, for sure.
One official copy, no copy standing.
And were these attached to your petition?
They were not attached to the petition. They are, in fact, a transcript from the prior hearing, so it almost kind of actually builds upon the work that was just passed
Will
out.
you make sure opposing counsel has a copy if
I
they
do.
don't already? And then
They do
just,
have one.
I don't need one, but if you can provide those to our board.
And the documents that we stipulated for us are all attached to our response.
Very well. Do you have a copy, an official copy or an extra copy that we can use as the edited exhibits?
I think I've already given those. Should be attached to the response.
Is this what you submitted this morning?
Yes, sir.
I'll tell you what I'll let you do, Counselor, if you will approach me, because I believe this is your response. If you will detach whatever the exhibits are, I'll...
And this one would use this copy.
Yeah, use that one. Yeah, there we go. Thank you. Thank you for doing that, though.
No problem.
Speed along Ms. Batt's numbering system. So by agreement of opposing counsel, the exhibits are admitted. They will be numbered by our own counsel at the appropriate time.
Transcript will be exhibit 1.
He's numbering, okay.
And do you just have the one exhibit?
I only have the one exhibit, that's right, yes.
So you will be exhibit number 1.
Okay, you may, are we ready to proceed? You're ready to proceed, sir?
Yes.
Please go.
This time I'll call Natalie Meyer.
You'll go to the witness chair and state your name for the record. Will you please state your name?
Natalie, mine.
And if you don't mind, will you please stand and raise your right hand? Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
The witness is sworn. Mr. Phillips, you may begin.
Ms. Meyer, who are the residents of the property that you own in Cleveland County?
My mother, Hi Tran, and my stepfather, Hung Ho.
Was that Hi, H-I?
H-A-I.
Hi Tran and Hung
Ho, H-O.
Now, Ms. Mai,
Council, let's go ahead and call her Judge Mai.
Okay.
She is duly elected.
my apologies, everybody, and Judge, my apologies on the salutation there. Judge Mai, since you overcame the 2018 challenge and were elected for Oklahoma County District Judge, you have been on the bench for approximately 3 years now, right?
3.5 years.
Okay. Have you sat in a civil docket?
I have.
Have you presided over, just say, cases involving mortgage foreclosures, things like that?
I have.
Okay. So you are well aware of what the legal term homestead means?
I am.
Okay. So in some cases or circumstances, people would have homestead rights to a property they live in, right?
That's correct.
Okay. And you're well aware and familiar with the homestead exemption?
Correct.
Okay. So when we say homestead exemption, we mean quite literally the place in which someone stays, right?
I don't agree with that.
Okay. When the tax commission has you fill out a homestead exemption granting you benefits and tax breaks on property, you are claiming, in fact, that you live at that property, are you not?
I claim that that is my property. I only have one property under my own name, and that is the only property that is eligible for a homestead exemption, of which my banker has advised me that is the one that I can claim on, as well as my accountant.
So with the homestead exemption for the Cleveland County case being an issue in the 2018 contest before the election board, that issue was brought to the forefront, was it not?
There was.
Okay.
And it was adjudicated.
May I approach the witness?
You may.
I'm going to have to object to these documents. As counsel said, that this was litigated in 2018. We will stipulate that, yes, she signed the homestead exemption. She owns the house.
What are the documents you're wishing to have reviewed?
So I would like to refresh her memory on what a homestead exemption requires, because she seems to need refreshing.
I'm sorry for interrupting, but I mean, I've established that we were wanting to hear new evidence, and I don't see this as being new evidence that wasn't covered in the 2018 trial.
Mr. Secretary, you want me to address your question first or his?
Well, why don't you address counsel first?
Okay. So what I would respond to that with is 2018 is past. Her homestead filings from before that hearing date are from before. Her homestead filings from since that date are since then. If she was negligent in her understanding or knowledge of what a homestead exemption was at that point, she was apprised that that was an issue, and she has continued to file the homestead exemption. The fact that the homestead exemption is what it is, a public declaration of residency, is in fact germane to this particular hearing, as she has filed homestead exemptions in every year since 2018. And so it's not a pre-litigated fact, because she has continued to do so. And as we stand here today, I believe she is in fact still, her question just now was that she is still claiming a homestead exemption on that house. So I think it's important to know, and I would like to refresh her memory if possible, if she understands what a homestead exemption is.
There is an objection outstanding. I have a question for Judge Mai. Can you confirm you did testify that you have claimed a homestead exemption on the Cleveland County property?
In 2018, yes.
Do you understand the legal definition of a homestead?
Yes.
Very well. I think with that, I will sustain the objection. She's answered the question.
May I complete the record? But her answer was that a homestead exemption did not require residency, and very clearly on the face of the form itself, it says homestead exemption cannot be approved if you do not own and occupy the subject property. And that's the form that she would have had to fill out.
Object to that as well. It's asked and answered. She filled out the form. We'll stipulate to it.
And at this point, I'm simply asking to refresh the witness's memory.
Well, we have testimony that she has completed the form, claimed the homestead exemption, and understands what that means. So I believe that's on the record.
And it's also irrelevant to show her residence for the last 6 months.
I think if there are any definitional issues you'd like to raise, you can raise those in closing argument.
So, and I know that we had stipulated to exhibits, but I didn't expect her to not know what a homestead exemption entailed. So at this time, I would like to move to admit a copy of an Oklahoma Tax Commission Form 921, which very clearly delineates in the form itself that you must be a resident of the property to declare that. And so if she's going to have an incorrect definition of what a homestead exemption is to complete the record, I would like to just submit the form and make that a piece of evidence.
Counsel's testifying, and I'd like to object to that as well.
Would you have advice for the chair?
I think that since it is a public forum, it is something that the board could appropriately take judicial notice of. So.
This is an Oklahoma Tax Commission form.
It is.
I think the board can take judicial notice of the form.
Okay. So Ms. Mai, are you aware that the Oklahoma Judge Mai, are you aware that the Oklahoma Tax Commission Form 921, the required form to fill out in order to file for a homestead exemption, states on its face, were you occupying this property as your place of residence?
I'm sure that's what it states, if that's what you're reading it as.
Does it also state, under the Part 2 ownership, Section B, homestead exemption cannot be approved if you do not own or occupy the subject property as your place of residence on January 1 each year the exemption is applied?
I own the property.
Own and occupy the subject property.
You said or.
If you do not own and occupy is what the form reads. Do you disagree
I
with that?
spent some nights there with my mother.
May I approach the witness?
You may, yes.
Judge Mai, I'm going to hand you homestead exemption information taken from the Cleveland County webpage. Would you read the highlighted sections for me real quick?
You must be the homeowner.
Oh, I'm sorry. Would you read it to yourself?
Sure. It's not very long, so I've read it.
Okay. Does the public information concerning homestead exemptions notify the person wishing to claim an exemption that you must be the homeowner who resides in the property?
That's what it says.
Okay. I don't want to recover too much, but I believe you already said that you have been claiming the homestead exemption on the Cleveland County property for the past 3 years.
That's correct.
And while tax year 2022 is not concluded yet, did you make any effort to change your homestead filing status before the change of the year?
No.
So you would expect to be granted the homestead exemption for 2022 as well?
I anticipate that would be so.
Judge, my part of your testimony in 2018 was that your mother was kind of instrumental in helping with your child care, respite while you were working. If you had court early in the morning, you'd stay at her house, that you guys were a very close family and that you stayed with her a lot.
That's correct.
Okay. And is that also been correct since you have taken office?
Absolutely.
So there would be, I would presume, many nights where you maintain contact over there?
No. I drop my child off and she stays with grandma while I work. If I have a jury trial that lasts overnight or multiple days, then I do not spend the night there because it's not convenient. I stay at my own house.
Okay, and I'm not trying to catch up on this. You testified that you used to stay over there overnight regularly at the previous hearing. Do you still stay overnight there?
I stay there whenever I feel like it or when my mother is not feeling well.
Do you still own the property on 7th Street that you were registered at?
I do not. That belongs to my ex-husband.
That property was owned under Duo Properties?
That's correct.
And you are still the registered agent for Duo Properties, correct?
It got transferred to him in the divorce. What he did with the paperwork, I don't know.
Concerning your ownership of the Cleveland County property, you said that's the only property you own in your own name?
That's correct.
And it's a very nice place, isn't it?
It is.
appraised is currently for over 800,000.
Objection, relevance.
We'll sustain the objection.
It's a significant asset, is it not?
Objection, same objection.
It's sustained.
Excuse me, I'm sorry.
No problem.
To be clear, Judge Mai, are you buying the house in Cleveland County for your mother, or are you owning it and allowing her to stay in it?
Objection, that was answered in 2018. That's not a new fact. We're in.
We'll overrule, and please answer the question.
The house was built by my parents. They couldn't afford it anymore, so I sold a commercial property that I had and bought it so they can maintain their residence. And have been paying for it since to make sure that my mother has a home to live in.
I would presume that your intent, since you put it in your name, is to retain the property after your parents would no longer need use of it.
I don't know. My parents are still alive. I don't have those plans.
You don't yet have plans to return to the Rivendell property once your tenure as judge is over?
I do not.
Objection, asked and answered.
I believe it's actually a slightly different question.
I will allow the question. Would you please repeat the question for the witness?
Is it not your intent to return to the Rivendell property as your homestead once, or excuse me, as your residency once your tenure as district judge is over?
So I would say my tenure as district judge could be possibly 25 years, and I don't know what happens then, so I can't answer that question for you.
Fair enough. Since the last election cycle, you have deeded that property actually from yourself to yourself because of a name change, correct?
That is correct.
You have mortgaged that property.
That is correct.
You've had, to sum those up, more than one transaction regarding that property.
That's correct.
You have not taken any steps to cancel your homestead exemption if you didn't have to refile for homestead exemption after the deed, correct?
Mr. Phillips, I'm going to advise you to get on track. We need material evidence, relevant evidence as to whether she is a resident of 6 months and whether or not she's been registered for 6 months.
Have you filled out a public declaration that the Cleveland County property is your homestead and residence since the election?
The only thing I recall doing is before the election.
Are you aware that it is in fact Oklahoma law that you notify the county in which you claim a homestead exemption if you cease to qualify for such exemption?
I'm not aware, but I've only filled out one form, so.
Are you aware that the application for homestead exemption is signed under penalty of perjury?
I am.
No further questions.
Thank you. Ms. Norwood, your witness.
Mai, do you work in Oklahoma County?
I do.
What address do you reside at now?
5906 North Pennsylvania, number 216B.
And is that in Oklahoma County?
It is.
How long have you resided there?
Since October of 2019.
Are your personal belongings and effects located at this address?
Absolutely.
Do you consider your mother's home your residence?
No.
Do you have any intention of abandoning your residence at the North Pennsylvania Avenue in the near future?
I do not.
Do you have any neighbors or friends or acquaintances that know about your address?
Absolutely, they're here.
Okay. Can I approach the witness?
You may.
Do you recognize that document?
I do.
This is the 2018 finding and order that is, I guess, Exhibit 2. This is our Exhibit A to our response.
That's accurate.
Could you please read for us paragraph 8 in that document?
Says Ms. Mai indicated.
I'll just object to the cumulative nature. The order is already in the record. It's been distributed by the parties, admitted by agreement into the record. Further reading of the document at this point is simply cumulative.
We'll move on. Could you please look at the second document? It's named Exhibit B in our response.
Yes,
Do you recognize that document?
I do.
What is it?
It's the warranty deed to my condo.
Okay. Does that appear to be a true and correct copy?
That is.
Okay. Did you buy this condo?
I did.
And this is the condo located at 5906 North Pennsylvania Avenue?
That's correct.
Can you tell us the date on that warranty deed?
It's October 4th of 2019.
And when did you move into that condo?
About that. I moved in right after closing.
And you still reside at that condo?
Yes.
Have you ever left that condo?
No.
Do you have any intention to leave the condo?
No.
Could you look at exhibit, I think, D, the HOA?
Ms. Norwood, before you move on, I think that just for the record, the formerly known as Exhibit B is now Exhibit 3. The exhibit you're about to reference, I believe, is Exhibit 4.
Okay, and that's our Exhibit D, I think.
So that'd be 5. It's D5.
Are you looking at the Secretary of State information?
No, it should be right after that, I think. It's an HOA statement.
Okay, we have that as Exhibit 5.
Yeah, I was given.
Oh, that was
Sorry.
Okay.
Exhibit 5.
Yes. Do you recognize this document?
I do.
What is it?
It's an HOA statement for my condo.
Could you please read the to section in the top left corner?
As in the AMD LLC, care of Natalie Mai, 5906 North Pennsylvania Avenue, number 216B, Oklahoma City, Oklahoma 73112.
And what's the date located on that document?
The date is March 2nd, 2021, covering the billing period of January 1st, 2021 to March 2nd of 2021.
And do you pay the HOA dues on that property?
I do, every month.
Okay, and we're gonna move down a little bit to what's gonna be Exhibit 8. So that would be for you. G?
That's correct.
Okay. Do you recognize that document? Exhibit G?
Yes, my voter registration records, is that correct?
Yes.
Okay. Yes,
Are you familiar with that document?
I am.
Is that a true and correct copy of it?
It is.
Can you please read the residence address toward the top of the document?
5906 North Pennsylvania Avenue, number 216B. That's Oklahoma City, Oklahoma 73112.
Okay. Can you turn to the last page of those documents?
Yes.
Is that your signature on the bottom?
Yes.
And what date did you sign this document?
4/6/2021.
And then moving to Exhibit 9, which is H in that packet.
Yes,
Do you recognize this document?
I do.
What is it?
It's my OG&E bill.
Does that appear to be a true and correct copy of it?
It does.
What time period is that statement for?
This is April 2021 to May of 2024.
And what's the service address at the top of the bill?
It is Natalie Mai, 5906 North Pennsylvania Avenue, number 216B.
Okay. And the last document in that group, do you recognize this document?
I do.
What is it?
It's my OG&E bill.
Is that a true and correct copy of your bill?
It is.
What period is the statement for?
This is March 9th, 2022 through April 8th of 2022.
And what's the address on the bill?
5906 North Pennsylvania, number 216B.
I have no further questions.
Thank you, Mr. Phillips. Do you have additional questions of the witness?
I do have one. Judge Meyer, some of the questions you were just asked went through like a utility payment that you make on the condo in Oklahoma County. Do you also pay the utilities for the house in Cleveland County?
I do. It's under my name.
Ms. Norwood, any further questions?
No further questions.
Very well. Thank you, Judge. You're dismissed. Mr. Phillips, do you have additional evidence or witnesses to present?
I do not.
Do you rest?
Yes, sir.
Okay, Ms. Norwood.
I'd like to call Detective Klicka.
Sir, if you'll go to the witness table and state and spell your name for the record, please.
Sure. It's Mike Klicka, that's K-L-I-K-A.
Very well. And will you please raise your right hand? Do you swear or do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
The witness is sworn.
Counselor, if I may, are you going to cover new ground that wasn't covered in the last hearing?
Yes. Detective Klicka, how do you know Judge Mai?
I'm a detective with the Oklahoma City Police Department. She's one of many judges that signed my warrants.
Have you ever been to her residence?
Several times.
And do you recall the address for that residence?
Yes, it was at stated 5906 on North Pennsylvania, Department, condo 216B.
And do you remember the first time you went to that residence?
Oh, I would probably say it's probably 2-3 years ago.
2-3 years ago, okay. Do you remember the last time you went to the residence?
Say it's probably over the Christmas time.
Okay. Thank you. I have no further questions.
Very well. Mr. Phillips?
Detective, you said that you went to her residence to have warrants signed?
Yes.
Okay, let's talk about that process a little bit. Oklahoma County judges, do they rotate an on-call status, or do they just all have phones?
They all have phones.
Okay. And so your role as a detective, when you need a warrant signed after business hours between 9 and 5, you call a judge, correct?
Yes, I'll call a couple different judges routinely, yes.
And if they're available, they answer. If they're not available, they don't, correct?
Correct.
Okay. So if a judge is out of town or at dinner in a noisy restaurant, they may choose not to answer, correct?
Well, on the contrary, actually, I've met judges at restaurants and even at the nail salon, so it's not uncommon for me to meet them at those places as well.
Let me rephrase my question. They choose whether they answer their phone or not, correct?
Correct.
Okay. So if they were in a place that they didn't necessarily want you to see them being, they wouldn't answer, presumably, right?
That's it.
Objection. Relevance.
We're going to overrule and allow the question. Please continue.
Would you try that one more time?
Presumably, if a judge is somewhere that they wouldn't necessarily want to meet you at, they just choose not to answer the phone, correct?
I've never had that experience, but that's possible, I guess.
Well, if they don't answer the phone, we don't know why, correct?
Correct.
Okay. So you would agree with me that it's entirely up to the judge as to whether or not to have contact with you at that time?
That's a fair assumption.
Okay. And so the next step in the process is once you make contact, they tell you if they're actually available in what time frame?
Oh, usually it's right away. It's not if they're at home or wherever they're at, they'll tell me where they're at and I'll meet them.
And right away is like then plus travel time, correct?
Right.
Okay. You don't just show up at a judge's door and then call the cell phone going, hey, guess what, I'm outside, right?
No.
Okay. They would have some lead time to know that you're coming.
If I may, I tell you, I think I know where you're going with this. I work at downtown headquarters. It's about a 15-minute drive to Judge Mai's residence.
Okay. But she would also have the choice not to answer if she wasn't at that residence, correct?
Correct.
Right. Thank you, Detective Pass Witness.
I have no additional questions.
Very well. Does counsel for either party expect to call the detective again?
I do not.
No. You're dismissed. Thank you. You may leave.
Thank you.
I know it's a late evening. Thank you very much for your time tonight. Appreciate it.
And we do have another detective, but he's here to testify for the same thing. So would you guys like to hear that testimony?
Is it duplicative testimony?
It is.
Would the board want to hear additional testimony along the same lines? I think we're good.
Okay, I'd like to call Kristen Pickering.
Ms. Pickering, would you please state your full name and spell it for the record?
Yes. Kristen Pickering, KRISTYNPICKERING.
Would you please raise your right hand? Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
Witness is sworn. Clerk, please proceed.
Ms. Pickering, how do you know Judge Mai?
She's my neighbor.
And what address do you live at?
6008 North Pennsylvania Avenue, 14B.
Okay. And how long have you known Judge Mai?
Since she moved in, so 2019.
2019. Are you familiar with her residence and her being around the area?
Yes, I mean, we are directly across from her, so sounds weird. I can see her leaving, coming home. I would see her walk her dog almost every morning or in the afternoon when she gets off from work.
Do you help Judge Mai when she works late?
Yes. I will go to her house and let her dog out for a walk and feed it whenever she's working.
And how long have you done that for Judge Mai?
A long time. I couldn't tell you. I mean, I don't know. It's been since she's moved there. I mean, I can't tell you the exact month that I've started doing that, but.
Could you narrow it down to a year?
Sure. I mean, at least a year. I mean, I don't know. I really don't. I don't know.
That's fine.
The first time it was.
But it's been quite a while, right? Has
Yes,
it been over
yes,
6
it's-
months?
Yes, absolutely. I just don't know when it started the first time I did it, a couple of years ago, I don't know.
Okay, that's fine. Thank you. That's all the questions I have.
Very well. Mr. Phillips?
No questions.
No questions. The witness is dismissed. Ms. Norwood, you're back up.
Okay, I'd like to call Dave Short, please. Dave.
Sir, if you'll go to the witness table and state and spell your name for the record up here.
State, spelling.
Yeah, up here. Just say and spell your name, please.
David Short, D-A-V-I-D-S-H-O-R-T.
Mr. Short, will you please raise your right hand? Do you swear or affirm upon penalty of perjury to tell the truth, the whole truth, and nothing but the truth?
I do.
The witness is sworn. Please proceed.
Mr. Short, how do you know Judge Mai?
She lives directly across from me and my wife. It's about, our front doors face each other, so about 15 feet.
And what is your address?
I live in 5904 address, number 215B.
Is that on North Pennsylvania Avenue?
Yes, ma'am.
How familiar are you with Judge Mai's coming and going?
Well, I'm retired and I'm up early, and I'll crack my blinds. I'll most of the time see her leave in the morning.
Okay.
And occasionally in the afternoon. I mean, I'm not nosy. I did see a couple of detectives come in one day. I didn't know that really at the time she was a judge. They were, I didn't know who they were or what they were doing, but they were getting warrants signed, I guess.
All right. How long have you known Judge Mai?
Since 2019, about, seems like the first part of 2019, but we moved in there October 2018. So,
All right, thank you.
3 years or so anyway.
Okay, I have no further questions.
Mr. Phillips, do you have questions of the witness?
Very briefly, Mr. Short, I mean, we're all in the same room. Ms. Pickering testified to being right across the doorway from Judge Mai. You don't live with Kristen Pickering, do you?
No, she lives down below
So you're on
the
top.
west buildings over there, and it's she lives really right across from her. She's got a balcony like we do, and she's got a ground floor, but
Okay.
she lives really directly across from her.
And you're on a second story.
I'm on, you call it a second floor, yeah.
Okay.
Yeah, the one below me is 115, and then we're 215B, and the one in front of us is 215A.
You said that you see her leave most mornings, and you see her come back or go somewhere in the afternoon sometimes. Is that what I heard? Okay. Not every day though, right?
Not every day, but most of the time.
Okay.
Or she's out walking her dog.
I didn't ask Miss Pickering, but I really want to know what kind of dog is it?
It's it's like the one you'd see on Little Rascals. I don't know the name of it. He's mean too.
Okay, excellent. Mr. Short, thank you for humoring me. I'll pass the witness, everybody.
Thank you. Ms.
No
Norwood, do you have
further
additional-
questions.
okay.
Thank you.
You're dismissed, sir. Thank you. Ms. Norwood, do you have further witnesses?
No, sir, I rest.
Okay. At this time, and I apologize to the board, I didn't offer you any chance to ask questions, but I assume you would have spoken up if you had questions.
Absolutely.
At this time, I think we will go to closing arguments. Mr. Phillips?
Mr. Secretary, we admitted by recognition the Oklahoma Tax Commission Form 921. Just for the purposes of my closing argument, I'd like to pass out physical examples so that it can actually be seen by the board.
I have no objection to that. Board members, are you okay with this? Yes. Very well. Sure.
ladies and gentlemen of the board and our reporter, I'm not going to move this mic again because it squealed really awfully on me earlier. But if you can't hear me, if I start, getting unaudible, just let me know, okay? Get to my right page. It's really late in the day. I'm going to try to be as quick as I can be. Having watched most of the hearings as best we could from out in the waiting area, I know that you've heard a lot of legal words and phrases throughout the day. And so I'm trying to leave those out. I didn't give an opening statement because I know that you've been recited Section 92I probably 5 times already today. My case is this. Judge Mai is not a legal, actual resident of Oklahoma County. I'm not contesting that she's a registered voter in the county. I'm just simply contesting her actual status as a resident, okay? And so when you look at, the legal jargon that we've been hearing throughout the day, subjective intent, that a candidate's intent is subjective, things like that. And the thing with all of these, phrases that we have, the little snippets from the cases, is that truly a good attorney can argue them both ways. And I expect counsel to make a really great argument opposing everything I say. But when we look at the intent to maintain a dwelling in Oklahoma County or maintain a dwelling in Cleveland County, I think the panel would be remiss not to consider all the facts, including the testimony given in 2018. The transcript is in the record. And while I'm in effect partially asking the panel to reverse the earlier decision, that's not necessarily what you have to do. You've heard cases today kind of going both ways. You've heard cases where judges were accused of moving outside the district. You've heard cases where candidates were accused of moving inside the district simply for the purpose of running. I honestly don't have a particular desire for you to rule in that regards one way or the other. Judge Mai's intent is very clear, and I'll circle back around to that here in a little bit. You've heard things like present place of abode. And when the attorney arguing the case wants you to disregard where the person is currently at this moment living, they will argue the sides of those factors and those pointers to say, hey, it's not the only factor. It cannot be regarded as conclusive. Well, that works for me right now, so I'm going to go ahead and argue that right now. Judge Mai might be spending most of her time right now at a condo in Oklahoma County. But does that mean that she's abandoned home ownership and residency in Cleveland County? Not necessarily. The quote that everybody likes to quote comes from the Moore case. Fun fact of law, if you trace the actual quotation that people like to quote from the Moore case, it actually comes from a 1925 case called Anthus versus Drew. It involved Indian territorial land, passed down to a decedent who passed away. A court made a ruling based upon his alleged residency, and then heirs on each side of the family fought over it years later, and that's how you get that weird piece of law. So we're using a case that started out because of what effectively I would call a probate case is now affecting our arguments as to where candidates live and reside. But the fact that Judge Mai spends most of her time in a condo in Oklahoma City, well, they're both in Oklahoma City actually, in Oklahoma County proper, is not the one end-all be-all argument. You've probably heard the name Suglove more times today than you care to. Suglove is a case about people who moved to Indonesia. Yeah. So Oklahoma County isn't Jakarta. But interestingly enough, some similarities can be drawn between the present case and the Shuglove actual fact pattern. The Shugloves, John and Doreen, they retained ownership of a property in Oklahoma when they moved to Jakarta, Indonesia for work. The Oklahoma Tax Commission, based upon that and some other factors, said, no, you didn't abandon your residency or your domicile in Oklahoma, we're still going to tax you. And so they tried to prove that they did in fact abandon a residence or domicile, and they were unsuccessful. And I've kind of argued that perhaps this again is kind of a loaded argument because the court was trying to, well, I wasn't around when it was decided, but my suggestion to this panel is that the deciding body had an interest in maintaining a residence of somebody who would otherwise move out of the country and we would lose tax dollars. But that's maybe an argument for another day. But upon the factors, or some of the factors in Shuglove was ownership of land. It was the fact that they had come back and stayed there from time to time. I think the fact that the court really weighed very heavily the fact that they had stayed at the property multiple times over the course of a couple of years in between work assignments abroad is a very big similarity to here. And I know that counsel wants me to stay out of the 2018 case, but Judge Mai has returned to that Cleveland County property not simply to meet her mother, but to stay there for extended periods. It's in her name. If she was simply buying a property for her mother to live in, she would have no need to put it in her name. She has mortgaged that property in her name. She has deeded it to herself to take her ex-husband's name off the title before. When I say his name, she had a hyphenated name. It was Mai Dong, and now it's just Mai. But she is the sole owner and has been sole owner of that piece of property, a substantial asset in Oklahoma since 2015. Continuous presence. The cases that talk about domicile and all of the references to actual residence being very similar to domicile, I don't love them for this case, but I really don't love them for any of these candidacy cases because it's hard to get an accurate picture of a judicial candidacy case when we're talking about cases that deal with people moving across the country, out of the country. Very few cases on the books talk about somebody who moved from one side of Yukon to the other side of Yukon. And what we're really talking about is kind of that small of a difference. Both of these pieces of property are in Oklahoma City. And we all know that we have a really big city. The Cleveland County property puts her outside of the judicial district. The Pennsylvania property puts her inside of the district. They're the same social circles. They're probably 20 minutes away from each other without traffic. They're not significantly further from the courthouse from one another, from those properties to the courthouse. And so a lot of the factors that we would normally employ in this analysis are just really hard to talk about with any real sense, right? You're not abandoning one Rotary Club and joining another. You're not donating to one charity and donating to a totally different. I think it's all probably, maybe local Rotary clubs or something, but Habitat for Humanity is all across our area. So a lot of the indicators that you're going to look for in those cases are just hard to pin down here. I think, and I don't know if I'd have an objection, but I think many people in Oklahoma, because of our geographically dispersed locations, we drive 30, 45 minutes to drop kids off at school, much less get to work sometimes. And so while there is a really big difference in this particular case because one puts her outside the district and one does not. The same analysis is very hard to apply. But we have a continuous presence over time in the Cleveland County property that she owns in her name. And we also have a very continuous abatement. Ladies and gentlemen of the board, I'm not telling you that Natalie Mai is a resident of Cleveland County. Judge Natalie Mai is telling you that she's a resident of Cleveland County. She's telling you that. She's telling the state of Oklahoma that. She's telling the citizens of Oklahoma that. I've passed out the exemption form. The most current one, if you go to the website, pops up. They're all substantially the same. They have the same disclaimers. To get this exemption, you must be a resident and occupant of that property. You must own it, yes, but you must be a resident. It's very plain. It's on the form. I mean, hey, if it was buried in a code and not on a hard to read, form that you need an accountant to understand, I may go, hey, you know what? That's a scrivener's error, possibly. Homestead exemptions are very clear. You only get a homestead exemption if you own the property and if you are a resident of that property. Natalie Mai has proclaimed the state of Oklahoma and reaped the benefit of that homestead exemption. And I think it matters because of this. If it was a mistake, she would have fixed it after the last contest. She went on reaping that tax benefit. She went on publicly proclaiming that she is a resident of Cleveland County to get that benefit. I've seen some of those witnesses today. I think that compared to the last contest, I think she's made a very good showing of staying in Oklahoma City proper. She stays most of the time in Pennsylvania. I'll give her that. But she has proclaimed to the world to be a resident of Cleveland County and she's reaped that benefit. I don't think it's fair to say, oh, no, I get to proclaim whatever I want when it fits me, whether that be tax benefit or public office. That's not just unfair to me as the other candidate, but it's unfair to the taxpayers, it's unfair to the voters, and I think it's a little bit disingenuous. I don't think that this homestead exemption is such a small thing that we should kind of sweep it under as something that we all kind of forget about. It was brought to light in 2018. If it was a mistake, she would have fixed it. The fact that she didn't seems purposeful to me, and even if you want to chalk it up to an omission, it's a purposeful omission to which she benefited. I'm not telling you that Judge Mai lives in Cleveland County. She's already told you that.
Thank you, Mr. Phillips. Ms. Norwood?
The simple fact here today is that petitioner has offered absolutely no additional evidence to show that Judge May lives anywhere other than on North Pennsylvania Avenue. The inquiry is about intent. You heard her testify that she lives at that condo and she has no intention to move. You heard from other people that have known her to live at that condo from at least 2019, which is over the 6-month period, and that's the only inquiry that the board needs to go into. She has already told this board that she does own her mother's home in Cleveland County. She's already told this board that she does not reside there. She does spend time there. It's her family. We all spend time in our family's houses. That's not against the law, that's not against the rules, and it's not an inquiry for this board. There is nothing new before you here today, other than Judge Mai's change in location from one condo that her husband now owns to another condo that she purchased in 2019, where she resides As you can tell from her electricity bills, her HOA statements, and all of the testimony that you heard here today. Consistent with this board's decision in 2018, when they did think about the mortgage and all of the things that go along with that, it's still evident that she resides in Oklahoma County, and she has for at least the last 6 months. And that was petitioner's contention, that she has not resided in the county for the last 6 months. And now you've seen the evidence that she actually does reside in Oklahoma County, the same as she did in 2018. Now, the burden is on the petitioner, and he has, again, provided no actual evidence that Judge May lives anywhere other than Oklahoma County. So we respectfully request that you dismiss this challenge. Thank you.
Thank you very much. Counsel, please advise the board of the legal matters at hand.
Board members, there is one statute to remind you of in determining how you will vote this evening. And point you to Title 20, Section 92(I). This is the candidate for district judge or associate judge. And it states in relevant part, to file as a candidate for the office of district judge or associate district judge, one must have been a registered voter and actual resident of the appropriate county for at least 6 months prior to the first day of the filing period. Board members, I'll also remind you that Box versus State Election Board, which we have talked about a few times this evening, held that residency is a subjective intent. It's a question of fact. You should look for facts evidencing intent in determining this matter. Do you have any questions about the law as I've read it to you?
No.
No.
So members of the board, after hearing evidence presented today and testimony and arguments of counsel, and by the greater weight of the evidence, if you find that the petitioner has sustained or has proven his burden, you should move to sustain the petition and strike the contestee as a candidate from the ballot. If you find that the petitioner has not established his burden, then you should move to deny the petition and retain the contestee as a candidate on the ballot.
Thank you, counsel. Board members, do you have any questions of counsel?
No.
I would entertain a motion at this time.
I move to deny the petition and retain the contestee as a candidate on the ballot.
Ms. Klein has made a motion to deny the petition and retain the contestee Natalie Mai as a candidate on the ballot. Is there a second? Dr. Malden seconds the motion. Will the clerk call the roll?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
By a vote of 3 ayes, 0 nays, the State Election Board has denied the petition and will retain the contestee Natalie Mai as a candidate on the ballot. We appreciate everyone sticking around. It's been a long day. We especially thank the witnesses. It's been a very unexpectedly long day for you, I'm sure. So thank you and good morning. Go have some IHOP.
Thank you, everyone.
But in a moment, I think we may want to take a very brief 5-minute break or so while the other, however, what I wanted to do was ask the board members, do any of you intend to recuse on the last cause? No one intends to recuse? Well, with that, I would ask then that our alternate members, Mr. Buchanan and Ms. Thompson, be dismissed. So with that, I do want to say thank you, Mr. Buchanan, thank you, Ms. Thompson. We won't need you for this last one, so you get a head start.
Thank you.
Everyone, be careful.
Thank you for hearing me.
Thank you, Mr. Phillips. You have a good evening.
County problem. So you're not staying to the bloody end, are you?
Yeah, I have to expect that Jerry would stick it out anyway.
Good night, everybody. Get out of here.
Do we need to take do we want to take a brief recess? Is there a motion for a 5-minute recess?
5 minutes.
Motion by Mr. Montgomery, second by Ms. Klein. David, will you please call the roll for a 5-minute recess?
Okay, Mr. Montgomery. Dr. Malden. Ms. Klein.
Aye.
3-0. We are at a 5-minute recess. We will be back at 12:30.
You're up, Paul.
Thank you and welcome back. This is the State Election Board meeting. Is there a motion to reconvene?
Motion.
We have a motion by Dr. Malden and a second by Mr. Montgomery. Please call the roll, Mr. Bennett.
Okay, Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
We are back in session, and I believe the next item on the docket call, the final one of the morning, is cause number 2022-12, Bollinger v. Horn. And Mr. Chairman, without objection, would it be proper for Ms. Klein to be able to share this last cause?
Absolutely. I'll delegate the responsibilities to you.
Thank you.
Vice Chair.
Okay, we are back on the record in cause number 2022-12, Bollinger versus Horn. If petitioner and contestee counsel can make appearances.
Amy Majue for the petitioner.
Brian Ted Jones for the contestee.
And how many witnesses do you anticipate calling?
We anticipate calling one witness, Ms. Madison Horn.
We anticipate calling no witnesses.
Very good. I will allow each of you approximately 2 minutes to give a brief opening statement or review the issues for us.
During the time we were preparing for this, we did come to stipulations. We'd like to begin with a few stipulations. First, the contestee stipulates to the pending nature of the voter application that was included as an exhibit to their answer, that it is pending. Petitioner stipulates that nothing else as of today can be done by Ms. Horn in order to register to vote as a Democrat in the state of Oklahoma, since she did submit the application. Ms. Horn stipulates that when she registered to vote in Arkansas, she did not choose a party affiliation at the time, and that her voter registration in Arkansas is inactive in status. Ms. Horn stipulates that she did not include an apartment number on her declaration form, and Ms. Horn stipulates that she signed the declaration under oath.
Counselor, for the contestee, do you agree with those stipulations?
I do.
Then we will adopt those stipulations as stated. Thank you. You may continue.
Good morning, members of the board. My name is Amy Majue. I'm here for the petitioner, Jason Bollinger, to challenge the qualifications of Ms. Madison Horn for the U.S. Senate seat. There are 3 reasons why this board should disqualify Ms. Horn and strike her from the ballot. And the board has the authority to do so as granted under Article 3 of the Oklahoma Constitution. The 3 reasons are: first, that Ms. Horn's declaration of candidacy form is inaccurate, incomplete, and has false information provided on it. And that is in contrast to the requirements of Section 5-111 of Title 26 of the Oklahoma statutes. The second reason is that as a matter of public policy, Ms. Horn is not qualified to represent the people of Oklahoma because she is not registered to vote in the state of Oklahoma, nor has she been registered as a Democrat in the state of Oklahoma for the past 6 months, as required under Section 5-105 of Title 26. And third, although this board has the authority to allow candidates to amend their declaration forms, an amendment here would not cure the defects that exist on the declaration form. First, Section 5-111 requires that a candidate identify their party affiliation as well as their voter registration information on the declaration of candidacy form that they fill out per the Secretary of the Election Board that is specific to the offices of U.S. Senate and U.S. Representative. Those requirements are itemized under 5-111. Looking at Ms. Horn's declaration of candidacy form, there is not registration information that is accurate or complete. In fact, on Ms. Horn's form, a voter registration number is written down and then crossed out and initialed. 2 minutes. Okay. There's precinct information on there as well, but Ms. Horn is not registered to vote in the state of Oklahoma, so that information is inaccurate. Secondly, the policy under the requirements of section 1-5-105 should be read in conjunction with the other statutes under Title 26.
Counselor, excuse me, with all due respect, this is opening statement. If you could just give us an overview and not necessarily the arguments as to the law.
Certainly. Well, I think I gave you the overview initially, if you'll accept my opening as that.
Absolutely. Thank you.
Thank you.
Good to see you again. My name is Brian Ted Jones, as I said, and I'm proud to represent Madison Horn. Mr. Bollinger is asking this board to take a statute that expressly does not apply to candidates for federal office and impose from that statute a 6-month voter registration requirement in order to disqualify Ms. Horn from the ballot. This would be a violation of the Oklahoma Constitution because it would violate the separation of powers provision of our Constitution. Simply put, this board doesn't get to amend Title 26. If the board went ahead and did this anyway, the board would then be violating the United States Constitution because qualifications for U.S. senators are set by Article 1 and states cannot change them. And not for nothing, but Ms. Horn has registered to vote in Oklahoma, and she had when she filed her declaration of candidacy. Now, the brief I filed with Ms. Horn's answer this morning addresses these points, and I'll elaborate briefly as we go through. The statute Mr. Bollinger cited, 26 OS Section 5-105A, which does impose a 6-month durational voter registration requirement on state and county candidates, does not apply to federal candidates. If the board did what Mr. Bollinger is asking it to do, you would effectively be amending 26 OS 5-105 again, which would violate Article 4, Section 1 of the Oklahoma Constitution, which prohibits the 3 branches of government from exercising the powers properly belonging to each of the others. If the board did that anyway, it would also be violating the U.S. Constitution by adding a requirement to the U.S. Senate Qualifications Clause in Article 1. States cannot do this. And I provided a citation to the U.S. Supreme Court's opinion in U.S. Term Limits Incorporated versus Thornton to that effect. In short, Mr. Bollinger is asking this board to violate the Oklahoma Constitution in a way that would violate the United States Constitution. And again, Ms. Horn has registered to vote in Oklahoma, and she had registered to vote when she filed her declaration of candidacy. That documentation is also in our response. So this contest is wrong on the facts and wrong on the law. The board should deny the petition and retain Ms. Horn's candidacy. Thank you.
Thank you, Counselor. Ms. Marjorie, you may call your first witness.
All right,
Petitioner
Klein, I have just a way to streamline things, if I might.
Yes.
Okay. Counsel, based on my review of the petition and the answer, this is coming down not on facts, but on questions of law. Am I correct on that?
No, it's a combined question of fact and law because we have the issue as to the requirements being met in the completion of the form and those being done under oath as a first issue, and then the second issue as a matter of law regarding the voter registration requirements.
So are you in dispute then of Section 5-120 that states that said petition must allege that contestee was not qualified to become a candidate for the office of which he filed declaration of candidacy?
Yes, and our petition does allege that she's not qualified to become...
Because of
the Oklahoma requirements not being met. And if I may actually address that, I know that that's to the question of law, but I can address that further if you'd like.
Okay, and but I just want to nail down on that. I mean, we're talking about qualifications by law.
Correct.
So a declaration of candidacy is not in effect a qualification, correct?
It is not a qualification as required under the U.S. Constitution. That is correct.
Okay, I'm gonna go ahead and say it again. It's not a qualification for office, correct?
Under the U.S. Constitution, correct.
Okay. And would you also agree that Article 1, Section 1 of the Oklahoma Constitution states that the state of Oklahoma is an inseparable part of the federal union and the Constitution of the United States is the supreme law of the land?
I would, and I would also point this board to Article 3 of the United States Constitution, or Article 1, Section 4 of the United States Constitution, that gives the states the authority to oversee the procedural components of elections and those procedural requirements.
But only time, places, and manner.
Well, sorry, I'm already arguing the law point, but the United States Supreme Court has actually held that even requiring a time for a party to be registered for the party they're seeking a nomination is considered a procedural requirement that states may do, and that's under the Storer case of 1974.
But was that for a federal office?
Yes.
Okay, can you give me the site to that real quick?
I certainly can. It is 415 U.S. 724.
Thank you.
Would the board like me to proceed with presenting Ms. Horn as a witness?
One moment, please.
Okay.
I can go read that as while she's presenting argument, yeah.
Argument or testimony?
Just whatever.
Okay, go ahead and call your first witness.
Petitioner would like to call Ms. Madison Horn as a witness.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Ms. Horn, you grew up in Oklahoma, is that right?
Yes.
Did you go to college in Oklahoma?
I did not.
When did you move out of state?
So I moved out of state. I was back and forth. My parents were divorced, and so I grew up in a number of different homes because of that. But I was back and forth between Oklahoma and Arkansas from the time that I was 9 to the time that I left and went to Georgia and went to school.
And when was that you...
In 2008.
Have you moved back to Oklahoma?
I have.
When did you move back to Oklahoma?
Sure. I moved back May 23rd of last year.
Why did you make that move?
I moved back to represent my home, where my family has lived for 53 years prior to the state's existence, and to take care of my home, in which I believe that is not being represented.
So would you say that's the reason you chose to run for office?
I chose to run for office for a number of reasons. That is not just about my home in the state of Oklahoma. While I love my state and I want to help take care of my family, the reason I chose to run for office is to take care of Oklahoma as a whole, as well as my country, with my qualifications as a candidate that are very, very unique, with a background of 12 years within cybersecurity and working within the National Defense Base, within the DOE, and a skill set that doesn't exist right now and is so critical for our nation to have, given the fact that everything operates within the modern era, and that is something that we need critically within our government.
When you were thinking about running for office, who did you talk to about moving here to do so?
I mean, I counseled a number of people within my community, my family, mentors.
And why was the decision made at that time, a year ago, that that was the right time to move here?
Sure. So, I mean, the decision for me to run for office was far before the moment that I moved back. You know, I had the idea that maybe this was something that I should do because I felt a call to action. But I also wanted to understand, can I do this? Are there things that I need to work on and grow as a leader? So for me to take on a responsibility, then I need to understand that I will be able to serve that in the capacity that I would feel responsible to do so.
So you said you moved here back to Oklahoma about a year ago. Where do you live?
Sure. So I live in Midtown. My address is 1130 North Harvey Avenue.
Is that a home or an apartment?
It's an apartment.
And what's your apartment number?
Sure, 501.
And how long have you been at that address?
I've been at that address, it's new construction, so I'm like trying to remember when it opened. August of last year.
Where did you move from a year ago?
Sure. I moved from Virginia.
What city?
What city? I was living in Arlington, but I was also living in DC as well.
Do you still have an apartment in Arlington or DC?
No.
How often do you go back to Virginia?
Since I have been back, I've been back twice.
What were the reasons for those visits?
Objection, relevance.
Sustained.
Do you have an Oklahoma driver's license?
I do not.
Why?
When?
Why did you not get an Oklahoma driver's license?
So, I do have an ID that is an Oklahoma ID. I had to wait, because when I first moved back here, I did go to the DMV, or excuse me, the tag agency, not only to register to vote, but also to get my driver's license. When I first went to the tag agency because of COVID, then I went to the tag agency, but they no longer do out-of-state transfers. And due to the craziness of COVID, as well as the transition for the state for real IDs, appointments were actually 60 days delayed. And so on my second attempt in October to get both a driver's license and to register to vote, I was missing a form and had to actually make another appointment, which wasn't going to be until February.
When you said you were missing a form when you went in October, what form were you missing?
Sure. So I had to show 2 copies of that I was established at my apartment, and I took my W-2. The external envelope had my address. I assumed my W-2 also had my new address, and it did not.
What address did your W-2 have?
Well, since I was working in DC, part of that W-2 had my address from DC.
When you mention working in DC, are you still working in DC?
So I work in Oklahoma, and I pay taxes to Oklahoma.
Where do you work?
I work for a company called Siemens Energy.
Where are they based?
Well, their headquarters is in Germany, but they have offices all over the U.S. and different satellite offices.
Do you work in person or remote?
Well, remote. My entire team is remote.
So you have an Oklahoma ID, but not an Oklahoma driver's license, if I understood correct?
Correct.
So does that mean you have not registered your car in the state of Oklahoma?
No, I needed the ID to do so.
You needed the ID or you needed the driver's license?
Well, I assumed that I needed an ID to get my tags changed over.
When did, you said you got your ID when?
So April 12th is when I got my ID.
You had a follow-up appointment, you said, after the October one in February.
And
Why did you not get the ID in February?
I got COVID.
After that point, when was the next available appointment?
So I was able to find one out, where did I go? I can't remember the town that I went to, but I was able to get one, and I just waited throughout the day to get my ID and register to vote.
When?
April 12th.
Okay. Did you attempt to register to vote or get your ID between February and April?
I did not.
What is the last election in which you voted?
Objection, relevant?
It's relevant to demonstrating her as an active participant and a registered voter in any state.
Not an issue regarding qualifications.
Sustained.
You have stipulated that the application you've submitted to register to vote in Oklahoma is pending. Would you agree with me that means you are not registered to vote in the state of Oklahoma yet?
Objection, I think that calls for some knowledge about how the election board procedures work that I'm not sure Ms. Horn has any personal knowledge of or should be asked whether she has personal knowledge of.
She's welcome to say she doesn't know.
Do you have a response to the objection?
Oh, yeah, that it's relevant to whether she believes she's registered to vote or not.
Overruled.
So to my knowledge, I was registered to vote when I filled out my candidacy form.
Okay, but that's not what I asked. Do you believe that you're registered to vote in the state of Oklahoma right now?
I have done everything that I can to register to vote in the state of Oklahoma.
Okay, having done everything to register is not the same thing as being registered. Do you believe you are registered to vote in the state of Oklahoma?
If I call the
I'm sorry, I object. I think we've stipulated that the application is pending, but she's done everything that she could do. So I think this is actually asked and answered because of the stipulation.
That's fine, we'll move on. I would like to point to the exhibit that's attached to contestee's answer. It is a statement from the Oklahoma County Election Board certifying the attached is true and correct. I'll bring you a copy of this to view, and it has the application attached as well.
Counselor, you want me to offer this as an exhibit?
Yes, please.
Do you have copies to provide to opposing counsel?
Oh, yes, and we've stipulated as to all of the exhibits that are being admitted, and opposing counsel has all of them as well.
And what about the board? Because I have this attached to, we're going to need originals because this is attached to the answer. Do you have an extra set of exhibits?
I do not, well, for the ones that we brought, yes, but since that one is contestee's exhibit, no, we did not bring extras of that one.
How would you like to number this?
We will number it as 1.
Thank you. You may continue.
Ms. Horn, on the bottom of that form, if you look to the bottom of that form, the bottom right corner states what?
There is an activation date and it is blank. And it also shows right above it the date that I registered to vote, which we've discussed, of April 12th of 2020.
So you submitted the application and signed the oath on your application on April 12th. But the box below the portion where you submitted stating activation is left blank, that's right?
Again, I'm going to object. I think this is asked and answered because we've stipulated that the registration application is pending and she's done everything she can. So I'm not sure where we're going with this.
That's fair. It has been stipulated that this has not been approved by the Oklahoma board election board, right?
We've stipulated that it's pending.
Have you received your voter identification card?
I have not, but my knowledge, limited knowledge of this is some people have waited a month, 2 months, 3 months, 4 months, 6 months.
Are you registered to vote in any other state?
Don't believe that I am active to vote in either state. I believe when I change my ID over, they're inactive, would be my assumption.
Prior to submitting your application to vote in the state of Oklahoma, were you actively registered to vote in any other state?
Prior to, I was active in Virginia.
When you say active in Virginia, what do you mean?
I had an active voter registration.
So, as far as your active voter status, did you vote in any elections in Virginia in the last 2 years?
Objection, relevance, we covered this already, it's been asked and answered.
Sustained.
I would like to offer Exhibit 2, which is Ms. Horn's Arkansas voter registration, public information. It's tab 4 of the binder that was provided to you each.
Is this attached to your petition?
It is not attached to the petition. It's a separate copy of the exhibits. I provided folders for each of you.
Give me a minute because I'm going to have to put my hands on that.
Yeah. Should be there. Yes, that's it.
And Counselor, what page?
Oh, I have them tabbed. Sorry, I don't know what page they are in the photocopies that were made for you.
What am I looking for?
You are looking for, it states Madison Horn's Arkansas voter registration at the top.
And why I'm looking at that, if you would explain to the board why this is relevant in a contest as far as the United States Senator, please.
Yes, so as far as prior registration, part of what we are arguing today is that she needed to have been registered as a Democrat in the state of Oklahoma for 6 months prior to her filling out the declaration form. And her Arkansas voter registration information demonstrates that her party affiliation is not Democrat.
And what is the basis of the law on the first point that she had to be registered for 6 months?
It is section 5-105 of Title 26 read in conjunction with sections 5-102 and 5-111, as well as the discretion and authority that this board has under the Oklahoma Constitution, Article 3, and Article 1 of the U.S. Constitution that permits states to provide procedural requirements to elections.
Does that authority for Oklahoma to provide procedural authority for elections transpose into federal elections, or is that limited to the state elections?
It transposes into federal elections per the United States Constitution.
Counselor, can you read the statute at hand?
Section 5-105.
That's the primary one you're relying on, correct?
No, the state.
Just for the benefit of the board.
Section 5-105A states, except as provided in subsection C of this section, to file as a candidate for nomination by a political party to any state or county office, a person must have been a registered voter of that party for the 6-month period immediately preceding the first day of the filing period prescribed by law.
May I stop you right there? What is the descriptor for the type of office that was referenced there?
I know exactly what you're getting at. It states it.
Does it say state or county office?
It says state or county office, yes.
And is the United States Senator a state or county office?
No, it is not. However, the public policy behind that requirement may extend to federal office, and this board has the discretion and authority to find so.
Ms. Majouet and board members, I do want to interject at this time. So I think you have seen this case because it's in the petition. Bradshaw versus Oklahoma State Election Board case. Are you aware of that?
I am.
In which this board actually ignored the advice of counsel by the Attorney General's office and sustained a petition for removal from the ballot of a candidate for federal office, specifically U.S. Congressional District, 4th District, and struck him from the ballot. That candidate then took the case to the Supreme Court, and the Supreme Court, in a, let's call it almost unanimous opinion, so 8-1, stated that, issued a writ of mandamus requiring the Oklahoma State Election Board to restore that person's name to the ballot. So
Correct.
that's why yes.
When you say Supreme Court, do you mean the state?
The Oklahoma Supreme Court.
And I would like to address that issue, if I may, before
Okay.
the board.
We're trying to, you know, get this case to the final point.
Yeah, and counsel, I'd just add that at this point, this is the law that we are bound by.
This is the law of the state of Oklahoma currently, but as you all have noted, the U.S. Constitution is above the Oklahoma Constitution or supersedes where there's some sort of contradiction. The Elections Clause of the U.S. Constitution, as held by the United States Supreme Court, has given states authority to govern elections and add procedural requirements. In Storer, the United States Supreme Court found that a California law that was called a disaffirmation law that prevented a candidate who had not been registered in the party for which they sought nomination for a full year prior to them filling out their candidacy was able to be struck from the ballot, and the United States Supreme Court found that that was constitutional under the Elections Clause.
But that's a distinguishable case here, counsel, is it not? And the court in Storer was looking at a ballot access issue in which the California federal court said, no, you cannot run as an independent when you previously were running for the same office as a Democrat, registered Democrats, and the court there held that there were constitutional protections that were important in that case, namely party fractionism, ballot integrity, and making sure that, you know, we don't have dissension. So how is that case relevant to this case? I get where you're going. You're arguing time, places, and manner, but I don't see how that gets to qualifications. Qualifications is separate, distinct, mutually exclusive of time, place, and manner. I get to determine what the times of my polling are. So if I want to do 8 a.m. or let's say Oklahoma is 7 a.m. to 7 p.m. I can say places. We get to determine where we have our voting precincts or polling stations. And then manner. Do we do absentee balloting? Do we do other forms of balloting? Do we do full mail-in? That is where I think the Constitution is getting at. I'm not so sure, in light of U.S. Term Limits Incorporated versus Thornton, that we are in a place, especially in light of the Bradshaw case, to ignore the plain language of Article 1, Section 3, Clause 3 of the U.S. Constitution that sets 3 qualifications for U.S. Senator. Must be 30 at the time of swearing in, citizenship of 9 years in the United States, and must be an inhabitant of the state.
I think you actually expressed the exact policy that we are arguing for here as iterated in the Storer case. In that case, the candidate, they were trying to prevent the candidate from being able to change party affiliation right before a race for running for the same office as separate parties and changing that affiliation, because it was trying to maintain the integrity of the electoral system, to protect the people that are voting, the electorate, from
to ensure that they know who and for what they're voting, which actually ties exactly into Justice Cogger's dissent in Bradshaw. That's exactly what he was saying, that this law, despite the language saying state and county only, the intent behind it is to protect the people of Oklahoma and to ensure that they know who and for what they are voting.
But Justice Cogger's dissent, she was a lone dissent. We are talking an 8-to-1 dissent, meaning she did not have buy-in from any other justice on the court at that time.
That's correct, but the policy that is cited by her dissent is exactly the policy that is upheld by the United States Supreme Court and Storer, as you identified it yourself.
Counsel, I have a quick question. So Article 1, Section 3, times, places, manner. What entity is given the authority to determine times, manner, and place of elections in Article 1, Section 3?
The Secretary of the Election Board.
No, it's the legislature. It's the state legislature is given that authority under the U.S. Constitution.
Correct.
If the legislature had intended for that law, even taking a broad view of it and ignoring the U.S. term limits case, is that U.S. term limits v. Arkansas? Even if we took a broad view of that, counsel, if the legislature, and I believe even Bradshaw, the majority opinion, referenced this, that even if you took a broad view of that, the Oklahoma Supreme Court said they didn't have to, because the legislature limited it to state and county offices, and that if the legislature had wanted it to apply to federal offices, the legislature would have said federal offices, because the Supreme Court has ruled more than once that if the legislature did it a certain way, they intended it to be that way.
You're correct, but that step...
Excuse me, let's do this. Instead of, we don't need to argue the law now. I understand you have a position on it. Some of us may view that differently. Let's go through your exhibits and get them numbered properly and get them in, since y'all have stipulated to those, and we will let you streamline your testimony that you're eliciting from this witness.
Madam Chair,
Yes.
at the appropriate time, we still have a witness, don't we?
Yes.
I do have a few questions at the appropriate
Okay,
time.
we're going to let her finish. We'll do cross, redirect, and then we'll come to the board for questions. Counselor, your exhibit 2 I had as 1 page. Is that correct?
No, it should be 4 pages.
Okay, I will add this to your number 2. What else would you like to mark and have it made?
For Exhibit 3, Ms. Horn's Declaration of Candidacy.
$396 in the top right?
Correct.
That'll be your Exhibit 3?
Yes, and that is 2 pages long.
Okay. These 2 pages?
Correct.
All right, thank you. What else?
Exhibit 4 should have recently been handed out to you. It's a Facebook post dated January 31st. I see it sitting in front of the chair here.
And how many pages is this exhibit?
1.
And it's number 4. What other exhibits?
Exhibit 5 will be Facebook post from April 8th.
Okay. What else?
And the final exhibit 6 is a photo of Ms. Horn's license plate.
Thank you. And Counselor, for the contestee, do you agree that all of these exhibits, especially these last 3, were included in stipulation?
We do.
Thank you. All right, Counselor, if you could continue with your testimony.
Ms. Horn, you filed your declaration of candidacy form to run for the U.S. Senate. Did you fill that out yourself?
Yes.
Did you have the assistance of anyone helping you?
So when I arrived at the Capitol building, that form was filled out, received, and then taken back, and I was asked to wait. When I had called back saying that there was an issue with the form, then what I was told is there was an issue with the ID number. I assumed that I messed up the ID number, so I scratched it out and started writing it back down, trying to be diligent. And with the election board's guidance, they said, oh, that's actually our ID, we're looking for your voter registration number. And I said, is it on this form? We did not see it there. And so with the guidance from the election board, and they said, well, what office are you running for? I stated the office I was running for. And we actually went back to figure out, well, is that actually a requirement to run for office? And they realized that it was no. And the funny part is they said, well, to ensure that no one actually contests your candidacy, where are you registered to vote? And I said, Oklahoma County. They gave me the precinct number. We wrote it down. And then they marked it out and asked me to initial, where I marked out my Oklahoma ID number, and said that they would figure out on the back end. They knew that there were issues with the DPS and lags with voter registration, but that they would figure out on the back end if there was an issue.
And you said you filled out the form yourself prior to that?
Yes.
In section 8 of this form, you signed under oath that the information on your form was true and correct, but not all of it was correct at the time you signed it. Is that right?
So when I filled out that form, and to my knowledge that information was correct, obviously I made a mistake, but to my knowledge that information was correct.
So the mistaken information that you had put on there is what you signed and had notarized, correct?
Yes.
And you were later told, for whatever reason, that that information was not correct.
So are you asking me about the when I was told that it was incorrect?
Yeah, let me rephrase. So after the form was notarized and when you were submitting your declaration, that's when you were informed that the voter registration information on this form was incorrect.
That's correct. And I was also told that this happens, because mistakes happen. And so the only thing that I needed to do was to initial it, and that the voter protection board, would review it, and if they had any issues with accepting it, then they would call me back. But after I initialed it, and they declared that I didn't actually need my voter registration number on there anyways, then they accepted my form.
The form section 3 states that voter registration information is required, correct?
I would have to read the form. I don't have it in front of me.
Objection, that's a little argumentative, and I think that we've covered that. So if you want to keep going, if there's I don't really know what my objection is, but this seems argumentative.
It is not intended to be argumentative, okay. Just to denote the requirement on the form.
Okay.
Are we still discussing her registration, her being registered to vote in Oklahoma?
No, this line of questioning is regarding her inaccurate and incompleteness of the form under oath. May I provide this to her to view?
Yes.
Thank you.
Have you provided a copy to opposing counsel?
Yes. This is Exhibit 3. So in Section 3, the voter registration information, is it noted that that information is required?
Voter information in parentheses then says required.
Why did you not fill in your voter registration number if you were registered to vote at the time you filled out this form?
Objection, asked and answered.
Sustained.
Did you have a voter registration number at the time you filled out this form?
So I assumed that it was on the receipt that I received from the DPS agency because I registered to vote there. When I received this, when I got this form and printed out, I just assumed that it said ID number. I filled out the ID number, which is the mistake that I made.
And how many days prior to filing your declaration did you submit your application to register to vote?
So I think we discussed that when we were talking about this form.
I think that's asked and answered, but I'm also, I think maybe rephrase that question. It sounded like you asked about the same form twice, but it's also almost 1 o'clock, so I may
Sorry. Sure. How many days prior to submitting your declaration for candidacy did you apply to become a registered voter in the state of Oklahoma?
So on my third attempt to register to vote in the state of Oklahoma, while previously being registered to vote as a Democrat in Virginia, then I registered to vote in Oklahoma on April 12th, 2022, almost said 2012, 1 a.m. And I filed my candidacy on, I believe that it was the 17th, but let's hold us accountable here. This is why we read on the 14th.
I have no further questions.
Counselor, before you conclude, I want to give counsel to the board an opportunity to correct the record. Mr. Schneider.
Sure.
Thank you. Just wanted to correct the record for the members of the board. Hodges, the dissent in Bradshaw was actually 3 different justices, Hodges, Hargrave, and Cogger. It was a 5-3 opinion though.
With that information, do you need to ask any more questions of this witness?
No, not at this time.
Thank you, Counselor.
No questions.
All right, having no questions from attorney for contestee, members of the board, do you have any questions for the witness? Dr. Malden.
If I may, and I'm in the presence of very esteemed legal counsel, so I'm not sure what the answer will be. May I ask if you're presently registered to vote?
Yes, well, I believe that I am registered to vote. I do not know what the status of activation, different definitions are. That may.
From the standpoint of the U.S. Constitution, what are the requirements to be a U.S. Senator?
Sure. I have to be 30 years old. I have to be a resident of the United States for 9 years. And I only have to be those things at the time that I am elected as a U.S. Senator.
Are you a United States citizen?
Yes, sir.
Would you be 30 by the time you were elected?
Good lucky here, I am 32. So I am already 30.
So you're 30 years old, U.S. citizen, and you hope that you are registered to vote?
Yes, but it's not a requirement, so yes, I'm registered.
Thank you.
Yes, sir.
Mr. Montgomery? Will you, if elected, will you be an inhabitant of the state of Oklahoma?
Yes.
Mr. Secretary, do you have any questions for the witness?
No questions.
Counsel for the board, do you have any questions for the witness?
No questions.
Thank you for your testimony. You're excused.
Thank you.
Do you have any further evidence or testimony?
No further evidence or witnesses, but I would like to readdress some of the statutes we were discussing earlier.
With
Are we permitted to call another witness?
Does it address the issues that were raised in your petition?
Yes.
Yes.
You might still say no. Maybe call the secretary of the election board to understand the procedure as to when someone is actually actively registered to vote.
I think I'm gonna have to object. He's a participant in the tribunal's deliberations. He doesn't have a vote. I don't know that he could speak to,
So that I'm clear, Counsel, you're wanting to call the secretary to testify as to the procedures to be registered to vote in the state of Oklahoma?
And when someone is considered registered to vote.
And Counselor, what is your objection?
Relevance, again, as we've established, it's not a qualification, so he could not testify, if he's testifying about when a person is registered to vote, he could not testify to any issue that's actually relevant to her qualifications.
It is relevant to the challenge that we're making as to her not providing a complete or accurate form under oath. And the declaration packet to the candidate states on page 3 that the board will not accept incomplete applications.
I think that Mr. Schneider pointed out that the qualifications are the qualifications in Article 1. The declaration of candidacy form is not a qualification under Article 1. So that would be my argument.
Sustained. You will not be allowed to call Secretary Zerix. Anything further?
May I make further argument on the statutes?
We'll let contestee present case if they have one. Do you rest at this time?
With the reservation that you'd like to make argument thereafter.
We have no witnesses to call. Would this be an appropriate time to make a closing argument, or would we want to allow the petitioner to make the closing argument first?
Let's talk about whether you have any exhibits or not.
No.
So all of the exhibits have been stipulated to, identified, and entered into evidence. Is that correct?
Correct.
Okay. We're going to allow both sides to present closing argument, and we will start with the petitioner. But before we do that, does anything from members of the board, Mr. Secretary, before we go into closing arguments?
Nothing for me.
All right, we're going to limit closing arguments to 3 minutes each, since it is very, very late. So, Counselor for the petitioner, you are up.
For starters, I would like to object to the limitation of the time, considering we have stayed here all day and the other hearings were not limited as such, and we have patiently waited for our case to be heard.
Counselor, with that in mind, how long do you need to present a closing argument?
I would like 5 minutes and leave for more if the board asks questions.
She can have 2 of mine.
So you get 7 minutes, is that fair? And
Sorry, I'm sorry. I just meant that if I don't need more than about a minute, so if she wants to, we can still, I'm sorry, I'm already not streamlining things, I apologize, withdrawn.
do you consider 5 minutes for your closing argument to be fair, and then whatever questions the board has will not be taken out of your 5 minutes to close?
Yes.
Then you shall have 5 minutes.
Thank you. Contestee is arguing that the requirements of the form are merely a form. If the only qualifications to run for an Oklahoma U.S. Senate seat are that spelled out in the United States Constitution, then there would not be provisions in the United States Constitution that give procedural authority to state election boards or to state legislatures to outline procedural requirements for registering as a candidate in any race. If you look to the laws of Oklahoma, the legislature has enacted statutes, and under section 5-102 gave the election board and the secretary the authority to further spell out those procedural requirements. Reading section 5-102, 5-105 discussing the registration status of a candidate, and section 5-111 that outlines the requirements, including for federal office, it is stated it includes federal offices in the requirements under section 5-111 for the requirements to fill out the candidacy form in order to be a valid validly declared candidate even for U.S. Senate. And those requirements under Section 5-111 include party affiliation and voter registration information. It is not just a form. The U.S. Constitution, as interpreted by the United States Supreme Court, gives states wide latitude to oversee procedural requirements in state and federal elections. And that's exactly what the statutory requirements of 5-111 have done. Ms. Horn did not provide a complete application under the requirements of 5-111. Again, 5-111 states those requirements, including for federal office. Ms. Horn did not provide registration information annotated on the form as required, and she signed that form under oath. It is her oath that she is testifying when she signs that form. So any reliance on anyone else telling her she doesn't need to complete that section, that is still her responsibility, especially if she wants to be a candidate for U.S. office. If we look to the legislature's authority that it has granted to this board, regardless of the language that is in Section 5-105, which does state state and county, it is inconceivable that the legislature would intend for someone registered to vote in a different state to represent the people of this state. It should be required, and the legislature deemed it required procedurally for even candidates for federal office to identify their voter registration information in the state of Oklahoma. And Ms. Horn did not do that on her form. So as a matter of the letter of the law, as outlined when reading those statutes in conjunction with one another, supported by the authority of both the state constitution and the U.S. Constitution, as well as the matters of public policy that provide this board the responsibility to prevent things like corruption in our political atmosphere, any sort of confusion for the people of Oklahoma in understanding who or what they are voting for, it is the responsibility of this board to govern those procedural requirements, which have been upheld as a responsibility of the state, and our state legislature delegated that to this board. For those reasons, we request that the board disqualify Ms. Horn and strike her from the ballot.
Thank you, Counselor.
Thank you for your time and your service today. Again, Mr. Bollinger is asking this board to just make up a requirement that a candidate for federal office has to be registered to vote for a given period of time as a Democrat, and that's just not the law. In fact, it would be a violation of the separation of powers provision in our Oklahoma Constitution for this board to make up that law, and that would be a violation of the U.S. Constitution, which established the qualifications for U.S. senators in Article 1 in 1789. States have no authority to change those requirements whatsoever. U.S. Term Limits Incorporated v. Thornton. I am going to close by talking a little about Bradshaw. Bradshaw says, the provisions of 26 OS section 50105 are, by their express terms, uninvocable against candidates for federal offices. Mr. Bollinger is asking the board to disqualify a candidate for federal office by invoking a statute uninvocable against candidates for federal office. The board should deny the petition and retain Ms. Horn's candidacy. Thank you.
Thank you. Any rebuttal? You have 45 seconds.
We do not dispute the language of section 5-105, but again urge the board to look at the requirements that are required under 5-111, even for federal office. Although Bradshaw addresses 5-105, it does not address 5-111, which by the express language of that statute
requires voter registration for federal office. Thank you.
Thank you, Counselor. Any questions for either attorney from members of the board? Any questions, Mr. Secretary?
No, thank you.
Any questions from council to the board?
No questions.
Everybody rest? Everybody closed? All right, so I will turn it over to counsel for the board to advise us in the law.
I would first point the board to section 5-120 of Title 26, and we've been over this a couple of times today, and I want to refresh your memory as it is early in the morning. Said petition must allege that the contestee was not qualified by law to become a candidate for the office for which he filed the declaration of candidacy and must contain the reasons therefore. I would also remind the board of Section 1 of Article 1 of our Oklahoma Constitution that states the state of Oklahoma is an inseparable part of the federal union, and the Constitution of the United States is the supreme law of the land. Now, the qualifications for U.S. Senate are laid out in Article 1, Section 3, Clause 3. Requiring a candidate for U.S. Senate at the time of his or her election to be 30 years old, to have been a U.S. citizen for 9 years, and to be an inhabitant of the state from which they are seeking election. Moreover, I would also point that a statute in issue is Section 5-105. Which states, except as provided in subsection C of this section, to file as a candidate for nomination by a political party to any state or county office, a person must have been a registered voter for that party for the 6-month period immediately preceding the first day of the filing period prescribed by law and under oath so state. You've also heard arguments relating to 5-111 that sets forth that a candidate seeking office in the state of Oklahoma must file a declaration of candidacy, and that declaration must contain certain information. There's several cases that we've talked about today. The Bradshaw case, that was a 2004 case in which the state Supreme Court reversed the decision of this board relating to a candidate for federal office, specifically U.S. Representative, Congressional District 4, and ordered that this board reinstate that person to the ballot. And that's what Mr. Jones talked about previously. Another case that's relevant for your decision is the U.S. Term Limits Incorporated versus Thornton decision. In that decision, the United States Supreme Court was asked whether or not a state could impose an additional requirement. The state of Arkansas inserted a requirement on candidates' term limit. A candidate for office opposed that, challenged it, and the U.S. Supreme Court ruled that the qualification of that person not having been served a certain period was an unconstitutional qualification imposed by the state constitution of Arkansas and invalidated that provision. And then finally, as Ms. Majoué has brought up the Storer v. Brown decision, it is my recommendation that this case is distinguishable for the sole proposition that it related to partisan candidates who were defeated and then wanted to seek independent office for the office of president and vice president. And it was a ballot access question. So, based on that, that is the law. You have heard testimony from Ms. Horn, you've reviewed exhibits submitted into the record, and you've heard argument for counsel for Mr. Bollinger and Ms. Horn. You have two options before you. If you believe that petitioner has sustained his burden, you should grant the petition and strike the candidacy of Ms. Horn. If you believe that the petitioner has not sustained his burden based on the evidence presented to you, then you should deny his petition and retain the candidacy of Ms. Horn on the ballot.
Thank you, Counselor. Members of the board, do you have any questions regarding the law as set forth by Mr. Schneider, counsel for the board? Dr. Mullen?
I'll have a motion when the time is appropriate.
Do you have any questions regarding the law?
No.
I have one question, Mr. Schneider. Is the law stated in the United States Constitution leave the sole qualifications for election to office being one, that the candidate has attained the age of 30 years old, two, that the candidate have been 9 years a citizen of the United States, and three, that when elected, the candidate will be an inhabitant of the state of Oklahoma?
It's my opinion and recommendation that those are the sole qualifications for the office of U.S. Senator as set forth in the U.S. Constitution.
Thank you, Counselor. All right, if we have a motion at this time, we'll entertain it. Dr. Walden.
Madam Chair, I move to deny the petition and retain the contestee as candidate on the ballot.
Do we have a second?
Hang on.
May I ask, do we have discussion regarding the motion? Do you have any discussion?
I'll second the motion.
Okay, we have a motion to deny the petition and maintain or retain the candidate on the ballot. We have a second. Mr. Dunn, will you call the roll?
I will be delighted to call the roll. What time is it? Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye. All right, thank you, counselors. Thank you for staying late.
Secretary, would you like me to call that one? My 3 ayes, 0 nays. The board has voted to deny the petition and retain the contestee Horn on the ballot.
Do we need to do some cleanup on?
In just a moment, I think we need to have the acting chair dismiss the parties.
Okay.
Counselors, parties, thank you very much. We appreciate your prompt presentation.
Good morning.
Yeah. Good morning.
So here's your motion.
Okay, thank you.
And then here's, you want to do this after she's finished.
Are we ready?
I think so.
We'll make it out.
At this time, I move to direct the board's legal advisor to draft findings of fact, conclusions of law, and final agency order in all of the causes presented before this board today and yesterday, and present the same to the chair for his review and signature.
Yes, Mr. Walden?
I second the motion.
Okay, we have a, are you decanting?
No.
Okay, we have a motion and a second. Mr. Dunn, will you call the roll, please?
Yes, Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye.
The motion carries by 3 ayes, 0 nays.
Okay. I'd like to make a motion to table items 18 through 31 to a future meeting.
Second.
So there's a motion to table items 18 through 31 to be heard at a future meeting.
Mr. Dunn, we have a motion and a second. Will you call the roll, please?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye. So by a vote of 3 ayes and 0 nays, the motion carries.
I got one more motion. I want a motion to adjourn.
And the second?
A second.
We have a motion to adjourn with a second. Mr. Dunn, will you call the roll?
Mr. Montgomery.
Aye.
Dr. Malden.
Aye.
Ms. Klein.
Aye. By a vote of 3-0, this meeting is adjourned.
Good night, good morning, and goodbye.
Thank you. Good riddance.